ಇದು ಇಟ್ಕೋ. I couldn't go through the files. I was not keeping well from the past 3-4 days. That's
ಯಾರು
the reason.
ಯಾರು
ನಾನೇನೆ.
ಆರಾಮಿಲ್ವಾ?
ಹೌದು, I was not keeping well.
ನಾಳೆ,
Next week
Thursday,
ಅಥವಾ ನಾಳೆ
Thursday.
ಏನಿದೆ?
ಫೈನಲ್
30 serial.
Page
on health
6,
ground.
page 6, number 25.
30, my lord.
30.
I'm for the petitioner.
ಹಾ
1 week accommodation make.
ಯಾಕೆ?
I could
All
not. Please,
Week after next.
Pajo, please.
Not serial number
At the
22,
request
man.
ಹಾ
Page 6, number 25. 2017 matter, my lords, but my one last indulgence my next week, my lords.
మేము ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಓದಿದ್ಮೇಲೆ ನಾವು ಮತ್ತೆ ಓದೋದು ಹೇಗೆ ಇವನ್ನೆಲ್ಲ?
One indulgence, my lord, next week, my lords. Please, ma'am.
You appear for this one for the next Thursday.
Oh, pleasure.
Not serial number 22, my lord.
22. ಮತ್ತೆ ಲಿಸ್ಟ್ ಮುಗಿದು ಹೋಗ್ತದೆ. ಇನ್ನು ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ಏನಿದು?
1 week time may be granted, my lord.
All right, 2 weeks.
22.
22, 24 matter. ಹಾ ಹಾ 22 18 2018 matter. Why, brother? All right, week after next ಹಾಕಿ. ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇರಿ ಕೊಡೋಣಂತೆ.
Fresh matter, my lords.
ನೀವು ಹೋಗಿ, ನಾವು ಕೊಡ್ತೇನೆ, ಹೋಗಿ. We'll 2 weeks ಕೊಡ್ತೇವೆ, ನೋಡೋಣ. ಓಕೆ.
Can I just,
ಹಾ
fresh
But
matter,
may I make
lords,
one-
matter pertaining, fresh matter pertaining to transfer, my lords.
ಟ್ರಾನ್ಸ್ಫರ್.
Transfer.
ಹಾ Thursday.
But may I make one submission?
ಹಾ
2 writ petitions KAT, my lord. Notices have been issued.
Ah.
In one case, my lord, sealed cover procedure has been followed, and subsequently after filing the writ petition, that has been opened and promotion is granted. Now only consequential benefits, my lord, is required to be paid. For
next
which
week ಹಾಕ್ಬೇಡಿ.
there is one more,
Week after next ಹಾಕೋಣ.
my lord, one more matter pertaining to regularization. Now I have retired. KAT has granted me the partial relief, my lord, against which I have filed.
ಅದು next week after next. ಓಕೆ.
My lord, in this is matter, service matter, my lord. Partly heard agida, my lord. Houses are not constructed under the Australia scheme.
ಪಾರ್ಟೆಡ್ ಆಗಿದೆಯಾ?
Yes, my lord.
ಯಾರ ಮುಂದೆ?
ಮುಂದೆನೆ, my lord.
ಇನ್ನೊಂದು ಬೆಂಚ್ ಅದ ನೋಡ್ಕೊಂಡು ಹಾಕ್ರಿ. ಇನ್ನೊಂದು ಬೆಂಚ್ ಇದ್ದಾಗ ಹಾಕೊಟ್ರಿ. ಹಾ ಹಾ
Service matter. Fresh matter, my lord. SKT matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಏನ್
For the same charge, second time the inquiry has been conducted.
ಏನಂತೆ? ಸ್ವಲ್ಪ ಅದು ಏನು ಅದು ಮೈಕ್
For the same charge, the second time the inquiry has been.
ಸೆಕೆಂಡ್ ಎನ್ಕ್ವೈರಿ
Yes.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
That's service matter, my lord.
Ah.
Petitioner has been retired, my lord.
ಪಿಟಿಷನರ್ ಹ್ಯಾಸ್ ಬೀನ್
He is retired, my lord. So
ರಿಟೈರ್ಡ್.
yeah,
ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ.
ಸರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. ಎಸ್ ಹಾ
One disposed of matter.
Ah.
This honorable court has directed the appellant to make the payment towards the tender deposits as such. And despite that, we have made a representation before the appellant, respondent number 2. They had sent that to my address. I have vacated the premises now. Now I am unable to collect the payments as such. The payments has to be collected.
ಪೇಮೆಂಟ್ ಅಷ್ಟು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ, disposed of.
ಬಟ್ ಡಿಸ್ಪೋಸಲ್ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಅದಕ್ಕೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಏನಾರ ಹಾಕೊಳ್ಳಿ, ನೋಡೋಣ. ಒಂದು IA ಏನಾರ ಹಾಕೊಳ್ಳಿ.
Please.
ಹಾ
Pay for the petition in this matter.
ಏನಿದೆ?
But with R1, my lords, is this Public Service Commission's petition.
Ah.
R1 was non-suited from the selection process because of suppression of fact that she was already a government employee. But with much help of government advocate, we were able to serve it on her, my lords. She was even present on the last date. She had submitted that she will engage an advocate and hence time was granted. But it appears that she is not engaged, my lords. That is a charade that has come up in the cause list.
ಮೊದ್ಲು ನೀವು ಇದ್ರಾ?
ಇಲ್ಲ, I'm for the petitioner. For R1, my lords, with help of government advocate, we were able to serve it on her. She was even present in the court last date. She had submitted that she... ಅಲ್ಲ, ಆಗಿದೆ. She was present in the court last date. She had submitted that she will engage an advocate.
The first respondent. Submit on behalf of first respondent to the project report. She needs some time to engage the service of an advocate. ಅವ್ರೇನೋ advocate ಅನ್ನು
Last,
engage ಮಾಡ್ತಾರೆ.
present ಇದ್ಬಿಟ್ಟು ಹೇಳಿದ್ರು, but it appears she has not done. Maybe one last indulgence with warning, my lords, next week we did.
ವಾರ್ನಿಂಗ್ ಹೆಂಗದ ಅವ್ರು
ಅಲ್ಲ, ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ we'll proceed ಅಂತಾನೆ.
ಹಂಗೆ ಹೇಳು, ನಾವು ವಾರ್ನಿಂಗ್ ಮಾಡಕ್
ಆತ,
ಅಡ್ವೊಕೇಟ್ ತಗೊಳ್ಳೇಬೇಕು ನೀವು ಅಂತ.
misuse of words, my lords, I'm so apologetic.
On the previous occasion, that is on 22/8/2024, we had said as under. Next, the coordinate bench had said like as under. First, as a last chance. Next paragraph, as a last chance, call this matter after 2 weeks. After 2 weeks. Okay.
May I request for a date, my lords?
No, no, this is of 2017 matter. One day other date question. 20 years.
Obliged.
20. First. Yes. ಅವ್ರೇನೋ 2 weeks ಬೇಕು ಅಂದ್ರಲ್ಲ, 2 weeks for compliance. ಏನದು ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆಯಾ?
Not matter has been dismissed for non-prosecution,
Dismiss for non-prosecution.
non-compliance with the objections.
Application ಹಾಕ್ಯಾರನು? ಹಾಕಿಲ್ಲ. Finally, 2 weeks.
It has actually, the recalling order was passed subject to the condition that they will comply within 1 week. my lord. That is also expired.
Not. ಸಿದ್ಧ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೆ. Okay.
Appellant,
Seventh time.
you're already complained the office objection in October 22, 2024.
ಹೌದಾ?
You're-
Office objections are, learned counsel for the petitioner submits that office objections are substantially complied with.
Yes, sir.
We agree with that.
Date may be fixed
Ain't date, argue.
for argument and for one IA is the, your honor, pending for the,
ಏನದು ಅಯ್ಯೇ?
5.5 years delay in filing, my lord. He is resigned the job.
Ah.
After 5.5 years, he filed an application before KAT. my lord.
84?
He is seeking, his representation has to be considered, my lord.
ಏನ್ representation?
Withdraw ಮಾಡಿ, resignation ಕೊಟ್ಟಿರೋದ್ನ withdraw ಮಾಡಿದೀನಿ ಅಂತ, after 2 years ಕೊಡ್ತಾರೆ.
first resignation has been given on the year 2018. That is accepted by them in 2012 and before that,
12.
after 4 year, 3 year, they are not responding anything. He is mentally unstable for the, because of a family reason, he is not.
ಮತ್ತೆ ಇಲ್ಲಿ ಅಂತವ್ರನ್ನ ಇಟ್ಕೊಂಡು ಹೆಂಗ್ ಕೆಲಸ ಮಾಡೋದು ಗೌರ್ಮೆಂಟ್?
From last 4 year, that last 4 year, they are not accepting any that resignation letter. After that, suddenly before I representation for the taking back that representation of resignation letter, that before that they accept the same and resign, the resign letter has been issued.
ಏನ್ ಮಾಡಿ? ಹೆಂಗೆ?
Yes, sir.
How to grant relief now at this length of time?
That's why my senior wants to argue the matter.
How many?
first. Right now, see, he is went for the health checkup. So tomorrow, day after tomorrow, no problem. I have, we are ready for that.
ಏನಿದೆ ಕೇಸ್ನಲ್ಲಿ? ಇಂಥ ಕೇಸ್ನಲ್ಲಿ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗಿ ಬೇರೆ ಕೇಸ್ನಲ್ಲೂ ಜಸ್ಟಿಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ನಮ್ಗೆ.
Yes, sir.
ಕಾಲ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಫಸ್ಟ್ ಇದನ್ನ ಕೊಡಿ, ಟೈಮ್ ಕೊಡಿ. On health ground of the arguing counsel, finally. Call on. 13th ಅಲ್ಲ? 17th. 13th is already.
I have to file the IA for condonation of delay, my lord. Take time.
Condonation of delay for ಏನಿದು?
Recalling, my lord, non-prosecution dismission. I filed the recalling
Calling.
application.
ಕೊಡಿ. ಎಷ್ಟು ದಿವಸ ಇದೆ ಡಿಲೇ? Dismiss for non-prosecution ಅನ್ನೋದು.
How's long back, I have filed the IA, my lord. It was not put up 3 to 4 times. We went to the registry and there are, my lord, sea of files. We could not see the, and it is notified.
non-prosecution. ಒಂದು ಮೆಮೊ ಬರ್ಕೊಡಿ ಫಾರ್ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ. ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ? ಅಯ್ಯ ಪೋಸ್ಟ್ ಆಗಿದ? A coordinate bench of this court, wide order dated 17/8/2022, had dismissed the petition for non-prosecution. First stop. Next paragraph. Now the application has been moved, supported by an affidavit seeking recall of the said order. First, office has raised an objection as to the absence of an application for condonation of delay, comma, arguably there being delay. First, the counsel for the petitioner has filed a memo explaining why delay is brooked. First, dismissal for default is not a happy thing to happen in any proceeding. First off. However, at least when application is filed seeking recall with the assurance that the office objections would be addressed, comma, such applications need to be allowed so that the litigant can argue the matter on merits, subject to all just exceptions. First off. Next one, in the above circumstances, the memo is accepted and delay of a short delay of is condoned. First, application is favored and the coordinate bench order dated 17/8/2022 is recalled, and as a consequence, the petition is restored to the board, subject to the condition that the petitioner shall address all office objections within 2 weeks finally.
Allah objections. A2, A5, A9, my lord. I gave the explanation, my lord, in the office itself. It's a legible copy antandu. On that only it is dismissed. Very clear, my lord.
Huh?
A2, A5, A9.
14 objections ide. Address
ಇಲ್ಲ,
ಮಾಡಿ.
remaining all I have.
ಬರ್ಕೊಳ್ಳಿ. However, the objection as to the eligibility of annexures
A2, A5, A9.
A2,
Give the
A5,
explanation.
A9 is overruled. In Urdu address ಮಾಡಿ.
And ಬೇರೆದು Kannada translations.
Kannada translation is also dispensed with. First off, rest of the objections to be addressed.
Public.
ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡಿ ಲೈಬ್ರರಿಗೆ. ನಮ್ಮ CH ಹನುಮಂತರಾಯ ಅವರ ವಕೀಲನ ವಗೈರೆಗಳು ಆ ಒಂದು ಪುಸ್ತಕ ಕೊಡಿ, ಚೆನ್ನಾಗಿದೆ ಅವ್ರ ಲೈಫ್ ಸ್ಟೋರಿ. ಎಸ್, ನೋಡಮ್ಮ ಬರ್ಕೋಬೇಕ ವಕೀಲರ ವಗೈರೆಗಳು. ಎಸ್, ಆ ಮೆಮೊ ಒಂದು ಮಾಡಿಕೊಡ್ಬೇಕು, ಎಷ್ಟು ಡಿಲೇ ಇದೆ ಅದು ಹೀಗೆ ಅಂತ ಒಂದು ಆ ರೀತಿ ಮಾಡಿಕೊಡಿ. ಓಕೆ.
File, my lord, appears for the petitioner.
ಪ್ರಸನ್ನ ಏನಿದು?
Please, my lord, I have already filed the translated copies along with the memo. It is not strict, my lord. That is the only office objection.
Translation is not required, therefore dispensed it for the time being. ನೋಡೋಣ, ಯಾರು ಇಂಗ್ಲಿಷ್ ಜಡ್ಜಸ್ ಬಂದಾಗ ಮತ್ ನೀವು ಬೇಕು ಅಂದ್ರೆ ಕೊಡಂತ್ರಿ, ಕನ್ನಡದಲ್ಲಿ ಬೇಕಿಲ್ಲ. ಏನಿದು ಮ್ಯಾಟರ್?
My lord, the petitioner, my lord, challenged the order of the KAT, my lord, wherein the DGO, my lord, challenged the penalty order before the KAT. Lord, that was set aside by the honorable KSAT.
ಏನು?
Penalty order.
ಪೆನಲ್ಟಿ
Please, pass the
ಡಿ
government.
ಆಗಿತ್ತಾ?
D ಆಗಿತ್ತು.
ಏನ್ ಚಾರ್ಜ್?
My lord, charge, my lord, substandard of work, my lord, in road work, my lord. It was, my lord, condition of the road, my lord, damage within 3 months of the formation of the road. That was the charge.
ಮತ್ತೆ ಉಸುಕ್ನಿಂದ ಕಟ್ಟಿರಿ ಏನಾಗ್ತದೆ? 3 ತಿಂಗಳು ಬರಲ್ಲ ಅವು.
They are the executive assistant, senior executive engineers in the, my lord.
ಯಾರ್ದು? ನೀವೇ ಜವಾಬ್ದಾರಿ? ಯು ಆರ್ ದಿ ಸೈಟ್ ಇಂಜಿನಿಯರ್ ನಾ?
No, my lord, I am the Lokayukta, my lord. Lokayukta has challenged this petition before the court.
ಲೋಕಾಯುಕ್ತ
Please,
challenge
notice has to go, my lord. Notice is not in English.
issue emergent notice.
R2, my lord. R1 state.
Learned AGA is requested to accept notice for first respondent. Emergent notice to second respondent.
Please, apply. Great.
Yes.
Steps we have taken today. It's already taken for R4.
Yeah, ಇಷ್ಟು ದಿವಸ ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
Oversight. not-
Steps to be taken before sunset of the day, failing which petition stands rejected on that ground.
Great. Petition.
Mr. Anthony, ಏನಿದು?
My lord, the office objections are in relation to the Kannada translations, my lord.
ಬೇರೆ ಯಾವ್ದಿಲ್ವಾ? ಯಾವ್ದಿಲ್ಲ. But ಏಳು seventh time ಹಿಂಗೆಲ್ಲ
My
ಮಾಡಿದ್ರೆ.
lord, it used to come up before the registrar, then it came up before another coordinate bench, my lord.
All right. Office objection being insignificant is dispensed with.
My lord, this is a challenge to an order passed by the administrative tribunal, my lord. I am for the Lokayukta, my lord.
Yes.
The entrustment order and articles of challenges were under, articles of charges were under challenge before the case act, my lord. He is an executive engineer of the PWD. My lord, it is relation to a substandard work. The honorable tribunal, my lord, considers an order passed by the tribunal in Kalburgi in relation to a same matter, my lord. But in that matter, my lord, he applies doctrine of parity, but that matter stands at a different pedestal, my lord, because there was also a B report filed in that matter. In this matter, there is no B report filed, my lord, but he applies a doctrine of parity and says that these are similar matters. And on that ground, he allows the application, my lord.
ಅಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ಅಂದ್ರೆ ಕ್ರಿಮಿನಲ್ ಸೈಡ್ ಆಗ.
Criminal side, even
ಇದಕ್ಕೆ ಕಲ್ಪೆ ವರ್ಕಿಂಗ್
disciplinary proceedings ಗೆ apply ಆಗಲ್ಲ.
Lord, and also B report is not conclusive, my lord.
That's why.
B report can be.
No order is passed on B report.
My lord, that is not in relation to this case, that is an, yeah.
They're asking,
Ah.
because Apex Court said in that Rupen Devul Bajaj versus KPS Gill,
Please.
95 or 96, Shankar, how the year? IR 95, B report should be heard, objection should be considered, then decision to accept the cognizance or not to be decided. What happened on that B report, at least, have you ascertained?
No, my lord, in the order, it only says this, my lord. There
Have
are-
you ascertained as a Lokayukta?
No, my lord.
But ಅದನ್ನ ಸರ್ಟನ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲ, ಅದು
Please.
ಏನ್ರ ಒಂದು ಹೇಳಿರ್ತಾರೆ.
But in
In any way, it is not relevant.
not relevant, my lord. That's my contention.
Learned DGA is requested to issue notice. Learned DGA is requested to accept notice for first respondent,
And
emergent notice to second.
1 and 2, my lord.
1 and
1 and 3, my lord.
Other.
1 and 3.
1 and 3.
Please.
You appear for 1 and 3.
1 and 3, my lord.
Emergent notice to second. Be report. Decision out. That's fine. Okay, query, protest petition. Yes. Any,
My lord, the office objection again relation to the.
no, no,
Kannada.
dispense with office objection, dispense. Okay.
My lord, here what was under challenge before the case act was a 12-3 report, my lord. The allegation against a forest range officer saying that non-removal of encroachment.
Yes.
Please, my lord. The grounds on which the application has been allowed is, my lord, on the basis of a letter. My lords may kindly turn to page 33 of the impugned order.
3.
Please, para 7.
At the time of argument,
Please, my lord. The learned counsel for the applicant produced letter addressed by the principal chief conservator to the chief secretary regarding dropping proceeding against the present applicant. Then, my lord, he has elaborately discussed the subject matter and it says that he has not committed any misconduct is what they say. On the basis of that letter, my lord, the application comes to be allowed.
because PCCF has said,
Please.
ಏನಿದೆ ಇದು?
Ade, my lord, I don't think, already when his own department has
He is
stated.
the highest functionary in the department. He says that everything is all right.
Please,
If you want to go take action against him.
please, I bow down.
Lord, I appear for the respondent pursuant to the order passed by the honorable tribunal.
Ah.
Lord, after 3 years, my lord, they have preferred writ petition. Lord, the order is dated 7/12/2020. After that, my lord, the state government has accepted the order of the tribunal and withdrawn the, my lord, 14A order. Therefore, my lord,
14A order is
is
withdrawn.
withdrawn, accepting the order of the tribunal. Lord, the principal chief conservator of
Now,
forest.
where is such a question? Once proceedings are quashed, where is the question of government withdrawing? Where is thing to be withdrawn?
Yes.
There should be a thing to be withdrawn if it is quashed. Where is the question of withdrawal?
I pointed out the same thing to the officer, my lord.
ಬರ್ಕೊಳ್ಳಿ. Karnataka Lokayukta, ಕೂತ್ಕೊಳ್ಳಿ.
Please.
Is knocking at the doors of writ court for assailing the State Administrative Tribunal's order dated 7/12/2020, whereby private respondent's application number 941 of 2017 having been favored, he has been relieved of the disciplinary proceedings. First off, the operative portion of the order reads as under. Nodama, you think. Learned, next paragraph. Panel counsel appearing for the petitioner submits that the KAT grossly erred in accepting letter of the Principal Chief Conservator of Forest Government of Karnataka without ascertaining its authenticity, and therefore there is error apparent on the face of the record warranting indulgence of this court. First, learned counsel appearing for the private respondent submits that the PCCF, being the chief executive of the Department of the Forest, himself having vouched the work of the petition, work of his client as being not vulnerable for any inquiry, his version cannot be doubted. First off, it is not the case of Lokayukta that what the PCCF has said in his letter is not true and correct. First off, the tribunal, having acted upon the letter of the PCCF, has granted relief to the civil servant, and that accords with reason and justice. First off, next paragraph. Added to the next paragraph. Learned counsel appearing for the civil servant points out that Lokayukta has brooked enormous delay in laying a challenge to the order of the KAT, and that the explanation offered for that is not plausible. Full stop. This aspect need not be gone into since we are deciding the matter on merits itself. Full stop. Next part, in the above circumstances, petition being unworthy of merits is liable to be dismissed, and accordingly it is. Costs having been made easy.
My lord, again, office objection.
ನೋಡಮ್ಮ ಇದನ್ನಲ್ಲಿ ನಮ್ಮ PS ಹತ್ರ ಕೇಳ್ಕೊಂಡು ಸ್ಟ್ರಕ್ಚರಿಂಗ್ ಮಾಡ್ಕೋಬೇಕು ಯಾವ ರೀತಿ ಆಗ್ಬೇಕು ಅಂತ. We have to consult our PS. She will give the format. Okay? All right. Yes, Mr. Anthony.
Office objection is in relation to the Kannada transcript.
Kannada, dispensed it.
Please. My lord, the order under challenge, my lord, the administrative tribunal, what is challenged before the administrative tribunal is the entrustment order, my lord, by a Tahsildar. The allegation is non-removal of encroachments in a Rajakalve, my lord. The only ground on which the honorable tribunal proceeds is that there is no independent application of mind while proceeding with the 12-4 report is what it says, my lord.
Then if 12-4 is set aside, what we have held in Dharwad, which is the judgment,
please.
Matter has to go back to the concerned authority, na? Buddy. Issue emergent notice. Learned AGA is requested to accept notice for the first respondent. First off, issue emergent notice to second. Okay.
Great.
This order we have made, keeping in view a division bench judgment. Idu enu report enu entadra report agidya?
Please, my lord, I'll pass it on. I'll pass on.
In Karnataka Lokayukta versus Sri Ishwar. So and so.
Please, I'll pass on. Grateful.
Next. Yes.
For the petitioner, your lordship. On 28/2/2025, your lordship. 28/2/25, we have already paid the PF, your lordship.
You have paid PF now?
Yes.
Council submits that needful is done. Full stop. Registry to look into. Yes. Interim order to continue.
Therefore, applicant, petitioner,
Yes,
only translation regarding subject.
translation discussed it for the time being. Yes, ನೋಡಪ್ಪ ಎಲ್ಲೆಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಬರುತ್ತಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್. When other judges who do not know Kannada ಅವ್ರು ಬಂದಾಗ ನೀವು ಕೊಡಬೇಕಾಗ್ತದೆ. Yes, ಏನಿದೆ?
Matter pertains to compassionate appointment.
ಹಾ.
Petitioner is, father of the petitioner was not in service.
Father of petitioner
Hmm.
was not in service.
Not in service. That is not communicated to the petitioner also.
If not in service, where is the question of
No,
compassionate?
madam. Kindly see page number 85 of the order. There is no,
85.
there is no signature, there is no communication.
85.
Page number 85, madam.
Hello, what was your father?
I am the superintendent, madam, office superintendent.
How many years of service he has put in?
More than 25 years, madam.
25 years.
Hmm.
Where have you stated?
My lord.
Where have you stated that? Removal was because of disciplinary inquiry,
Please. Here,
not a death in harness.
two allegations, my lord.
Ah.
One was relating to
Unauthorized absent.
unauthorized absence and the other one was misappropriation of funds.
Ah.
And so far as misappropriation of funds was concerned, the disciplinary proceedings were postponed, my lord. Regarding unauthorized absence, he has been found guilty of misconduct and he has been removed from service in 2016, 29/8/2016, my lord. The order of dismissal is at annexure R1, page 115, my lord.
Was it communicated to him?
It is
But,
not communicated, madam. I
But
am,
he remained not only absent, he also was had absconded, my lord.
He has
That is the
absconded.
reason that is the ground taken, my lord. I have no instructions as of now. I have gone through the material and I'm making my submission.
Anyway,
Not for instruction.
the service comes to an end by death or otherwise determination or by abandonment of service. Where there is abandonment,
tomorrow, madam. Senior is,
what is senior? ಇಷ್ಟೇ ಇರೋದೇ ಇಷ್ಟೇ.
ಅಲ್ಲ, senior father chairman is. Tomorrow.
ನೀವ್ ಯಾಕೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಿ? Call next week for further hearing. As of now, we have not found any merits. Yes.
Translation dispensation.
Dispensed.
That's the order is, the tribunal refused to grant an interim order of, the order what was challenged was the suspension order,
Yes.
which your lordship should get at page 109 in the writ petition. It's dated, my lords, 10/2/2025. Its first three paragraphs, they make an, Tahsildar reports that as per media reports, there was a trap and I was arrested, which is not the fact. Media reports, neither I have been arrested nor a trap was laid. I am not even a part of the trap. There is a PC case registered against me.
Newly,
I have also,
lord, fresh matter, it has been listed for the first time. I have not even received the copy, my lord. Maybe they have served it, but I have not.
ಕಾಪಿ
Given the
ಸರ್ವ್
copy.
ಮಾಡಿರ್ತಾರೆ, ಅವ್ರು ಬಂದಿರಲ್ಲ, ಸಾರಿ. ಅದು ಇಲ್ಲಾಂದ್ರೆ ರಿಜಿಸ್ಟ್ರೇ ಆಗಲ್ಲ ರಿಟ್ಟು.
ಅಲ್ಲ ಬೇರೆ ಮೀಡಿಯಾ ರಿಪೋರ್ಟ್ ನಿಂದ ಹೋಗಂಗಿದ್ರೆ ಈ ಬಾಳ ಜನ ಜಡ್ಜಸ್ ಜೈಲಿಗೆ ಹಾಕ್ಬೇಕಾಗ್ತದೆ. ಬರೀ ಲಾಯರ್ಸ್ ಅಷ್ಟ ಅಲ್ಲ.
Instructions.
He says absolutely nothing.
ಅಲ್ಲ, ನನ್ ಮೇಲೆ PC ಇದೆ, ಬಟ್ ಟ್ರಾಪ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅರೆಸ್ಟ್ ಆಗಿಲ್ಲ. ಅಂಡ್ PC proceedings are stayed by the High Court.
Brother, it's heard, learned senior advocate appearing for the petitioner. First, issue emergent notice. Learned AG is requested to accept notice for first
One,
and
two.
second third respondents.
4, 1 to 4,
1 to 4,
1 to 4.
1 to 4. Learned panel counsel is requested to accept notice for respondent number 5. First off, interim order as prayed for. First off, this interim protection is granted on the assertion of learned senior advocate that the criminal case filed against his client has been stayed by a learned single judge of this court in
When
criminal petition number
that's writ petition number 4050 of 2025. It's at
WP
page
number
107.
4050 of 2025.
25.
25. Yes,
Please.
ಏನು ಯಾರು ಬೇಕಾದ್ರೆ ಹಂಗೆ ಹೆಂಗ್ ಬೇಕಾದ್ರೆ ಅರೆಸ್ಟ್ ಸಸ್ಪೆಂಡ್ ಮಾಡಿಬಿಡೋದು ಸ್ವಲ್ಪ ನೋಡೋದು ಬೇಡವಾ ಏನಿದೆ ಎಂತಾನ
I'll find out, my lord,
Huh?
what is. I'll find out what.
ಅಲ್ಲೇ learned AG accepted notice sites. Yes.
I appear for the petitioner. The impleading I have filed by impleading applicant, my lord, is in fact has no locus standi, my lord.
Impleading application, all right, ನಿಮ್ದು ಹೇಳಿ, ನಿಮ್ ಕೇಸ್ ಹೇಳಿ,
I may be permitted 1 week time.
week after next, finally, at the request of counsel for the petition.
For the passover of them.
Regarding application in IA number 1 of 2023, supported by an affidavit seeks recall of the dismissal order dated 11/1/2023 for non-prosecution. First, application in IA number 1 of 2024, supported by an affidavit seeks condonation of delay in moving the first application. First, a plausible explanation is offered in both the applications. First, next paragraph, in view of the above, both the applications are allowed, delay is condoned, and the order dated 11/1/2023 is recalled. Full stop. As a consequence, WP is restored to the board.
Lord, copy needs to be served on the government, my lord. Full copy is not served.
ಕೊಡ್ಬೇಕು. 2 weeks finally for compliance of all objections, including service of the usual service of copies of the petition on the learned, on the office of the AG in terms of rule 4. Okay. For rule 4. Okay. Yes. Yes, Prasanna.
Yes, my lords.
Huh?
Appear for the, for impleading.
Huh?
I filed by the impleading, lord.
ಏನಿದೆ ಮ್ಯಾಟರ್?
Applicants claims to be the direct recruitees, whereas not the petitioners are the promotees from the post of foresters to the deputy range forest officers. Now, they were deputed as deputy range forest officers somewhere in the year 2013 and 14 on an independent charge. They have not been promoted. They made representations. Seniority list being issued, not ignoring their seniority and service and in independent charge. Then, my lords, an application came to be filed by the petitions before the state tribunal, where, my lord, the tribunal was pleased to department to consider their seniority. Then, my lord, a fresh order came to be issued.
Consider seniority.
Yes, they are considered representation so as to provide seniority because they were in independent charge, though under Rule 32 on deputation. They are entitled for promotion and seniority par with the other employees. Therefore, my lord,
Rule 32 promotion ಆಗತ್ತ.
promotion, deputation ಆಗತ್ತೆ. But if they are placed under independent charge, my lord, they have to be considered, my lords, under the amended rules, my lords.
ಹೌದು.
My lord, Karnataka State Civil Service Regulation, Promotion and Pay and Pension Rules 1978 as amended. Lord, Rule 2, Sub-Rule 3, Lord, reads, promotion of a civil servant may be made with the effect from a retrospective date.
He was placed independent charge.
Yes, if while being eligible according to his seniority in the list that was in force and otherwise fit for promotion according to the cadre and recruitment rules, he had only been placed in independent charge of the post by the competent Page number 208.
ತೆಗಿರಿ ಇದನ್ನ BN ಧೋತ್ರದ್ ವರ್ಸಸ್ ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ಆರ್ಮಿ ಕಾರ್ಪೊರೇಷನ್ ತೆಗಿರಿ. No,
208 minutes.
Directed to
para number 8
consider
minutes.
the representation dated so and so from applicants that too by placing them under rule 42B of KCSRC.
The opinion is expressed minutes. Kindly see minutes, para number 8 minutes above. In middle, in our considered opinion, it is a fit case to issue direction without expressing any opinion on the merits of the application and eligibility of the applicants for their promotion and seniority to consider the representation dated 24/7/2010 vide annexure 10 in accordance with the law in appropriate orders. Pursuant to this minutes, the respondent's authority minute was pleased to issue an order dated 22/7/2022 wide annexure A21 page number 221 minutes. 221. 221.
ಏನಂತ ಮಾಡಿದ್ರಿ ಇದರಲ್ಲಿ?
They were promoted with effect from 10/12/2021 only, not instead of 2013 and 14 minutes.
With effect from first day you should
Yes.
have been anta.
Yes.
Provided you were qualified as on that date for promotion.
Yes, but since we were placed under rule 32 on an independent capacity minutes charge, not we are eligible for promotion. Therefore,
What is the law on the point?
Lord,
How courts have said that?
My lord,
Ah.
they were promoted against the direct recruitment vacancies under Rule 32. Subsequently, my lord, they were regularized from the date of prospective effect. There is no vacancies available for promotional quota.
They were,
Under the
that was not their quota.
their quota.
ಅದೇನ್ ಪ್ರಮೋಟಿ ಕೋಟಾದಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ಇವ್ರಿಗೆ
that is not minutes forthcoming as per the statement of the government.
ಅಲ್ರಿ ನೀವ್ ಹೇಳಿ ಯಾವ ಕೋಟಾದಲ್ಲಿ ಅವ್ರನ್ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ರಿ?
Lord, they have been placed in independent charge against the quota meant for direct recruitees.
ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್.
Direct recruitees.
ಇಲ್ಲ ಅದು ಹೇಳಿಲ್ಲ ಆರ್ಡರ್ ಅಲ್ಲಿ ಪ್ರಮೋಷನ್
ಹೇಳ್ತಾ
ಮಾಡುವಾಗ
ಆಯ್ತು ಈಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು ಈಗ ಹೇಳ್ತಾ ವಾಟ್ ಇಸ್ ಓವರ್ minutes without any record. But I can place it on record minutes. Can I share? Kindly see the where minutes we were placed under
ನೋಡ್ರಿ
independent charge.
This is what Rama Joyce writes. Honorable Justice Rama Joyce writes. He has dedicated 1/2 chapter on that. Okay, ತರ್ಸ್ರಿ Rama services under the state ತರ್ಸಿ. ಇದೆಯಾ? ಅದರಲ್ಲಿ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಇನ್ ಚಾರ್ಜ್ ಅನ್ಕೊಂಡು ಒಂದು ಇಂಡೆಕ್ಸ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ. ರೈಟ್ 366 ಪೇಜ್ 366. They have referred to Justice Govinda Bhatt's judgment. ಅದು ಮೋಸ್ಟ್ಲಿ ಫಸ್ಟ್ ಎಡಿಷನ್ ಅದ್ದು ಇರ್ಬೇಕು ನೀವು ಹೇಳ್ತಾ ಇರೋದು. ಇದು ಸೆಕೆಂಡ್ ಎಡಿಷನ್. 1984 ಎಡಿಷನ್ ಅದ್ದು ಇದರಲ್ಲೂ ಇದೆ. ಸೀನ್ ಇನ್ ದಿಸ್ ಬುಕ್ ಆಲ್ಸೋ. BN ಧೋತ್ರ ವರ್ಸಸ್ ಲ್ಯಾಂಡ್ ಆರ್ಮಿ ಕಾರ್ಪೊರೇಷನ್. ILR ಏನಪ್ಪ?
ILR 2006
2006 ಕರ್ನಾಟಕ ಕೊಡಿ. M. Marideva versus state. BN Dhotra.
Yes, it refers to Marideva.
It refers to Marideva. That's what Justice Govind Bhatt's judgment.
Yes.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿ. ಇದನ್ನೆಲ್ಲ ಯಾಕೆ ಓದ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀವಿ ಅಂದ್ರೆ ನಮಗೂ ನೆನಪಾಗ್ತದೆ ಸರಿಯಾಗಿ. ನಂತರ ಮೆನಿ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇರ್ತಾರೆ, ಅವ್ರಿಗೆಲ್ಲ ಹೆಲ್ಪ್ ಆಗ್ತದೆ. ಅವರೆಲ್ಲ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಲ್ಲ ಕೋರ್ಟದ್ದು. ಅದಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಏನಿದೆ ಅನ್ಕೊಂಡು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. ಅದರಲ್ಲಿ ಒಂದು ತಾಸು ಹೋಗ್ತದೆ ನಮ್ಗೆ. ಓದಿ ನೋಡಿ, ಅವ್ರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಕೊಡಿ ಓದಿ. ಯು ರೀಡ್ ದಟ್ ಪೃಥ್ವಿ.
Therefore, I'm reading from that road. Therefore, he is not supposed to discharge the substantive functions of the post which he holds on.
No, not that. About that paragraph,
yes,
there is one we have, learned Justice, Honorable Justice Najir has quoted.
Yes.
Justice Rama Joyce's book.
Yes, my lord. That's the
Adnodi.
page 366 in relation to in-charge arrangement in higher post as under.
Correct.
Promotion to a higher post means the appointment of a civil servant to a higher post on a regular basis, either temporary or permanent, in accordance with the rules. In-charge arrangement and promotions are well understood terms
in service jurisprudence.
posting an officer in the lower post to discharge the duties of a higher post without promotion is only an in-charge arrangement and it cannot be treated as promotion. He does not get the salary of higher post, but only gets the
Charge.
prescribed charge allowance. While making such arrangement, it is the exigency of public service that shall be relevant consideration and not the
And not
consideration.
seniority.
A person so posted on independent charge does not hold the
Cannot
post of
function
post.
substantive.
Yes, he continues in the lower post, but only discharges the duties of the
So
higher.
this is the bedrock on which your right to get promotion arose.
That is not with respect to in charge, but here not an independent
In
charge.
charge, independent charge, bala difference illa anta hold made one judgment nalli Gulbargadalli ನಾವು. Except that where he holds independent charge, subject to certain exceptions, he can discharge some functions also. That one. Number two, when he holds independent charge, he gets in one subject to again exception, he gets the salary of the post which he is holding.
Yes.
There is one such judgment. Independent charge ಅಂತಂದ್ರೆ ಸ್ವಲ್ಪ higher level ನಲ್ಲಿ. But both in charge and independent charge are not on the basis of seniority at all, on the basis of exigency of service. ಅರ್ಜೆಂಟ್ ಕೆಲಸ ಮಾಡೋದಿರ್ತದೆ, ಹ್ಯಾಂಡ್ಸ್ ಇರಲ್ಲ, ಅದ್ರಾಗ ಯಾರು ಕಾಂಪಿಟೆಂಟ್ ಇರ್ತಾನೆ ಅವ್ರು ಇದನ್ನ ಯಾರನ್ನೋ ಒಬ್ಬಂದು ಚೂಸ್ ಮಾಡಿ ಅಲ್ಲಿ ಇಡ್ತಾರೆ. ಆ ರೀತಿ ಇರ್ತದೆ. ಹಂಗಾಗಿ ನಿಮ್ ರೈಟ್ ಹುಟ್ಟೋ ರೀತಿ ಇದೆಯಲ್ಲ, ಅಷ್ಟು ಸ್ಯಾಂಕ್ಟಿಫೈಡ್ ಬೆಡ್ರಾಕ್ ಅಲ್ಲ ಅದು. ದಟ್ ರೈಟ್ ಯು ವಿಲ್ ಗೆಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಆಕ್ಟ್. ಅದರಲ್ಲಿ ಅಲ್ಲಿ ನಿಮ್ಗೆ ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ಲಿ ಕೊಡಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಎಸ್ಪೆಷಲಿ ವೆನ್ the quota in which you were put in independent charge did not belong to you.
Promotion not
Satisha ಏನಿದೆ ಇದರ ಮೇಲೆ, ಈ ಪಾಯಿಂಟ್ ಮೇಲೆ ಲಾ ಏನಿದೆ?
RPP rules. RPP rules.
Says that, but if you are working on independent charge.
Yes.
But I am entitled for retrospective
Promotion from the date.
But the
Vacancy.
placement under Rule 32 is against the quota meant for.
That is what the court has said. ಯಾವ್ದು ಕ್ಯಾತೆಗೌಡನ ಯಾವ್ದೋ ಒಂದು ಸಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟೇ.
Then Minots, I may impress Minots one more point, Minots. Kindly see, we were not the.
ಮತ್ತೆ ಅವರಿಗೆ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ಟು ಏನ್ ತಂದ್ಕೊಂಡು ಕಾಫಿ
ಇಲ್ಲ.
ಕಾಫಿ ಕುಡ್ಸಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ. ನೀನ್ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ಟು
Last time our senior ಕೊಟ್ರು.
Yes. Court is entered. There is one section in IPC, in the Evidence Act. The court can put any question to anyone in the court hall.
Because we are all
section.
officials of the court.
No, not only officers. Anyone, a private party, I can ask. See the section, how beautifully Fitzgerald had coined that Indian Evidence Act. Yes.
In the first instance, Lords, they were provided promotion with effect from Lords 2021. Then, Lord, a corrigendum was passed by the respondent authorities.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೀನಿ. ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನಾನು.
ಅದೇ ಮಾಡಿ.
ಅದನ್ನ ಇವಾಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಪ್ರೀವಿಯಸ್ ದಟ್ ಈಸ್ ಎ ಕೊರಿಜೆಂಡಮ್ ಈಸ್ ಅಪೆಲ್ಡ್ ಅಂಡ್
ಕರೆಕ್ಟ್. ಆ ಪ್ರಿನ್ಸಿಪಲ್
ಬೇರೆ ಏನಿಲ್ಲ.
ಬರ್ಕೊಳ್ಳಿ. The civil servants are grieving against the order of the state administrative tribunal dated so and so, whereby their challenge to government corrigendum dated so and so has been negatived, wide order dated so and so. First, learned counsel appearing for the petitioners vehemently argues that once a civil servant is placed in the independent charge of the higher post for a long period, he gets a right to get promotion to the said post with effect from the date he gained entry to the same. First, in support of that, he banks upon Rule 2 bracket 3
subsection
of pay promotion pension rules.
Regulations.
Pay pension pension promotion rules.
1978.
First, learned AGA appearing for the state and learned private counsel appearing for
I am
the
only for
impleading
Not yet
applicant.
allowed.
Impleading applicant vehemently opposed the petition, contending that legal position is well settled in this regard, semicolon. Ordinarily, the promotion to be granted shall be with retrospective effect is true, first stop. However, it is subject to the condition that the placement in independent charge should be in a post that belong to the quota to which the petitioners are entitled to. First stop. We agree with this view. First stop. The same view is reflected in the impugned order. First stop. In the above circumstances, petition being devoid of merits is liable to be dismissed and accordingly. Next. Impleading application allowed.
I may have to
Since
carry out the amendment.
sorry. Since the applicant broadly fits into Rajia Begum versus so and so, AR 58 Supreme Court. Citation ಕೊಡಬೇಕು. And separate order ಮಾಡಿಕೋಬೇಕು. Petitioner to amend the cost state. Yes. Yes. Yes, Vijay.
Lord, petitioner is not promoted as AS super time scale on 7/3/2024. Lord, page annexure C, page 43. By which, Lord, the post held by the petitioner was additional deputy commissioner, which is an upgraded post and which can be filled only by a person who is in the KAS super time scale cadre.
KAS super time scale alone can be brought to that.
Yes, Lord. That is what the order of promotion says, Lord. Lord, on 1/8/2024, Lord, I was promoted on 7/3/2024 and sent to Bagalkot as additional deputy commissioner. Lord, sir, before I could complete my tenure, on 1/8/2024, third respondent is posted in place of petitioner. And
Detention period in.
minimum period is 2 years, Lord,
2
and
years.
maximum is 5.
And what is the reason to dismiss?
Minimum period is 2 years, Lord, for group A post. Lord, I have not completed 2 years, sir. Lord, so on 1/8/2024, the private respondent, Lord, is posted in the place of petitioner, rendering the petitioner without posting, Lord. Questioning the same, Lord, I approached the Honorable Tribunal. Initially, Lord, the Honorable Tribunal granted me an interim order. Lord, there was an interim order operating. Lord, in the meantime, Lord, during the pendency of the application, Lord,
Posting
the
quote.
respondent authority gave me posting in Bagalkot itself as project director, urban cell, Bagalkot. Lord, that was challenged by me before the Honorable Tribunal in Belagavi bench. Lord, what has happened is that project director post can be filled by a selection grade officer.
Not you.
Not by the super time scale. Lord, the third respondent who is in the selection grade cadre, Lord, he, Lord, is posted in the place of petitioner, rendering me without posting. And when the matter was seized before the tribunal and the interim order was operating, Lord, I was given posting as project director Bagalkot. Lord, questioning that, I approached the tribunal and tribunal granted interim order of stay on to that order also, Lord. In the meantime, what has happened, Lord, there are 2 interim orders were operating. Lord, the interim order which is operating in the Belagavi bench, Lord, is still matter is pending before the tribunal, which is yet to be decided, Lord. In the meantime, Lord, tribunal, Lord, dismissed the application filed by the petitioner before this
On the ground that posting is given.
Yes, Lord. And saying that you have there is no hardship is caused because you are posted in the Bagalkot district itself, as a Bagalkot itself. Lord, the question before your lordship says my question before the tribunal, Lord, I said that
One is premature.
Another
is even subsequent event could not be a ground for dismissal because the post which is given to you is lesser than what you are entitled.
Lower care post. And Lord, now, Lord, the application is dismissed. On that ground, Lord, I approached this honorable court challenging the same, Lord, the tribunal order.
What do you say?
I have to seek instructions.
Yes.
Well, I have filed a caveat already. My name is not shown.
No, you are here now.
Yes, I may be permitted. All these, both the points are covered by a well-reasoned order of the tribunal. Point number 1, as far as posting, which he says that he was given
a lower posting, that's incorrect. Tribunal in depth at para number 6 and 7 of the impugned order.
Why he cut short the period of retention period?
It has not been cut short, my lords. It is not a transfer. For that also, there is an order. In detail, it has been addressed by the tribunal, which says the transfer policy permits chief minister to cut short the period.
What is
Number
the
one.
reason
Second-
given by the chief minister?
Their lordships have said, so,
We have held,
yes,
just giving approval is insufficient.
sir,
He has to give reason why
My-
he is granting the approval.
My
That you have
lords, your lordship may kindly see in the final order itself, their lordships have specific in the tribunal, they have categorically stated that we have gone through all the records and on getting convinced that this order is not nullified and all the procedures are followed, they say that there is no merit. They have specifically mentioned that
but
they have
that's
gone
not-
through all the records.
That's insufficient. Justice H.G. Ramesh said, Satish, which is that judgment? H.G. Ramesh's judgment which said the chief minister has to give the reason for approval, which is that judgment?
M. Rajshekar.
N. Rajshekar versus Swines.
But your lordship may one more thing, your lordship may kindly see,
Yes.
I have here, what their lordships have stated is here, your lordship can, it is at page number 7. However, the guide, they say that it is not a transfer also because in the same building, he has been given a posting. In the same building.
Which is that judgment? With the building also the transfer, it amounts to transfer, which is that?
ಇಲ್ಲ ಅದು ಇನ್ನೊಂದು ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದೆ
Amresh versus.
ಅದರಲ್ಲಿ ಹೇಳಿದ್ರು ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಮಾಡಿದಾರೆ ಅಂತ.
And it requires consideration. Issue emergent notice.
I have already reported
Learned-
for duty. I am working there.
Give
No,
back,
I have
give
not
back
handed
that
over the
duty to
charge.
him. Learned AG is requested to accept notice for respondents 1 and 2. First up, the petitioner shall be continued in the office from which he was transferred. And the third respondent is directed to yield the post to him immediately. Full stop. The compliance has to be reported by the government of this order on the next date of hearing. Call this matter on Thursday. Yes, next. Friday. Wednesday ಮಾಡ್ಕೊಳ್ಳಿ. Wednesday ಮಾಡ್ಕೊಳ್ಳಿ. Yes.
14th, my lords. 14th.
14. Oh, 14. But you should report, say it is made clear that if the private respondent does not obey this order, he shall not be heard in the matter. Okay.
My lords, I may be permitted to file my wakalat.
Shri Shankar Hegde appears for third respondent. Okay.
PM.
Yes.
Again, a transfer, my lords. My lords, I was posted to the present place on promotion on 15/11/24. My lords, by an order of 7/11/20, 7/1/21. Now, my lords, by order
But
dated
what is the
15
post? What is the retention? It's a transfer matter.
transfer matter, my lords. My
What
lords,
is the post? What is the retention period?
survey supervisor 4 years. Now, my lords, the order was passed in November, given effect to in February, my lords. By February, my lords, I have completed my term, my lords. Only difficulty is this. I was rendered without posting in the impugned order, my lords. They said he shall be transferred to some other district. Now, my lords, I was rendered without posting. Tribunal said only till he is given a posting. My only request is, my lord, I am physically handicapped. I have 2 children studying. Up till the general transfer, my lord, if interim order is continued, my lord, if I am retained there, only up till
That
then.
becomes ನಾಳೆ ಇನ್ನೊಬ್ರು ಕೇಳ್ತಾರೆ ನಾಳೆ ನೀವು ಪೃಥ್ವಿಗೆ ಆರ್ಡರ್ ಕೊಟ್ಟಿರಿ ನಮಗೂ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಮುಂದೆ ನಾವೇನ್ ಮಾಡ್ಬೇಕು?
Nobody is posted to my place also, my lord.
Huh?
Nobody is posted to my place.
ಯಾರನ್ನು ಪೋಸ್ಟ್ ಮಾಡಿಲ್ವಾ?
Nobody is posted and I am
Not yet received any instruction.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ.
my lord, I am
ಕಾಪಿ
given
ಯಾವತ್ತು ಕೊಟ್ರು? ಮಧ್ಯಾಹ್ನ ಕರಿತೇವೆ, immediately ಕರಿಬೇಕು ಆಫೀಸರ್ಸ್. He is handicapped person, although he has got 2 children. That's all right. But there is no posting.
Yes, ma'am.
Why?
I'll find out. I'll find out.
Yes. my lord.
Afternoon.
But only one thing I would want. There are no complaints or no allegations. I just wanted to bring that.
Transfer. Yes.
Yes, great.
Similar to my lord, the serial number 12, Lord, FIR is stayed by this honorable court,
Padi.
which is at, my lord, page 127. The basis for suspension is, my lord, registration of the criminal case. But I will give only two dates, my lord. On 7/2/2025, Lord, the petitioner passes an order, Lord, impounding the document and direct the complainant to pay the deficit stamp duty on 7/2/2025.
7/2/2025.
Yes,
This is under the Stamp Act section 34.
yes, he is a district registrar, my lord, under section 30. Lord, passes an order. On the same day, my lord, complainant gives, my lord, pays the stamp duty. Lord, thereafter, my lord, I issue the, my lord, certificate.
That deficit is made good.
Made good. Lord, on 12/2/2025, he gives a complaint that one Sri Kiran, who is working as, my lord, FDA in the office of district registrar, has demanded illegal gratification on 6/2/2025. Lord, trap takes place. Lord, I am requested to my lord, go for, my lord, chemical test. Chemical test is negative. Lord, the trial court says that no work is pending. Therefore, my lord, I challenge the FIR.
Document was given, deficit was given when? Which date?
7 to page 73.
What was the deficit amount?
Lord, 33,000, Lord, 26,400.
Show that date.
Lord, page 73. With these facts, my lord, this honorable court stays FIR and all further proceedings.
This was on 7/2/2025.
Yes,
Yeah, ಯಾವ್ದೋ ಕಿರಣ್ ಹೇಳಿದ್ದು ಯಾವ date?
11/2/2025.
What do you say, brother?
Kindly come to, my
Matter is
lord.
still pending before the tribunal, my lord. They are
All right.
against
What?
fresh matter, my lord.
Yes. She has collected duty and given it to the state exchequer. And as on that date, 11 to ಏನು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಅವರು ಸಸ್ಪೆಂಡ್. Yes, suspension spree. Wherever you want, you will ತಗೊಳ್ಕೊಳ್ಳಿ. See, she should be given some award. She has insisted that section 33, 34 have to be complied with. They provide for impounding of documents. And she has received the amount remitted to the treasury. After 4 days, complaint is saying that on 11/2, somebody demanded money and she was subjected to that test, pink test.
My lord, there has
Test
to be
is
some
negative.
prima facie evidence for suspension, my
Just
lord.
because section
As of now,
rule
I
is
don't-
amended now. You have amended rule.
Please.
Suspension ಮೊದಲಿನಷ್ಟು wholesale ಇಲ್ಲ ಈಗ. ಕೂತ್ಕೊಳ್ಳಿ. Issue emergent notice. Learned AG is requested to accept notice for the respondent. ಎಲ್ಲ respondents are
ಒಬ್ಬರೇನೆ sole respond.
respondent. Full stop. Interim order as prayed for. Full stop. This interim protection is granted keeping in view that the petitioner collected the deficit stamp duty on the subject document under sections 33 and 34 of 34 read with 47 ಏನದು ಇನ್ನೊಂದು
45A.
45 capital A of the Karnataka Stamp Act 1957. First stop. Secondly, when she was subjected to pink test, the result was negative. First. Thirdly, allegation is of 11/2/2025, when already the deficit stamp duty was collected 4 days ago. Okay. Notice to R1. Email. Learned AG is requested to accept notice. Okay.
My lord, kindly pass over.
Pass over.
Petitioner.
Yes, Mr. Anthony.
My lord, the case had challenges the entrustment order and articles of charge, my lord. While allowing the application, the court once again says that while proceeding under 12(4), there is no independent application of mine similar to the.
ಅಷ್ಟಕ್ಕೆ ಮುಗಿಸಿ.
ಅಷ್ಟಕ್ಕೆ.
ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕವರ್ಡ್ ಬೈ ಅದು
My
citation
lord,
ಕೊಡ್ಲಿಲ್ಲ.
my colleague is bringing the citation, my lord, it's gone. I'll pass it on.
Issue emergent notice. Learned AGA is requested to. How many states of Karnataka there in this state?
My lord. My lord.
Have you read Alur
Please,
Venkat
my lord.
Rao's Karnataka Gata Vaibhava?
My lord, there is a error, my lord, in that.
Learned
I'll have it
AGA is,
corrected.
requested to accept notice for respondent number 1 and 2. Panel counsel, yaru Karthika yaru BBM. See, Karthikeyan panel counsel is requested to accept notice for respondent number 3. Emergent notice to private respondents.
So grateful.
This order is issued in the light of coordinate bench decision in
I'll
so
pass
and
it.
so.
Grateful.
Yes, my lord.
Lord,
Yes.
the appellant is the junior engineer, my lord.
Ah.
Taken the work of construction of check bund in survey number 23 in Hiriyur Taluk, my lord. Wherein, my lord, the allegation is that he has not completely done the work and given the bill for completion of the work and taken 33,000 extra amount for showing the excess amount which he has done, my lord. So based on that, my lord, the Lokayukta, my lord, has passed an order by given penalty for, my lord, annual increment with 1 year, that is cumulative effect, my lord, for 1 year annual increment has been
Charge
imposed.
prove ಆಗಿದೆ.
Charge is true agliche that complainant, my lord, who has given the complaint, that was, my lord, 2007 she has given the complaint. And she has given her evidence also, wherein, my lord, she has stated that I am not aware of the contents of the complaint, what she has given, my lord.
7 ವರ್ಷ 2007 ಕೊಟ್ಟು enquiry ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ?
Enquiry start ಆಗಿದ್ದೆ 2011, my lord.
How she will remember? She is not Shakuntala Devi to remember everything.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ she has given the complaint that work was not completed, but as per the MB report, my lord, the work is completed. MB book ಅದರಲ್ಲಿ work of
Book ನಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿಕ್ಕೇನೆ
measurement of the book, my lord, that was maintained by
measurement book ನಲ್ಲಿರೋ ಎಂಟ್ರಿಗಳನ್ನ we cannot believe when there is a complaint, because ಆ ಬುಕ್ ಅನ್ನು ಬರೀಬೇಕಾದ್ರೆ ಅವಳ ಸಿಗ್ನೇಚರ್ ಇರಲ್ಲ, ನೀವೇ ಎಂಟ್ರಿ ಮಾಡ್ತೀರಿ MB ನ.
MB book ಅನ್ನು ಎಂಟ್ರಿ ಮಾಡೋರು ಬೇರೆಯವರು,
ಇನ್ನೊಬ್ರು
ಅದರಲ್ಲಿ
But correct.
ಅದರಲ್ಲಿ work
ಅವಳದ್ದು ಸಿಗ್ನೇಚರ್ ಇರಲ್ಲ ಅದಕ್ಕೆ. ಅವಳ ಕೆಲ್ಸ ಆಗಿದ್ರೆ ಸುಖ ಸುಮ್ನ ಯಾಕೆ ಹೇಳ್ತಾಳೆ?
ಅವ್ರದ್ದು
ಅವಳ ಕೆಲ್ಸ ಆಗಿತ್ತು ಅಂದ್ರೆ ಅವಳು ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತಾಳೆ?
ಬಟ್ ಮಲೋಡ್ ಅಲ್ಲಿ ಹೋಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ ಎನ್ಕ್ವೈರಿ ಮಾಡೋ ಟೈಮ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಯಾವ ಪ್ರೂಫ್ ಕೂಡ ಇವ್ರಿಗೆ ಸಿಗೋತಿಲ್ಲ, ಬಿಕಾಸ್ ಅಲ್ಲೆಲ್ಲ ಬುಷ್ ಫುಲ್ ಬೆಳೆದಿರೋದ್ರಿಂದ ದೇ ಹಾವ್ ಗಿವನ್ ಎ ರಿಪೋರ್ಟ್ ದಟ್ ವಿ ಆರ್ ಅನೇಬಲ್ ಟು ಕಂಡಕ್ಟ್ ದ ಎನ್ಕ್ವೈರಿ ಮಲೋಡ್. ದಟ್ ರಿಪೋರ್ಟ್ ಹ್ಯಾಸ್ ಬಿನ್.
ಈ ರೈತರು ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತಾರೆ? ರೈತರಿಗೆ ಸುಳ್ಳು ಹೇಳುವಂತ ಅಗತ್ಯ ಎಲ್ಲಿ ಬೀಳ್ತದೆ? ಅವಶ್ಯಕತೆನೇ ಬೀಳಲ್ಲ. ಆಫೀಸರ್ಸಿಗೆ, ಲಾಯರ್ಸಿಗೆ, ಜಡ್ಜಸ್ಸಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಬೇಕಾಗ್ಬೋದು ಸುಳ್ಳು ಹೇಳೋದು, ಆದ್ರೆ ರೈತ ಯಾಕೆ ಹೇಳ್ತಾನೆ? ಅವನು ಕಾರಣನೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಲೇಡಿ ಬೇರೆ ಏನಿಲ್ಲ. ಕಾಮನ್ ಸೆನ್ಸ್ ಸೇಸ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಆರ್ ಹ್ಯಾಪನಿಂಗ್ ಇನ್ ದ ರೆವೆನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಅದರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್. ಕೋಡಿಗೆ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು, ಎಂಟ್ರಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಎಂಟ್ರಿ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು. ಅದು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕೋಬೇಕು. ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡೋದು, ಅದಾದ್ಮೇಲೂ ಸಹಿತ ಮಾಡಲ್ಲ. These officers do all these mischiefs. We can't keep our common sense, our experience away from these proceedings completely.
My lord, the money which he has drawn, that has directly RTGS has been given to the laborers who have done the work.
ಅಲ್ಲೇ ವ್ಯವಹಾರ ಆಗಿರ್ತದೆ, ನಾವು ಕಳಿಸ್ತೀವಿ, ನೀವು ಇಷ್ಟಿಷ್ಟು ಕೊಟ್ಕೊತ ಹೋಗ್ಬೇಕು ನಮಗೆ ಅಂತ.
33,000 ಇದರಲ್ಲಿ allegation is that, my lord, 33,000 excess amount, but there is no the MB book shows that, my lord, the entire work has been completed, my lord.
You please do not repeat,
because he is in a because next month ಅಲ್ಲಿ he is going to be retired.
ಎಲ್ಲರಿಗೂ ರಿಟೈರ್ ಆಗುತ್ತೆ
ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ
ಅಂತವ್ರು ಬೇಗನೆ ರಿಟೈರ್ ಆಗ. ಏನ್ ರೈತರಿಗೆ ಮುಂದೆ ರೈತರು ಏನ್ ಮಾಡ್ಬೇಕು? ಕೆಲಸ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು? ಎಲ್ಲದಕ್ಕೂ ದುಡ್ಡು ಕೊಟ್ಕೊಂಡು ಮಾಡೋದು, ಇದು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗ್? ನಾಳೆ ಅಲ್ಲಿ
ಅಲ್ಲಿ
ಪೆಸ್ಟಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಎಷ್ಟು ಇದು ಇರ್ತದೆ, ಸಬ್ಸಿಡಿ ಎಲ್ಲ ಇರ್ತದೆ, ಅದನ್ನೆಲ್ಲ ನುಂಗಿ ಕುತ್ಕೊಳ್ಳೋದು, ಬಂಡ್ ಕಟ್ಟುವಿ, ಕೃಷಿ ಹೊಂಡ ಕಟ್ಟುವಿ ಅಂತ ಹೇಳೋದು, ಅದ್ರಾಗ ದುಡ್ಡು ಹೊಡ್ಕೊಂಡು ಕೊಡೋದು, ಬರೀ ಹಂಗಾಗ್ಬಿಟ್ರೆ ಮುಂದೆ ಹೆಂಗೆ ಇಡೀ ಸಮಾಜನ ಹಾಳಾಗಿ ಹೋಗ್ಬಿಡ್ತದೆ. ಹಂಗಾಗಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಬಹಳ ಚೆನ್ನಾಗಿರ್ಬೋದು, ಒಳ್ಳೇನಿರ್ಬೋದು, ಬಟ್ ಈ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ ಸಾಕು ಕೇಸ್ ತೊಳಿ. ಇದು ಇಟ್ ಹ್ಯಾಸ್ ಟು ಸೆಂಡ್ ಎ ಮೆಸೇಜ್ ಟು ದಿ ಪೀಪಲ್ that courts will not tolerate corruption, bribery. There should be a limit.
ವರ್ಕ್ ಆಗಿರೋದ್ ಬಗ್ಗೆ all reports is very clearly stating that my lord work has been completed. But ಅಲ್ಲಿ my lord ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಮೌಂಟ್ which has been taken excess amount ಅಂತ ಹೇಳಿ ಒಂದ್ ಕಡೆ ರಿಪೋರ್ಟ್ ಹೇಳ್ತಿದೆ. But she has given a complaint that my lord work has not completed ಅಂತ.
ಅವಾಗ ವರ್ಕ್ ಅಷ್ಟು ಅಮೌಂಟ್ ಖರ್ಚು ಮಾಡಿದ್ರೆ ಪೂರಾ ವರ್ಕ್ ಆಗಿಬಿಡ್ತಿತ್ತು. ಪೂರಾ ವರ್ಕ್ ಆಗ್ಲಿದ್ದಾಗ ಏನ್ ಉಳಿಯತ್ತಲ್ಲ ಅಮೌಂಟ್, ಅದನ್ನ ಜೋಬಿಗೆ ಹಾಕೋಣ ನಾವು ನಿಮ್ ಕ್ಲೈಂಟ್.
ಅದರಲ್ಲಿ 3 ಜನ ಇದ್ದಾರೆ my lord, 3 engineers are there my lord.
Heard. Dismissed, agreeing with the order, reasoning of the tribe. Okay. Yes.
This is a writ filed by the state challenging the order of the tribunal, my lord, rejecting the both the application and thereafter review application was also filed, my lord. Even that came to be dismissed on the ground of delay, my lord. My lord, on merits, my lord.
Notice, sorry. Emergent notice.
My lord, on merits, definitely state has a case.
We have seen that.
Please, read.
Okay. ನೋಡಿ, ನಿಮ್ಮ ರೆವೆನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, ಎನಿ ಸರ್ವಿಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, ಈ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟಿಗೆಲ್ಲ ಸಮಸ್ಯೆ ಮಾಡೋದು, ಲೇಬರರ್ಸಿಗೆ ಸಮಸ್ಯೆ ಮಾಡೋದು, ಅದೆಲ್ಲ ಆಯ್ತು ಅಂದ್ರೆ ನಾವು ಸುಮ್ಮನೆ ಇರಲ್ಲ, ಆಯ್ತಾ? ವಿ ವಿಲ್ ಇಂಪೋಸ್ ವೆರಿ ಡೀಪ್ ಉಂಡ್, ವೆರಿ ಡೀಪ್, ದೊಡ್ಡ ಗಾಯ ಮಾಡ್ತೇವೆ ಮತ್ತೆ ನಾವು. ಇದು ನಿಮ್ಮ ಎಂಪ್ಲಾಯೀಸಿಗೆ ಹೇಳ್ಬೇಕು, ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಹೇಳ್ಬೇಕು.
ಈಗ ಖಾತೆ ಮಾಡೋದ್ರ ಬಗ್ಗೆ,
ಖಾತೆ ಮಾಡ್ಲಿಕ್ಕೆ ಸಮಸ್ಯೆ, ಎಷ್ಟು ನಮ್ನಿ ಕೇಸ್ ಬರ್ಲಿಕ್ಕೆ ಖಾತೆ ಮಾಡ್ಲಿಕ್ಕೆ ಸಮಸ್ಯೆ. ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ಯಾಕೆ ಖಾತೆ ಮಾಡಲ್ಲಪ್ಪ ಅವರು?
ಈಗ
ಆರ್ಡರ್ ಆದ್ರೆ ಮತ್ತೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕೋಬೇಕು.
ಈಗ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ 7 days ಅಲ್ಲಿ ಅಲ್ಲೇ ಖಾತೆ
ಮಾಡ್ಬೇಕು.
ಜನರೇಟ್ ಆಗಿದ ತಕ್ಷಣ ಇಲ್ಲಿ ಜೆ ಸ್ಲಿಪ್ ಜನರೇಟ್ ಆಗಿದ ತಕ್ಷಣ ಅದು ಹೋಗುತ್ತೆ,
ಆಟೋಮೆಟಿಕ್ಲಿ ಫಾರ್ಮ್ ಜೆ ಹೋಗುತ್ತೆ, ಅದನ್ನ ಇಟ್ಕೊಂಡು ಮಾಡ್ಬೇಕು ಅವ್ರು.
ಇವ್ರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ಬೇಕು, ಅದೆಲ್ಲ ಏನಿಲ್ಲ ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಜೆ ಸ್ಲಿಪ್ ಹೋಗಿದ ತಕ್ಷಣ ವಿತಿನ್ 7 days ಅಲ್ಲಿ ಖಾತೆ
ಮಾಡ್ತಾರೆ, ಮಾಡ್ತಾ ಇಲ್ಲ.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ
ನೀವು ಹೇಳಿ, ನೀವು ನಾವು ಹಾಗೆ ಬಿಡಲ್ಲ. ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ನಮ್ ನೇಚರ್ ಹೆಂಗಿದೆ ಅನ್ನೋದು, ಗೊತ್ತಾಯ್ತಾ? ವಿ ವಿಲ್ ಪುಟ್ ಎ ವೆರಿ ಡೀಪ್ ಉಂಡ್. ಓಕೆ, ವಿ ವಿಲ್ ಮೇಕ್ ದೆಮ್ ಬ್ಲೀಡ್. ಎಸ್. ರೈತರು ಹೊಲ ಹೊಡೆಯೋದ್ ಬಿಟ್ಕೊಂಡು ಅವ್ರು ಏನ್ ಆಫೀಸ್ನಾಗ ಅಡ್ಡಾಡ್ಕೋತ ಕೊಡ್ಬೇಕನ? ಎಷ್ಟು ಕಡೆ ನಾವು ಹೋದಲ್ಲೆಲ್ಲ ಬಂದ್ಕೊಂಡು ರೈತರು ನಾವ ಆಫೀಸರ್ಸ್ ಅಂತ ತಿಳ್ಕೊಂಡಿರ್ತಾರೆ, ಪಾಪ ಹಿಂಗ್ ಸ್ವಾಮಿ ಹಿಂಗಾಗಿದೆ ಹಿಂಗೆಲ್ಲ ಹೇಳ್ತಿರ್ತಾರೆ ಬಂದ್ಕೊಂಡು. ಯಾಕೆ ಹಂಗಾಗ್ತಾ ಇದೆ? ಆಸ್ಕ್ ಯುವರ್ ಆಫೀಸರ್ಸ್ ಟು ಬಿ ಫ್ರೆಂಡ್ಲಿ ವಿತ್ ಅಟ್ ಲೀಸ್ಟ್ ಯಾರು ನಮಗೆ ಅನ್ನ ಹಾಕ್ತಾರಲ್ಲ ಅವ್ರಿಗಾದ್ರೂ ಫ್ರೆಂಡ್ಲಿ ಇರ್ಬೇಕು. ಬೇರೆಯವ್ರಿಗೆ ನೀವೆಂತ ಮಾಡ್ತಿರೋ ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್ ಅಲ್ವಾ? ಏನ್ ಹೇಳಿದ್ರು ಕುವೆಂಪು ಅವ್ರದ್ದು? ಇವನೇ ನೋಡು ಅನ್ನದಾತ, ದುಡಿತ ಮಾಡುವ ಅನ್ನ ಕೊಡುವವನು ಬರುತ್ತಲ್ಲ, ಅದು ಸರ್ವಜ್ಞನೊಂದು ವಚನ ಏನದು, ಕೋಟಿ ವಿದ್ಯೆಯಲ್ಲಿ ಮೇಟಿ ವಿದ್ಯೆಯೇ ಮೇಲು, ಮೇಟಿ ರಾಟಿ ನಡೆದುದಲ್ಲವೇ ಅಂತ ಅನ್ಕೊಂಡೊಂದು ವಚನ ಇದೆ. ಸೊ ಅಡ್ರೆಸ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಆಫ್ ಫಾರ್ಮರ್ಸ್ ಫಸ್ಟ್. ಓಕೆ, ಫಾರ್ಮರ್ಸ್, ಲೇಬರರ್ಸ್, ಅಪ್ರೆಸರ್ ಕ್ಲಾಸಸ್, ಅವರನ್ನು ನೀವು ಕಾನ್ಫಿಡೆನ್ಸ್ ನ ತಗೊಳ್ದೊರ್ತು ಗೌರ್ಮೆಂಟ್ ನ ಮೇಲೆ ನಂಬಿಕೆ ಬರಲ್ಲ. ಈಗ ನಮ್ಮ ಮೇಲೂ ನಂಬಿಕೆ ಹೋಗಿದೆ, ಬಟ್ ನಿಮ್ಮ ಮೇಲೂ ಸ್ವಲ್ಪ ಉಚ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಎಸ್.
My lord, in this seeks a short pass over, my lord.
Pass over.
One submission, lord. No difficult to pass over. Letter dated 25/1/24, written by the then secretary, making allegation against the committee, these very members.
Yes.
May produce for pursuit of this court.
ಆ ಕಮಿಟಿ ಆ ಲೆಟರ್ ತರಿಸಿ.
Very difficult, my lord, because they made an allegation. Secretary specifically made allegation these members.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಬರ್ರಿ, ಅದೊಂದು ಲೆಟರ್ ತರಿಸಿ.
And OMR sheet ತಾವು ನೋಡ್ಬಿಡಿ, ನಮ್ಮ ತಪ್ಪಿದ್ರೆ ನಮ್ಮನ್ನು ತೆಗೆದು ಹಾಕ್ಬಿಡಿ, ತೊಂದರೆ ಏನಿಲ್ಲ.
We are not on that.
I am not worried about.
We are unhappy the way things are happening in that house.
My lord is right. Right from 1998, not today.
ಈ ಹೌಸ್ ಅನ್ನು ಕ್ಲಿಯರ್ ಮಾಡಿ ಹೊರತು ಇದು ಅಟ್ ಲೀಸ್ಟ್ ಒಂದು 50% ಜನರಿಗಾರು ನಿಜವಾದ ಜಾಬ್ ಸಿಗಬೇಕಲ್ಲ. ಎಲ್ಲದೂ ಆಕ್ಷನ್ ಆಗಂಗಿದ್ರೆ ಸುಮ್ ನೋಟಿಫೈ ಮಾಡಿಬಿಡಿ, ಇಂತಿಂತ ಪೋಸ್ಟಿಗೆ ಇಷ್ಟು ಅನ್ಕೊಂಡು ಒಳ್ಳೇದು. ಜನರಿಗೆ ಅಟ್ಲೀಸ್ಟ್ ದುಡ್ಡು ಇದ್ದಂತ ಬದುಕ್ತಾರೆ, ದುಡ್ಡು ಇಲ್ದಂತ ಸಾಯ್ತಾನೆ ಹೋಗ್ಕೊಂಡು. ಒಂದು 50% ಆದ್ರೂ ಒಂದು ಮೆರಿಟೋರಿಯಸ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕಾ?
In this case, my lord, particularly the KPSC itself has
ನಾವು ಮತ್ತೆ
initiated, my lord.
ಪೇಪರ್ಸ್ ಮತ್ತೊಂದು ಸರಿ ಓದಿದ್ವಿ ನಾವು ಪೇಪರ್ಸ್ ಎಲ್ಲ. ಪರ್ಹ್ಯಾಪ್ಸ್ ಅಂಬೇಡ್ಕರ್ ಜಿ ತಮ್ಮ ಸಮಾಧಿಯಲ್ಲಿ ತಿರುಗಿ ಬೀಳ್ತಾರೆ. ಎಂಥದ್ದು ಮಾಡಿದ್ವಿ ನಾವು ಅಂತ ಹಂಗ್ ಮಾಡ್ಬೇಡ್ರಿ.
All these my lord petitioners are degree with distinction they passed.
ನೋಡೋಣ
I contested my lord, they passed with.
ನಮ್ಗೆ ಭಾರಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದು ಟು ಮೀ ಅಂಡ್ ಟು ಮೈ ಬ್ರದರ್ ಈಸ್ 3-member committee is constituted. Committee is working. 3 meetings have taken place before constitution of the committee. The information is sought for from the secretary. The secretary has furnished the information. Everything is being looked into. You send that list. Very next day, on 24th it is prepared, 25th it reaches the government.
That is not correct.
ಹೆಂಗಿದು? ಹಂಗಾಗಿ
Immediately he shifted my lord, because they made allegation, secretary shifted. After my lord shifting secretary, these people made allegation secretary.
We look at pass. ಬರ್ರಿ. ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಟ್ಕೋಬೇಕಾ?
ಆಯ್ತು ಸರ್,
2:30. ಓಕೆ. ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ ಆಡಿಯನ್ಸ್ ಇಲ್ಲ. ನೋಡ್ 2:30 ಬನ್ನಿ.
At 25/1/24 letter ಅಂತ ತರ್ಸ ತಮ್ಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
ಆ ಲೆಟರ್ ತಗೊಂಡ್ಬರ್ಬೇಕು. ನೋಡ ಎಲ್ಲ ಅಷ್ಟು ಎವ್ರಿಥಿಂಗ್ ವಿ ವಾಂಟ್ ಟು ಲುಕ್ ಇನ್ ಟು. ಎಟ್ ಲೀಸ್ಟ್ ಒಂದು 50% ಜನರಿಗಾದ್ರೂ ಒಳ್ಳೆಯವ್ರಿಗೆ ಸಿಗಬೇಕಲ್ಲ ಜಾಬು. ಎಲ್ಲದೂ ಮಾರ್ಕೊಳ್ಳೋದು ಅಂತಂದ್ರೆ ಏನ್ ಹಿಂಗೆಲ್ಲ ಮಾತಾಡ್ಬಾರ್ದು ನಾವು. ಆದ್ರೆ ಹಂಗ್ ಮಾತಾಡಿಸ್ತದೆ, ರೆಕಾರ್ಡ್ ನೋಡಿದರೆ ಅವ್ನ ರೆಕಾರ್ಡ್ ಎಲ್ಲ ನಾವು ಇನ್ಮೇಲೆ ಜನರು ಓದಂಗ್ ಹಿಂಗ್ ಹಿಡಿದು ಬಿಡ್ತೇವೆ. ನೋಡ್ಲಿ, ಎಲ್ಲರೂ ನೋಡ್ಲಿ ಏನೇನಾಗಿದೆ ಅಂತ, ಎಲ್ರಿಗೂ ಗೊತ್ತಾಗ್ಲಿ. ಹಿಂಗೆಲ್ಲ ಹಾಕೋತ್ ಹೋದ್ರೆ ನಾಳೆ ಕ್ರಾಂತಿ ಆಗ್ತದೆ.
It's a painful thing.
ಬೇಕವು ಒಳ್ಳೊಳ್ಳೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಬೇಕು. ಎಲ್ಲದನ್ನು ಮಾರ್ಕೊಳ್ಳೋದಲ್ಲ. ಸಿಕ್ಕಿದ ಸಗಣಿ ಎಲ್ಲ ಮಾರ್ಕೋತ್ ಹೊಂಟ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಮುಂದಿನ ಜನಾಂಗ ಉಳ್ಕೊಳ್ಳೋದು ಹೆಂಗೆ, ಸಮಾಜ ಉಳ್ಕೊಳ್ಳೋದು ಹೆಂಗೆ? We will not permit all those. We will do something in this matter.
But 24% my lord, I can understand. Out of 24, only 11, because they are unable to reach them.
ಇದರಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಪಾರ್ಟಿ ಇದೆನಾ?
ಇದೆ. Government party.
Ask your tell your advocate general that court has asked him to come here. Yes. ಅವು ಸಬ್ಜೆಕ್ಟ್ OMR ಆನ್ಸರ್ ಶೀಟ್ಸ್ ಇದಾವಲ್ಲ, OMRs ಇದಾವಲ್ಲ, ಸೀಲ್ಡ್ ಕವರ್ನ ಕೊಡಿ, ಅವನ್ನ ತರಿಸಿ, ಬೇಗನೆ ತರಿಸಿ. 2:30 ಬರಬೇಕು. ಸಮಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ಆಗ್ತಾ ಇದೆ.
FSL ರಿಪೋರ್ಟ್ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ, ಏನೇನ್ ತರಿಸಿದೆ ಎವ್ರಿಥಿಂಗ್ ವಿ ವಿಲ್ ಕೀಪ್.
ನಮ್ಗೆ ಕೊಡಿ. ಸಾಮಾನ್ಯವಾಗಿ ಅವನ್ನೆಲ್ಲ ನಾವು ನೋಡ್ಕೊತ್ ಕೊಡ್ಬಾರ್ದು. ಆದ್ರೆ ಇದು ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಕೇಸ್. ತುಂಬಾ ಪಾಪ ಯುವಕರಿಗೆ ಭ್ರಮ ನಿರಸನ ಆಗ್ತಾ ಇದೆ. ದುಡ್ಡಿಲ್ದಂಗ ಆಗೋದೇ ಇಲ್ಲ ಕೆಲಸ ಅನ್ನುವಂಥದ್ದು ಬಂದ್ಬಿಟ್ಟಿದೆ ಈಗ. ಆ ನಮ್ನಿ ಆಗಿದೆ. ಯಾವುದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಆಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಆ ರೀತಿಯಾಗಿದೆ. ಬಿಡಿಸಿ ಹೇಳಲ್ಲ, ಆಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹಂಗಾಗಿದೆ. ಇಲ್ಲಿಗೆ ಬಿಡಲ್ಲ ನಾವು. ಇದು we will take it to its logical end. Yes.
ಈ KS
ಬರ್ಲಿ ನೋಡ.
KS ಎಕ್ಸಾಮೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರು. ಯಾಕೆಂದ್ರೆ ಆಲ್ ಮೆಂಬರ್ಸ್
let them argue in respect of this case, my lord. Let them argue ಏನು ಮೆರಿಟ್ ಅಥವಾ ಮೆರಿಟ್ ಅಲ್ಲ, ಹೇಗ್ ಬಂದಿದ್ದಾರೆ ಅನ್ನೋದು my lord.
ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಇರಬೇಕಲ್ಲ.
Transparency is very important. All the materials before the
ಸೆಲೆಕ್ಷನ್ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಇರಬೇಕು. Let the meritorious students come to the particular post.
ಒಂದು
ಏನಾರ ಮಾಡಿದ್ರೆ
ಈಗ ಪಾಪ ಅಷ್ಟೆಲ್ಲ ಕಷ್ಟಪಟ್ಕೊಂಡು ಓದ್ಕೊಂಡು ಬಡವರು ಇರ್ತಾರೆ. ದುಡ್ಡು ತಂದು ಕೊಡೋದು ಎಲ್ಲಿಂದ ತಗೊಂಡ್ಬಂದು ಕೊಡೋದು?
ಅಲ್ಲ, ಈ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಅಲ್ಲ
ಬೇರೆ ಕೇಸ್ ಅಲ್ಲದು. We are not on this case alone. This case we know how to decide.
Generally,
but your case will be very deeply looked into. ನಾಳೆ ಹೆಂಗೆ ಎಲ್ಲದೂ ಕಡೆ ಕರಪ್ಷನ್ ಆಗ್ಬಿಟ್ರೆ ಮುಂದೆ ಹಂಗಾರೆ ಹೆಂಗ್ ಮುಂದಿನ
ಕಷ್ಟ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ದೇಶ ಗೊತ್ತಾ, 6 ಲಕ್ಷ ಜನ ಪ್ರತಿ ವರ್ಷ ನಮ್ಮ ದೇಶದಿಂದ ಹೊರಗಡೆ ಹೋಗುವಂತವರ ಸಂಖ್ಯೆ 6 ಲಕ್ಷ. ಇಲ್ಲಿ ಮಾಡಲ್ಲ ಅವರು. ಎಲ್ಲ ಕ್ರೀಮ್, ಅದು ಆ ಕ್ರೀಮ್ ಎಲ್ಲ ಬೇರೆ ದೇಶಕ್ಕೆ ಹೋಗಿ ಕೊಡ್ತದೆ. ಇಲ್ಲಿ ನಮ್ ದೇಶ ಉದ್ಧಾರ ಮಾಡೋರು ಯಾರು?
So all brainees
ದೇಶ
are
ಉದ್ಧಾರ
going.
ಆಗೋದು ಹೆಂಗೆ? ಎಲ್ಲ ಕ್ರೀಮ್ ಬ್ರೈನ್ ಎಲ್ಲ ಅಷ್ಟು ಹೊರಗೆ ಹೋದ್ರೆ
True, my lord.
ಇಲ್ಲಿ ಮತ್ತೆ ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡೋರು ಯಾರು?
ಇಂಥವ್ರೆ.
ಹಾ 6 ಲಕ್ಷ ಜನ ಹೋಗ್ತಾರೆ. ರಿಪೋರ್ಟ್ ಇದು.
True, my
ದಿಸ್ ಇಸ್ ಅಫಿಷಿಯಲ್ ರಿಪೋರ್ಟ್.
ಬ್ರೇನ್ ಡ್ರೈನ್ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಆ ನಮ್ನಿ ಬ್ರೈನ್ ಡ್ರೈನ್ ಆದ್ರೆ ನೋಡಿ, ಅವರು ಇಸ್ರೇಲ್ ಕಟ್ಟುವಾಗ ವೆನ್ ಗುರಿಯನ್ ಆಸ್ಕ್ಡ್ ಆಲ್ ಜೂಯಿಶ್ ಪೀಪಲ್ ಟು ಕಮ್ ಟು ಇಸ್ರೇಲ್, ವಿ ವಾಂಟ್ ಟು ರಿಬಿಲ್ಡ್ ದಿಸ್ ನೇಷನ್, ಎಲ್ಲರೂ ಬನ್ನಿ ಅಂತ ಕರ್ಕೊಂಬಂದ್ರು ಹೊರಗಿನಿಂದ. ನೀವು ಇಲ್ಲಿಂದ ಎಲ್ಲರನ್ನು ಚೊಲ್ ಕಳಿಸ್ಬಿಟ್ರೆ ಮುಂದೇನ್ ಬೇರೆ ಕಳಪೆ ಜನರ ಜೊತೆನೆ ಇರೋದನ್ನ ಮುಂದಿನ ಜನಾಂಗ ಮುಂದೆ ಹೆಂಗೆ?
This is the right time to
you have to do something.
get the house in order.
Yes. ಬ್ರೈನ್ ಡ್ರೈನ್ ಆಗ್ತಾ ಇದೆ ದೇಶದಲ್ಲಿ. ಎಲ್ಲ ನಮ್ ಫರ್ಟಿಲಿಟಿ ಅಷ್ಟನ್ನು ಬೇರೆ ದೇಶಕ್ಕೆ ಕೊಟ್ಟು ಬಿಟ್ರೆ ಮುಂದೆ ನಾವೇನ್ ಮಾಡ್ಬೇಕಿಲ್ಲಿ? ಒಬ್ಬ ಗ್ರೇಟ್ ಬ್ರೈನಿ ಲೈಕ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ, ಎಷ್ಟು ಲಕ್ಷ ಎಕರೆ ನೀರಾವರಿ ಆಯ್ತು ಒಂದು ಬ್ರೈನ್ ನಿಂದ.
ಹೌದು.
ಮತ್ತೆ ಒಂದೇ ಬ್ರೈನು. ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ ಒಂದೇ ಬ್ರೈನು. ಎಷ್ಟು ಕೋಟಿ ಜನರಿಗೆ ಉಪಯೋಗ ಒಂದು ಗ್ರಂಥದಿಂದ, ಹೌದಾ? ಅಂತವ್ರನ್ನೆಲ್ಲ ನೀವು ಅವ್ರು ಸಪೋಸ್ ಅಂಬೇಡ್ಕರ್ ಜಿ ಅಲ್ಲೇ ಅಮೆರಿಕದಾಗ ಇದ್ದು ಬಿಟ್ಟಿದ್ರೆ ಅವ್ರಿಗೆ ಬೇಕಾದಷ್ಟು ಆಫರ್ ಇತ್ತು ಅಲ್ಲಿರ್ಲಿಕ್ಕೆ, ಬಿಟ್ಟು ಬಂದ್ರು ದೇಶಕ್ಕೆ. ಮೈ ಹಾರ್ಟ್ ಬ್ಲೀಡ್ಸ್ ಫಾರ್ ಇಂಡಿಯಾ ಅಂತ ಹೇಳಿದ್ರು. He came, otherwise he would have been a professor in Columbia University.
Yes, ma'am.
ಅವರೆಲ್ಲ ಇಲ್ಲಿ ಬಂದು ಮಾಡಿದ್ದಕ್ಕೆ ದೇಶ ಉಳ್ಕೊಂಡಿದೆ, ಸಮಾಜ ಹಂಗಾಗಿ ಉಳ್ಕೊಳ್ತದೆ. ಎಲ್ಲದನ್ನು ಮಾರ್ಕೊಂಡು ಸಿಕ್ಕ ಸಗಣಿ ಎಲ್ಲ ಮಾರ್ಕೋಬೇಕು ಅಂತ ಹೊಂಟು ಬಿಟ್ರೆ ಮುಂದೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಮಕ್ಕಳು, ನಮ್ಮ ಮಕ್ಕಳೆಲ್ಲ ಎಷ್ಟು ಜನರು ಸೂಸೈಡ್ ಮಾಡ್ಕೋತಾರೆ, ಹೆಂಗ ಆಗ್ತಾ ಇದೆ? ಹಂಗೆಲ್ಲ ಆಗ್ಬಾರ್ದು. ನೀವು ಅದನ್ನೆಲ್ಲ ನೀವು ಕೆಟ್ಟ ಜನರನ್ನೆಲ್ಲ ನೀವು ಯು ಹ್ಯಾವ್ ಟು ವೀಡ್ ಔಟ್. ಅಟ್ಲೀಸ್ಟ್ ಒಂದು 50% ಜನರಾದ್ರು, ಇನ್ನು ಉಳಿದು 50% ಜನರಾದ್ರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಸರಿ ಆಗ್ಬೇಕಲ್ಲ, ದುಡ್ಡಿಲ್ದಂಗೆ. ಯಾಕೆ ಹಿಂಗ ಆಗ್ತಾ ಇದೆ? ನಾವು ಈ ಫೋರಂ ನಿಂದ ಹೆಚ್ಚು ಮಾತಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ,
ಕಷ್ಟ.
ಈ ಫೋರಂ ನಿಂದ ಇಷ್ಟೇ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ. ಓಕೆ, ಬೇರೆ ಫೋರಂ ನಲ್ಲಿಯೂ ಡಿಸ್ಕಷನ್ ಆಗ್ತಿರ್ತದೆ.
ಹೌದು ಸರ್.
ಆಗ್ತಿರ್ತದೆ. ಅದಕ್ಕೆ ಹಂಗೆಲ್ಲ ಮಾಡ್ಕೋಬಾರ್ದು.
ಸರ್ ಮಾಡ್ಬೇಕು. ಒಂದು ಮನೆಯಲ್ಲಿ ಒಬ್ಬಗೆ ಸರ್ಕಾರಿ ನೌಕರಿ ಆದ್ರೆ ಆ ಮನೆ ಉದ್ಧಾರ ಆಗ್ತದೆ.
ಮನೆ ಉದ್ಧಾರ
ಅದನ್ನ ತಿಳ್ಕೊಬೇಕು.
ಖಂಡಿತ ಸರ್.
ಬಡವರಾಗಿ ಇರೋದು ಇವರೆಲ್ಲ
ಮಾಡ್ಕೊಂಡು ಮಜಾ ಮಾಡೋರು ಮಾಡಿ ಆಮೇಲೆ ಬೇರೆ ದುಡ್ಡಿದ್ದವ್ರಿಗೆ ನೀವು ಕೊಡಂಗಿದ್ರೆ ಹಾಗಾದ್ರೆ ನಮ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಯಾಕಬೇಕು? ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೇಡ ನಮಗೆ. ಎಲ್ಲರೂ ಬದುಕಬೇಕು, ಸಹಬಾಳ್ವೆಯನ್ನು ಉಂಟು ಮಾಡುವಂತ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದು. ಬರೇ ರಿಚ್ ಪೀಪಲ್ ಅಷ್ಟೇ ಮಾಡಿ. ವಿ ಆರ್ ನಾಟ್ ಅಗೇನ್ಸ್ಟ್ ರಿಚ್ ಪೀಪಲ್. ರಿಚ್ನೆಸ್ ಇಸ್ ಎ ವರ್ಚ್ಯೂ. ಆದ್ರೆ ಬಡವರು ಇದ್ದಾರೆ ಇಲ್ಲಿ. ಏನಂತ ಹೇಳಿದ್ರು ಇವರು ನಿಸಾರ್ ಅಹ್ಮದ್ ಅವರು? ಒಂದೆದೆಯ ಹಾಲ ಕುಡಿದವರ ನಡುವೆ ಎನಿತೊಂದು ಭೇದ ತಾಯಿ, ಒಂದೇ ನೆಲದ ರಸ ಹೀರಲೇನು, ಅದು ಸಿಹಿ ಕಹಿಯ ರುಚಿಯ ಕಾಯಿ. ಹಣವಿಲ್ಲ ಹೆಣದ ಸಂಸ್ಕಾರಕ್ಕೆಂದು, ಹಣವಿಲ್ಲ ಹೆಣದ ಸಂಸ್ಕಾರಕ್ಕೆಂದು ಕೈಹೊತ್ತ ಬಡವನೊಬ್ಬ, ಇನ್ನೊಬ್ಬ ತಾನು ಆಚರಿಸುತ್ತಿರುವ ವೈಭವದ ಹುಟ್ಟು ಹಬ್ಬ. ಒಬ್ಬನಿಗೆ ಕ್ರಿಮೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ದುಡ್ಡಿಲ್ಲ, ಇನ್ನೊಬ್ಬನಿಗೆ ಬರ್ತ್ಡೇ ಆಚರಿಸ್ತಾನವ 5 ಸ್ಟಾರ್ ಹೋಟ್ಲಲ್ಲಿ. ಈ ಡಿಸ್ಪೆರಿಟಿ ಹಾಕೋತ್ ಹೋದ್ರೆ ಸಮಾಜ ಉಳಿಯೋದು ಹೆಂಗೆ? ನಾಳೆ ಬರೀ ಸೂಟ್ ಕೇಸ್ ಇದ್ದವ್ರಿಗೆ ಅಷ್ಟೇ ಜಾಬ್ ಸಿಗಂಗಿದ್ರೆ ಉಳ್ದೋರ್ ಗತಿ ಏನು? ಉಳ್ದೋರ್ ಗತಿ ಏನು? ಅಟ್ಲೀಸ್ಟ್ ಒಂದು 50% ಜನರಿಗಾದ್ರೂ ಏನಾದ್ರು ಒಂದು ಉಪಯೋಗ ಆಗ್ಬೇಕಾ? 50% ಜನರಿಗಾದ್ರೂ ಜಾಬ್ ಸಿಗ್ತದಪ್ಪ ಅಂತಾರ ಅನ್ಸ್ಬೇಕಲ್ಲ.
ಖಂಡಿತ.
ಇದನ್ನೆಲ್ಲ ಕಣ್ ಮುಂದೆ ಇಟ್ಕೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಹೇಳಿ, ನಿಮ್ಗೆ ಯಾರ್ಯಾರಿಗೆ ಇದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಜನರೆಲ್ಲ ನೋಡ್ಲಿದ್ನೆಲ್ಲ ನಿಮ್ ಪೇಪರ್ಸ್ ಎಲ್ಲ ನಾವು ಇದು ಕಿಡಿತೇವೆ ನೆಕ್ಸ್ಟ್ ಎಲ್ಲ. ರಿಯಲಿ
ಹೌದು,
ನಾವು ಸಾಕಾಗೇವಿ.
ಆಗ್ಲಿ, ಖಂಡಿತ
ನಾವು ಸಾಕಾಗೇವಿ. ನಮಗೆ ಹೊಟ್ಟೆ ಉರಿತದೆ. ವಿ ಟೆಲ್ ಯು ಟ್ರುತ್, ವಿ ಆರ್ ಟೆಲ್ಲಿಂಗ್ ಯು. ಇಂಥ ದೇಶ ಕಟ್ಟಕೊಂಡಂಗಿದ್ರೆ ಯಾಕೆ ನಾವು ಸ್ವಾತಂತ್ರ್ಯ ನಮ್ಗೆ ಎದಕ್ ಬೇಕಿ? ಇಷ್ಟು ಹೊಲ್ಸಾಗಂಗಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ತಗೊಂಡು? ಹಂಗಾಗಿ ಸಮಥಿಂಗ್ ಯು ಹ್ಯಾವ್ ಟು ಡೂ. ಏನಪ್ಪ ಒಂದೇನೋ ಮಾರ್ಜಿನಲಿ ಯಾರೋ ಏನೋ ಒಂದು ಸ್ವಲ್ಪ ಹೆಚ್ಚು ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಎಲ್ಲ ಆಕ್ಷನ್ ಆಗಂಗಿದ್ರೆ ಎಲ್ಲ ಪೋಸ್ಟ್ಗಳು ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಹಾಕ್ಬೇಕು.
24-13 ಆಗೋಯ್ತು. 11 ಜನ ಮಾತ್ರ ಯಾಕೆಂದ್ರೆ they are not able to reach that.
ಹೇಳಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್
report.
ಹೇಳಿ.
11 ಜನ.
Please ask your advocate general to come. We'll revert in a couple of seconds. Okay.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಮುಂದಿನ ಗುರುವಾರ ಕೊಡಲ್ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ಮತ್ತೆ ಇರುವುದಿಲ್ಲ.
Yes.
For the petitioner, my lords.
Yes.
Before I address my
Ah.
submission, my lords, there's a caveat that this honorable, I have challenged the inquiry, initiation of inquiry and the charge memo,
Ah.
which was rejected. This court had not given me an interim order.
Yes.
The inquiry proceeded, my lords. I don't have instructions on what the
Inquiry
inquiry
is completed. Government order has also been received. I have asked for a copy of the government order, whether it is exoneration or penalty. I will get that information, but let's have it next week if it is not. Because
ಇಷ್ಟೇ ಇನ್ಫಾರ್ಮೇಶನ್
ಅಷ್ಟೇ.
ಮಧ್ಯಂತರಿಸಿ
ಅಲ್ಲ ಅದು ಅಲ್ಲಿ ಓಪನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Okay. ಕಾಲ್
It comes in sealed cover.
next week.
Great.
next week, Thursday, next Thursday,
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ರಜೆ ಅಲ್ಲ
Friday. Sorry,
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Much okay.
ಎಸ್ ಏನಿದೆ
But they have challenged they have sought equivalence in respect of the qualifications they possess with the qualification prescribed for recruitment to the post of graduate primary school teachers. The tribunal, relying on an earlier decision, has rejected the applications.
equal power to grant equivalencies with whom?
Equivalent, they want the subject which they have studied to be treated as equivalent to the
No, that decision to be taken, Supreme Court
By the-
said what?
by the government.
By government itself,
There should be a notification, my lord, as per the
for equivalence notification.
please, equivalence notification.
ಪಾಸ್ ಓವರ್ ಅವ್ರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ, ಫೋನ್ ನಂಬರ್ ಏನೋ ಇರ್ಬೇಕು ನೋಡಿ, ಫೋನ್ ಮಾಡಿ ಬರಕ್ಕೆ ಹೇಳಿ. ಎಸ್
For the second respondent, my
Ah.
request, my lord, matter may kindly be taken up on Monday, my lord.
ಯು ಆರ್ ನಾಟ್ ಪ್ರಿಪೇರ್ಡ್ ನೌ.
Engage the services.
Monday, I know issue Monday ಅಂತ ಡೇಟ್ ಕೊಟ್ರೆ ನೋಡಿ, there is one more matter connected to this writ petition.
ಮಂಡೇ ಸಿಟಿ ಇದು ಮಂಡೇ ಬರಲ್ಲಪ್ಪ, ಟ್ಯಾಕ್ಸ್ ಆಗತ್ತೆ.
Tuesday.
ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ
ಅಲ್ಲ, Friday ಬೇಡ.
ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ ಮಂಡೇ ಯು ಕ್ಯಾನ್ ಹ್ಯಾವ್ ಪ್ಲೀಸ್.
Writ petition number
ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್
4805 of 25.
ಓಕೆ ಬರ್ಕೊಟ್ಬಿಡಿ.
ಪೇಪರ್ ಕೊಡಿ
ಅವ್ರಿಗೆ ಪೇಪರ್ ಕೊಡಮ್ಮ. ಅಲ್ಲಿ KN ಪುಟ್ಟೇಗೌಡ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ 4 ಅಂತ ಇದೆಯಲ್ಲ, ಅಲ್ಲಿ ಪುಟ್ಟೇಗೌಡರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಪುಟ್ಟೇಗೌಡರ ಪರವಾಗಿ BBMP ನ ಅವ್ರದ್ದು ಹೆಸರು ಇನ್ನೊಬ್ರದ್ದು ಸೇರಿಸಿ ಅವ್ರ ಜೊತೆ. ಕುಮಾರ್ ಸಿಂಚನ ಅಲಾಂಗ್ ವಿತ್ ಪುಟ್ಟೇಗೌಡ ಅವ್ರ ಹೆಸರು ಇರ್ಲಿ. ಅವ್ರಿಗೆ ಸಿಂಚನ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು. Yes. Call next week. Week after next. To enable counsel for the petitioner to come and argue. Yes.
My lord, in this,
Yes.
in this draft notification was published, my lord, and objections was called for. Objections was looking into, my lord. Kindly have it, 4 weeks time may be granted, my lord. Because some amendment was sought, in that amendment is under the process of with the finance department, my lord.
No. Yes, Mr.
My
Diva.
case is not on that premises, man. My case is that since 2002 till date, 6 notifications were called for the post of lecturer sculptor in Chamarajendra Kava Institute at Mysore. No recruitment has been done. I am the only scheduled caste PhD holder in the entire state. Kindly peruse, my lord, order page 17. Page 16, page 17, KAT order. Para 2, my lord. Shall I read, my lord? Page 16.
Page 16.
16. Para 2, my lord. The applicant has sought for a writ of mandamus directing respondent 1 to 3 to fill up backlog posts of lecture in sculpture in respondent number 4 college by notifying and making selection for the post on the ground that the applicant has previously filed.
ಅಪಾಯಿಂಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
My lord,
ಯಾಕಂದ್ರೆ ನೀವು ಹಂಗೆ ಇಟ್ಕೊಂಡ್ ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ
draft
ಬಾರ್ ಹಾಕೋತ್ ಹೋಗ್ತೀವಿ.
C&R draft to produce, draft ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. Draft ಮಾಡಿ finalization ಗಿದೆ. Objections was called for. We have received 33 objections, my lord. Objections are under process because some mistake was happened and one in respect of 1-3 ಬದಲಾಗಿ 2-3 ಅಂತೆಲ್ಲ ಇದಾಗಿದೆ. ಅದನ್ನೆಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು. ಕರೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿದೀವಿ. ಇದರಲ್ಲಿ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಅಪ್ರೂವಲ್ ತಗೋಬೇಕಾಗಿದೆ. ಆ ಕಾರಣಕ್ಕೆ ದಯವಿಟ್ಟು 3 weeks, 4 weeks ಟೈಮ್ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್, my lord. In the meanwhile,
ರೂಲ್ಸ್ ಯಾವತ್ತು ಫೈನಲೈಸ್ ಆಗ್ತದೆ?
4 weeks time may be granted, my lord.
Nothing
Date
to
may
do
be
with-
fixed, my lord.
nothing to
Within
do
that,
with
we'll-
They want to.
No,
within
that is
that
nothing to do
we'll
with the
finalize,
subject
my
matter
lord.
of this petition.
Huh?
That is nothing to do with subject matter of this petition.
ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಏನ್ ಪ್ರೇಯರ್ ನಿಮ್ಗೆ?
So, my lord, my prayer is,
Yes.
I will read this entire paragraph.
Okay.
Page 16. The backlog post on the assurance given by respondent number, that is Principal Secretary, Kannada and Culture Information Department, the said previous application was withdrawn. However, even till today, no action is taken to see that the posts are filled up, which action is illegal, arbitrary and unwarranted. It is further contended that the respondents had called all 6 recruitment notifications previously on 3/1/2000, 4/12/2002.
ಯಾಕೆ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ? ಇವೆಲ್ಲ ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸೀಸ್ ಅನ್ನು.
Backlog, my lord, till 25 years, this SC post has not been filled. 20 since 2001, on one pretext or another. In the meanwhile, it is that they are taking the help of KPSC.
Where is our judgment that myself and Justice Varale Saab's judgment? Where is that judgment?
This is the letter communication which I have received, my lord.
ವೈ ಹಂಗ್ರೆ ಯಾವ SC ST ಗೂ ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರಿ, ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿ ನಿಮ್ಗೆ ಸಬ್ಮಿಷನ್ ಆಗ್ತೀವಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, C&R rules.
ಎಷ್ಟು come to page 70?
Yes, my lord.
3/1/2000, 4/12/2002, 9/12/2002, 3/12/2012, 35/2013, 19/6/2014 ಎಲ್ಲರೂ ಏಜ್ ಬಾರ್ ಆಗಿರ್ತಾರೆ ಈಗ. ಅಷ್ಟು ಏಜ್ ಬಾರ್ ಆಗಿರ್ತಾರೆ. ಹಂಗಾದ್ರೆ ನೀವು ಬಹಳ ಡಿಪ್ರೆಸ್ಡ್ ಕ್ಲಾಸಿಗೆ ನಾವು ಅದ್ ಮಾಡ್ತೇವೆ ಇದ್ ಮಾಡ್ತೇವೆ ಅಂತ ಸ್ಟೋರಿ ಹೇಳ್ತಿರಲ್ಲ. ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಹಿಯರ್?
ಆ ಕಾರಣಕ್ಕೆ C&R ರೂಲ್ಸ್ ಫೈನಲೈಸ್
Why all these things happened all these years? What should happen to ಎಲ್ಲರೂ ಏಜ್ ಬಾರ್ ಆಗಿ ಹೋಗ್ತಾರೆ ಈಗ. ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಅವ್ರಿಗೇನ್ ಮಾಡಿದ್ರಿ ನೀವು? Why this matter did not go to the backward commission?
No, it went, even the cabinet committee, subcommittee headed by the social welfare minister passed a resolution to appoint these people.
ಎಷ್ಟು ವೇಕೆನ್ಸೀಸ್ ಈಗ ಅಲ್ಲಿ?
My lord, there are 3 vacancies for in the Department of
ಟೋಟಲ್
Structure.
ವೇಕೆನ್ಸೀಸ್ ಎಷ್ಟಿದೆ?
Total vacancies, my lord. My lord, page 39.
ಆಮೇಲೆ ಯಾಕೆ ಇಷ್ಟು ಸಾರಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿರಿ ನೋಟಿಫಿಕೇಶನ್? Why you cancel these notifications?
C&R ಫೈನಲ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇದ್ ಮಾಡಿದೆ.
Since how long?
My lord,
2000.
kindly grant me 3 weeks time, my lord. We'll come with the finalization of C&R rules, my lord.
Old C&R.
C&R rules. When C&R rules is finalized, the entire problem will be resolved, my lord.
Brother, what Supreme Court said, for appointment, there need not be C&R rules at all. Especially for these kinds of appointments. Why? Why 15 ವರ್ಷ?
20 ವರ್ಷನೇ ಆಗಿದೆ.
20 ವರ್ಷ.
20 ವರ್ಷನೇ ಆಗ್ಬಿಟ್ಟಿದೆ.
20 ವರ್ಷನೇ ಆಗಿದೆ.
20 ವರ್ಷನೇ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಹೌದು. ಯಾಕಾಗಿಲ್ಲ? 25 ವರ್ಷ, 20 ಅಲ್ಲ.
25 ವರ್ಷ.
25 ವರ್ಷ ಆಯ್ತು appointment
2020ರಿಂದ.
ಯಾಕೆ? ಯಾರಾದ್ರೂ ಒಂದ್ ಕಡೆ ಬಿಗಿ ಮಾಡ್ಲೇಬೇಕಲ್ಲ. ಈಗ ನಾವು ಖಾಲಿ ಕೊಡಕ್ ಬರಲ್ಲ. ನಾವು ಏನಾರ ಮಾಡ್ಲೇಬೇಕಾಗ್ತದೆ. ಇದಕ್ಕೆಲ್ಲ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಯಾರು?
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು
C&R ಅದ್ ಬರೋಣಂತೆ.
ಹೌದು.
ಇದೆಲ್ಲ ಆಗಿದೆಯಲ್ಲ, ಇದಕ್ಕೆ ಕಾರಣ ಯಾರು? ನಾವು ಏನು ಹೋಲ್ಡ್ ಮಾಡೇವಿ? ಪಿರಿಯಾಡಿಕಲಿ ವೇಕೆನ್ಸಿಗಳನ್ನ ಫಿಲ್ ಅಪ್ ಮಾಡಬೇಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೇವಿ.
ಹೌದು.
ಯಾವ್ದದು ಜಜ್ಮೆಂಟ್, ಧಾರವಾಡ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ತೆಗೀರಿ. ಅವನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ತೊಗೊಂಬರ್ಬೇಕು ಅವನ್ನೆಲ್ಲ. Where is that judgment?
Annexure R9.
Answer our question. Where is judgment of Honorable Justice Varale and myself and Vijay Kumar Patil, 2 judgments on this? Where is the upgrading? ಅವೆಲ್ಲ ಹಂಗೆ ಬಂದ್ಕೊಂಡು ಏನಾರ ಒಂದು ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡೋಣ? ಅವನ್ನೆಲ್ಲ ಕೊಟ್ಟರೆ ನಾವೇನಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಧಾರವಾಡ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಜಸ್ಟ್ ವಿ ಗೇವ್ ದಟ್ ಇನ್.
Where is your secretary? Manjula N.
She undertook that she will be doing everything. That was in December.
4/12/2020, she has undertaken that within a month, you get that C&R rules approved.
Yes, my lord. C&R rule draft was final.
In the order sheet.
Yes, my lord. Draft was finalized, my lord. Draft was furnished. Draft was, objections was called for, my lord. Mandatory period is there. Objections was called for.
ಗಿಮಿಕ್ ಇರಂಗ್ ಕಾಣ್ತದೆ. ಸಮಥಿಂಗ್ ಹಿಡನ್ ಇದೆ ಇದರಲ್ಲಿ.
Lordship division bench judgment with Justice Varale.
ಕೊಡಿ ಅದೊಂದು. ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ನಂದು ಜಸ್ಟಿಸ್ ವಿಜಯ್ ಕುಮಾರ್ ಜಜ್ಮೆಂಟ್ ತೆಗಿರಿ. ಪಿರಿಯಾಡಿಕಲಿ ಯು ಶುಡ್ ಹೋಲ್ಡ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಅಂತ ಮಾಡೇವ್ ನಾವು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಬಹಳ ಜನರು ಏಜ್ ಬಾರ್ ಆಗಿಬಿಡ್ತಾರೆ.
My lord,
ನಿಮ್ಗೆ ಬೇಕಾದಾಗ ಮಾಡಕ್ ಬರಲ್ಲ. ಮೊದ್ಲು ಹಂಗಿತ್ತಲ್ಲ, ಆಮೇಲೆ ನಾವು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡಿವಿ ಅದನ್ನ. ಎವ್ರಿ ಇಯರ್ ದ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಶುಡ್ ಹ್ಯಾಪನ್.
my lord,
ಟೈಮ್ ಬಾರ್ಡ್ ಆಗ್ತದೆ.
my lord, in R9 dated 16/2/2015, in objection statement, they have furnished a document in which the meeting headed by the social welfare minister has directed me to appoint for my appointment.
2 ಕಾಪೀಸ್ ತಗೊಂಡ್ಬರ್ಬೇಕು ಕೋರ್ಟಿಗೆ. ಒಂದು ಸ್ವಲ್ಪ ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ 8 ವಾರ ಮುಂದೆ ಹಾಕ್ತೇವೆ ಕೇಸನ್ನ. Government being constitutional control is expected to conduct itself as a science to science. The government should rejoice when the citizen secures victory in our state. Further life judgment. When was issues to response to undertake or cost to taken the backlog recruitment drive in all government departments. Brother, this judgment was made in September 2023. Yes, September 2023 ಅಲ್ಲಿ ಇದೆಲ್ಲ ಜನ ಎಲ್ಲ ನೋಡ್ತಾ ಇದಾರ, ನಮ್ಮ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನೋಡ್ತಾ ಇದಾರ. September 2023, we are telling it to the public now. September 2023 ಅಲ್ಲಿ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದೇವೆ ವರಾಳೆ ಸಾಹೇಬ್ರಿದ್ದಾಗ. ಇದು ನಾನು ಎಲ್ಲರೂ ನೋಡ್ಲಿ ಅನ್ನೋದಕ್ಕೆ, ಜನ ಎಲ್ಲ ನೋಡ್ಲಿ ಅನ್ನೋದಕ್ಕೆ ಹೋಲ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ. ಈಗ ಎಲ್ಲ ನೋಡ್ಬೇಕು ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್ ಇನ್ ದ ಗವರ್ಮೆಂಟ್ ಅಂತ. ಬರೀ ಇಲ್ಲಿ ಒಳಗಾಗೋದು ಗೊತ್ತಾಗಲ್ಲ ಹೊರಗಿನವರಿಗೆ. ಅದಕ್ಕೆ ನೋಡ್ರಿ ಇದನ್ನೆಲ್ಲ ಅಷ್ಟು ಜನ ಎಲ್ಲ ನೋಡ್ತಾರ. ಓಕೆ, ಇದನ್ನೆಲ್ಲ ನೋಡ್ಬೇಕು. ಸೆಪ್ಟೆಂಬರ್ 2023 ಅಲ್ಲಿ ಎಲ್ಲಾ ಬ್ಯಾಕ್ಲಾಗ್ ಡ್ರೈವ್ ಅನ್ನು ಮುಗಿಸೋಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದೇವೆ. ಕಾಂಪ್ಲೈನ್ಸ್ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದೇವೆ. ನಾವು ಹಂಗ್ ಮಾಡಿದ್ವಿ, SC/ST ಹಿಂಗ್ ಅನುಕೂಲ ಮಾಡಿದ್ವಿ. ವೇರ್ ಆರ್ ದಿ ಸ್ಟೋರೀಸ್? ವೈ ಆರ್ ಯು ನಾಟ್ ಮೇಕಿಂಗ್ ಅಪಾಯಿಂಟ್? ಈ ಕೇಸ್ ಬಿಟ್ಟು ವೈ ದಿಸ್ ಇಸ್ ಕವರ್ಡ್ ಬೈ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್. ಈಗ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೇವೆ. ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ದಿ ಹೈಕೋರ್ಟ್ ಮಾಡುವಂತ ಆರ್ಡರ್ಗೆ ಬೆಲೆ ಇಲ್ಲ ಸರ್ಕಾರಕ್ಕೆ. ಹೆಂಗೆ ಹಂಗ್ರೆ ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ?
We have draft was finalized.
Give this judgment at least.
No, my lord.
ಮತ್ತೆ ನೋಡ್ಕೋಬೇಕು ಇವೆಲ್ಲ.
ಹೌದು. ಡ್ರಾಫ್ಟ್ ಫೈನಲೈಸ್ ಆದ್ರೆ
Repeat draft. What is this?
ಡ್ರಾಫ್ಟ್ ತಗೊಂಡು ಏನ್ ಮಾಡೋಣ್ರಿ?
Kindly peruse annexure R9, my lord, for a fraction of second. R9 submitted by the state. Page 36 of the objection statement, R9.
ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ದಿ ಹೈಕೋರ್ಟ್ ಆ ಬೆಂಚ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದು, ಅದನ್ನು ಕಂಪ್ಲೈ ಮಾಡಲ್ವಾ? ಏನಾಗಿದೆ ಸರ್ಕಾರಕ್ಕೆ? ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ರಿಯಲಿ ಏನ್ರ ತೊಂದ್ರೆ ಇದೆಯಾ 25 ವರ್ಷದಿಂದ?
ಅದಕ್ಕೆ 3 ವಾರ 4 ವಾರ ಬೇಕಾ?
25 ವರ್ಷ.
25 ವರ್ಷ.
25 years you have not done anything. ಯಾರು ನಿಮ್ಮ DPR ಸೆಕ್ರೆಟರಿ ಯಾರು ಸಂಬಂಧ ಪಡ್ತಾರೆ ಇದಕ್ಕೆಲ್ಲ?
ಡೈರೆಕ್ಟರ್ ಕನ್ನಡ ಅಂಡ್ ಕಲ್ಚರ್, ಚೀಫ್
ಅಪಾಯಿಂಟಿಂಗ್ ಅಥಾರಿಟಿ ಯಾರು?
ಅಪಾಯಿಂಟಿಂಗ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ.
ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಇರಲ್ಲ, ಸೆಕ್ರೆಟರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಯಾವ ಸೆಕ್ರೆಟರಿಯೇಟಿಗೆ ಬರ್ತದೆ ಇದು? ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೆಕ್ರೆಟರಿ ಕನ್ನಡ
ಅಂಡ್ ಕಲ್ಚರ್ ಮೇಲೆ.
ಕನ್ನಡ ಅಂಡ್ ಕಲ್ಚರ್. Ask him to be present at 2:30.
Tomorrow ಮೇಲೆ.
All right.
R9 kindly peruse ಮೇಲೆ.
ಏನ್ ನಾಳೆಗೆ?
R9 is
tomorrow. The principal secretary of Department of Kannada and Culture shall be personally present before the court to explain why for the last 25 years no regular recruitment drive is not undertaken, despite giving an assurance to this court on 4/12/2024. ಅವ್ರಿಗೆ ಬರ್ಲಿಕ್ಕೆ ಹೇಳಿ. Call this matter tomorrow. 2:30 10:30 ಆಗ್ಬೋದು. ಆಮೇಲೆ ಸೆಷನ್ ಇದೆ, ಅದನ್ನೆಲ್ಲ ಏನ್ ಹೇಳಿ ಕೇಳಲ್ಲ ನಾವು. ಹೇಳ್ಬೇಕು ಅವರಿಗೆ.
Petition number 1, my lords, I seek for short pass over, my lords.
You want pass over? All right, pass over.
Monday.
All right.
Paper Monday.
Yes.
Interim order may be kindly.
Interim order to continue till Monday.
One problem here, my lords. Your lordship had passed an interim order on the last occasion. But on the basis of the regeneration of the seniority. Oh, my lord, what has happened? Because of that order, there are other candidates, my lords, who are not parties to this writ petition. Their promotions have also got stalled. So that is something
that happens. Kathe Gowda.
Yes.
Kathe Gowda says that will happen inevitably. Yes.
The lordship could just take this on a priority basis. Not there are impleading applicants also. That's
New impleading applicants, sir?
No, I am the impleading. Mr. Joyce is appearing for the impleading.
You ಬಂದು ಎಲ್ಲರನ್ನು ಹೇರ್ ಮಾಡ್ತೀವಿ. Kathe Gowda ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Monday.
Yes. Yes.
For the respondents.
Yes. Raghavan ಏನೋ ಬರ್ತೀವಿ ಅಂತ ಹೇಳಿ.
He's just on his way. They can start. He's just walking up.
ಬರ್ಲಿ ಬೇಕಾದ್ರೆ ಅವ್ರು ಬಂದ್ಮೇಲೆ ತೊಗೊಂಡ್ರೆ ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ.
In fact, he's just sent us a message saying, ತೊಂದ್ರೆ ಇಲ್ಲ, we don't want to waste the court's time.
ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗಲ್ಲ, ಬೇರೆ ಕೆಲಸ ಇದೆ ನಾವು ಮಾಡ್ತೀವಿ, ನಮ್ಗೇನ್ ತೊಂದ್ರೆ.
ಅಲ್ಲ, ಅವ್ರು ಬರೋದಾದ್ರೆ ಅಲ್ಲಿ ಕಮೆಂಟ್ಸ್ ಅಂದೆ.
ಬೇಡ, ಅವ್ರು ಬಂದಾಗ ಕೇಳ್ಕೊಳ್ಳಿ.
I've just received word that
ಪಾಸ್ ಓವರ್. ಆಲ್ ರೈಟ್. ಅವ್ರು ಬಂದಾಕ್ಷಣ ಕರೆಯೋಣ. 36.
Transfer.
Ah.
Relates to transfer, my lord.
Ah.
Lord, the petitioner is in the care of excise inspector, my lord.
Yes.
Lord, the petitioner was transferred in place of one Arun Prasad on Lord 31 1 2024. The petitioner was transferred in the place of one Arun Prasad, my lord, on 31/1/2024. Lord, that transfer, my lord, is in fact, my lord, for Arun Prasad, it was an election transfer, my lord. Arun Prasad was discharging, he is about to complete his tenure at the present place. But my lord, due to election code of conduct, my lord, he was transferred. And my lord, I was posted there. Lord, I took charge of the post and I was discharging my duty. After election code of conduct is completed, Lord Arun Prasad came back to the post and holding that my transfer is also election transfer. Lord, my transfer was not an election transfer, Lord, it was
in a district election officer versus so and so.
Please.
Division bench say where the officials are sent on deputation to election duty, they are not cases of transfer.
Yes.
Justice Kumar's judgment tell there. Where is that judgment? Sorry, 2012-13 district election officer versus so and so. Take it, ILR so and so. This transfer deputation is under section 28A of Representation of People Act.
Yes, sir.
That is not treated as a transfer. That
Yes,
should
sir.
not be treated as a transfer and hold ಮಾಡಿದ್ದಾರೆ.
Please, Lord.
2013.
Volume 6, KJ, Lord,
Huh.
Lord, he went to Supreme Court also.
It affirmed there. It is affirmed.
Yes, my lord. How we come back again to the same place?
No, no. My, now, my lord,
That's all the question.
that Arun Prasad is not before this honorable court, my lord. Another person, my lord, by name, third respondent, approached the tribunal, my lord, challenging the order dated, my lord, 24/10/2024.
ನಿಮ್ retention period ಏನು?
Lord, minimum period is 2 years, my lord.
ಆಗಿದೆಯಾ?
4 years, my lord.
4 years.
4 years.
Yes, my lord.
ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಆಗಿಲ್ಲ.
ಇಲ್ಲ. What has happened, my lord, is I was transferred in the place of Arun Prasad on 31/1/2024, and Arun Prasad was transferred due to code of conduct, my lord. My lord, the
ಕೋಡ್ ಆಫ್ ಕಾಂಡಕ್ಟ್ ನಿಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆದಾಗ ಆ ಪೀರಿಯಡ್ ನೀವು ಇದ್ದೀರಿ ಅಂತ ತಿಳ್ಕೊ.
particular period, my lord. Yes, my lord.
ನೀವು ಆ ಪೋಸ್ಟಿಗೆ ಯಾವತ್ತು ಬಂದ್ರಿ?
31/1/2024.
31/1/2024.
Lord, Arun Prasad approached this honorable court, my lord, and the tribunal, my lord, and tribunal held that, my lord, he is, my lord, he has not completed tenure. Lord, therefore, he is continued. My lord, I approached this honorable court, and thereafter, my lord, I approached the honorable Supreme Court, my lord, that the order of transfer, my lord, is confirmed, upheld by the honorable Supreme Court, my lord. But the question is, before this honorable court is, on 31/8/2024, my lord, one more order is passed.
31/8/2024. ಏನಂತ?
My lord, posting the third respondent
to,
my lord, the very same post.
BUD24.
Huh?
BUD4.
BUD4.
You know?
But I read the fact. 1/12/23.
1/12.
Was 23. The petitioner was posted as the inspector of excise, case BCL D4, Whitefield.
Petitioner's posting.
Yes, sir.
Okay.
Due to election lot on 31/1/24, petitioner was transferred to BUD lot 4.
31/24. This is section 28A transfer. Deputation.
Yes. Then Arun Prasad, making the petitioner as a party, questioned that order. Court said it's the election transfer, both should go back to the original place.
Correct.
Then, my lord, being agreed by said order, petitioner approached this court, contending that no, it's not election transfer.
All right, ಆಯ್ತು ಅಲ್ಲಿಂದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಯ್ತು, ಕನ್ಫರ್ಮ್ ಆಯ್ತು.
What he cannot achieve, my lord, by this court, By order dated not 23/10/24, he comes to the same place where I am working.
ನಿಮ್ಮ ಪೋಸ್ಟಿಂಗ್ ಯಾವಾಗಾಗಿತ್ತು?
Namdo 31/8/24 ಗೆ.
31/8/24.
That, my lord, order was.
ಏನಿಲ್ಲ ರೀ.
Lord, I'm sorry. Lord, what has happened is, my lord, on 31/8/2024, where the third respondent was posted, my lord. My lord, initially, my lord, on 31/1/24, where I was posted, my lord, that was not a transfer due to election code of conduct. It was a regular transfer which was approved by the Honorable Chief Minister. Lord, that I can point it out, my lords, at Annexure.
ಕರೆಕ್ಟ್ ಇದೆ. ಚೆನ್ನಾಗಿದ್ರೆ ನಾವು ಕೊಟ್ಬಿಟ್ಟು ಯು ನೋ ಅವರ್ ನೇಚರ್. ಕೇಸ್ ಇತ್ತು ಅಂದ್ರೆ ನಾವು ಮಾಡಿ.
I understand, my lord. Annexure A5, page 68.
Dismissed agreeing with the reasoning of the guilt. Yes.
The case, my lord, of transfer without postage.
Yes.
My lord, may kindly peruse, my lord.
You are for respondent.
I am for the respondent, number 3. Annexure A3 may be perused, my lord, in page 52. The second column, my lord, Dvitiya Darji.
How long you have been in that? It says 11 years.
11 years, my lord, admittedly, I am there in that post. In so far as the appellant petitioner is concerned, my lord, he was serving in the post for 12 years.
Apologies.
Lord, may kindly peruse Annexure A3. Ink page, my lord, 53. The petitioner was transferred, my lord,
ಅವ್ರಿಗೆ
page 53.
ಪೋಸ್ಟಿಂಗ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ? What have you done?
My lord. My lord, in this, my lord, kindly see the KT order, my lord. Orders in KT, my lord. Page number 35, my lord. 36, my lord. Further, first and second respondents are directed to continue the applicants in the present place until he completes his minimum tenure of or transfer is necessitated in accordance with law. However, the first and respondents are directed to provide suitable posting to the third respondent within a period of 2 weeks from the date of receipt of this order, my lord. My lord, for this, these are all the places, my lord.
ನೋಡಿ ಯಾವ್ದಾವ್ದು ಬೇಕು ಅಂತ ಕೊಡಿ ಅವ್ರಿಗೆ. ಅವ್ರಿಗೆ ತೋರಿಸಿ, ನಮ್ಗೆ ತೋರಿಸಿರಿ. ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರಿಗೆ ತೋರಿಸಿ.
For me or him?
ಎಷ್ಟು ವರ್ಷ ಇಬ್ರು ನೋಡ್ಬೇಕು. ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೀರಿ ನಿಮ್ ಪೋಸ್ಟ್ ನಲ್ಲಿ? ನೀವ್ ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೀರಿ?
ನಾನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರೋ ಪೋಸ್ಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು. ನಾನು ಈಗ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರೋ ಪೋಸ್ಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು.
First time you are coming.
First time.
Prior to that, my lord, he was there for 12 years.
Therefore you also want to.
I am also there.
That is not in north zone is what I am told.
Choose ಮಾಡಿ, ಯಾವ್ದು ನೋಡಿ ಕೇಳಿ, ಯಾವ್ದು choose ಮಾಡ್ರಿ, ಯಾವ post ಬೇಕು.
Alas, in Bangalore, my lords, I am ready to go anywhere. And I am given to understand, my lord, that there is a vacancy in RT Nagar.
ಪಾಪ ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ನಾವೊಂದು ಗೌರ್ಮೆಂಟ್ ನಾವು ಗೌರ್ಮೆಂಟ್ ಆಗಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಿಮ್ಗೊಂದು ಆಪ್ಷನ್ ಕೊಟ್ಟಾರೆ, ಎಲ್ಲೆಲ್ಲಿಗೆ ಹಾಕ್ಬೋದು ಇವ್ರೆ?
ತುಮಕೂರಲ್ಲಿದೆ,
Problem now is, as per the orders of the KAT, my lord, he has to be transferred. He has to opt for a post. That is the order of the KAT.
We'll change it now. Therefore he is here.
Now, my lord, so far as the posting is concerned, if there is a vacancy in Bangalore, my lord, will kindly exercise discretion, my lord. It is still April. At least till April, till the studies of his kids are over. April, my lord, I am not asking for more time.
ಸ್ವಾಮಿ, ಏಪ್ರಿಲ್ ತನಕ ಅವ್ರ ಏನು ಮಕ್ಕಳೇನೋ ಸ್ಟಡಿ ಮಾಡ್ತಾ ಇದಾರಂತೆ ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಎಲ್ಲರ ಕೊಡಿ. ಅದಾದ್ಮೇಲೆ ಮುಂದೆ ನಿಮ್ಗೆ ಎಲ್ಲಿ ಬೇಕಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ.
Government permission because it is premature. I mean, not in the transfer season. ಬಟ್ ಅವ್ರಿಗೆ ಪೋಸ್ಟಿಂಗ್ ಮಾಡಿದಾಗ ಇವ್ರಿಗೂ ಪೋಸ್ಟಿಂಗ್ ತೋರಿಸ್ಬೇಕಾಗಿತ್ತು. ಹಾಗಾಗಿ ಇದು ಅಲೋ ಆಗಿದೆ KAT ಅಲ್ಲಿ ಅಲೋ ಆಗಿರೋದನ್ನ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿಗೆ ರಾಘವೇಂದ್ರ ಐ ಮೀನ್ ದ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ನಾವು ಪ್ಲೇಸ್ ತೋರಿಸಲೇಬೇಕಾಗಿದೆ. ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ನಾವು ಪ್ಲೇಸ್ ತೋರಿಸ್ತೀವಿ. ಅಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಗವರ್ಮೆಂಟ್ ಕನ್ಕರೆನ್ಸ್ ಅಂಡ್ ಶೇರ್ ಆಫ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಆಸ್ ಫಾರ್ ಆಸ್ ಪಾಸಿಬಲ್ ವಿಲ್ ಟ್ರೈ ಟು ಅಕಾಮಡೇಟ್ ವಿದಿನ್ ದಿ ವೇಕೆನ್ಸೀಸ್. ಈಗ ಒಂದು ವೇಕೆನ್ಸಿ ಒಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
ತುಮಕೂರು ತುಮಕೂರಿಗೆ ತೊಳ್ರಿ.
ಅಲ್ಲ ಮೆಲಾಡ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಟಿಲ್ ಏಪ್ರಿಲ್
ಒಂದ್ ತಾಸಿನ ಜರ್ನಿ.
ಟಿಲ್ ಏಪ್ರಿಲ್
ಹಂಗನ್ನಕ್ಕಾಗಲ್ಲ.
12 years 5 months in Bangalore.
12 years 5 months in Bangalore only.
Bangalore only.
ತೊಡ್ರಿ, ಚೂಸ್ ಮಾಡಿ.
But
ಸುಮ್ಮನೆ ನಾವು ಅಲೋ ಮಾಡಿ
try to give if possible in Bangalore.
ಏನೇನ ಇರ್ತಾವ.
ಬೇರೆಯವರು ವೇಟ್ ಮಾಡ್ತಾರೆ.
ತುಮಕೂರು ಕೊಡಿ, ತುಮಕೂರು
ಒಂದಿದೆ ಸ್ವಾಮಿ ಪ್ಲೇಸ್
ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ,
ತುಮಕೂರು ಕೊಡಿ ನೋಡ್ರಿ. ಮತ್ತೆ ಅದನ್ನ ಅಷ್ಟು ಮಾಡಂಗಿದ್ರೆ ಅಡ್ಡಿಲ್ಲ, ಇಲ್ಲಪ್ಪ ಅಂತಂದ್ರೆ ವಿಲ್ ಗ್ರಾಂಟ್ ರಿಲೀಫ್, ಯು ಮೇ ಸಫರ್. ಇದು ಕನ್ಸೆಷನ್ ವಿ ಆರ್ ಶೋಯಿಂಗ್ ಬಿಕಾಸ್ you said that she has her children are studying in
I am
Bangalore.
given to understand not there's a posting readily available at Atinagar.
You can't be in Bangalore permanently.
Till April, my lord. I am not seeking
You can't,
for
12.5 years you have been here already.
same thing, my lord, applies to the petitioner.
Petition is allowed.
Tumkur, my lord, I am ready.
ತುಮಕೂರಿಗೆ ಹೋಗಂಗಿದ್ರೆ ಮತ್ತೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀವಿ, ಆ ಪ್ರಕಾರ ಕಳಿಸಿ. ಇಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. Both the sides having argued the matter, very graciously agree that the petitioner shall be retained. ಯಾವ ಪೋಸ್ಟ್ ಅಲ್ಲಿಗೆ ನೀವು ರಿಟೇನ್ ಆಗೋದು?
Post in question.
Bangalore. In the place by virtue of transfer order dated 6/11/2024. And that the third respondent herein shall be accommodated in the vacancy available at Tumkur.
Yes,
Tumkur, comma, as is pointed out by the learned government advocate AGA on the instructions of Commissioner
of Public Libraries. Department of Public Library.
Department of
Public Library.
Public Library, personally present before the court.
Designation.
Shri so and so. We appreciate the presence and participation of the Commissioner in these proceedings. First off, in the above circumstances, the impugned order of the administrative tribunal is set aside, and that the government shall give to the arrangement herein above indicated forthwith, and file report of compliance before the Registrar General of the High Court within 2 weeks.
Them release the salary also, my lord, from the past 4 months. No salary has been received because of the transfer.
Salary ಇಲ್ಲ ಕೊಟ್ಟಿರಿ.
Salary ಕೊಟ್ಟಿಲ್ಲ.
Stay order, Swami, stay order ಆಗಿದೆ. Stay order August ಒಳಗಡೆ petitioner in this case has reported for this place because he was absent for 1 week and he had just applied leave and took the stay order. Stay order ಆದ್ಮೇಲೆ he should have come to the HOD and then said stay ಬಂದಿದೆ ನಮ್ಗೆ ಏನಾದ್ರು ಮಾಡ್ಕೊಡಿ, ಅವರು ಅಲ್ಲೇ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Instead of that he kept on.
ಒಂದು representation ಕೊಡಿ.
ಕೊಟ್ಟಾಗಿದೆ ಸರ್.
Petitioner,
It's already given.
the third respondent representation for release of the salary shall be decided by the Commissioner in accordance with law and within.
Because he has not worked, he has admitted in his application stating that I have not worked for 4 months.
ನೋಡಿ ಅದ್ರ ಪ್ರಕಾರ within 4 weeks. Within 4 weeks. ಅಲ್ಲಿ ordered accordingly and petition is disposed of. All. Very good. ಮುಗಿದೆ.
One matter, my lord, that handicaps matter.
ಯಾವ್ದು?
Transfer matter. He has released, he has been place has been given to him, my lord.
You have given the place now.
Place has been given, my lord. The present place which he is working is nobody has been placed, my lord.
in that.
ಅವ್ರಿಗೆ ಪ್ಲೇಸ್ ನಿಮ್ ಕೊಟ್ಟಿದಾರಂತ
Take note.
ಪ್ಲೇಸ್ಮೆಂಟ್ ಈಗ.
Today it was placed before the Honorable Tribunal. They have filed a memo along with posting, my lord.
Yes.
My request is, my lord, I will comply with this order, but till the general transfer period, may I be permitted to continue in the present person? Because I have not completed my tenure, my lords.
ಇವ್ರ
It-
ಟೆನ್ಯೂರ್ ಯಾವಾಗ ಮುಗೀತದೆ?
My lords, as on the date of the order, which was November 2024, my lords, I had not completed my tenure. In the
But
month,
it was given effect in February.
yes, my lords, as on that date I've completed, my submission is, my lords,
Completed.
there are no reasons assigned. I am physically handicapped candidate. I have produced the school fee receipts of my children who are in the vicinity of Pavagada, my lords. Now I'm transferred, this order which is produced, I was going to file a memo in the afternoon, my lords. I'm now transferred to Chintamani, which is 3.5 hours away from my present posting, my lords. Therefore, this is the hardship.
ಮನೆಯವ್ರು ಏನ್
posting,
ಮಾಡ್ತಾರೆ?
my lords.
ವೈಫ್ ಏನ್ ಮಾಡ್ತಾರೆ?
Wife is only at home, my lord. She is not working.
ಹೋಮ್ ಮೇಕರ್.
Yes, my lord. Homemaker.
ಶಿ ಇಸ್ ನಾಟ್ ವರ್ಕಿಂಗ್ ಅಂದ್ರೆ ಏನು ಹೋಮ್ ವರ್ಕ್ ಮಾಡೋದಲ್ಲ ಅನ್ನೋದು.
Allah, in the sense he's not having government duty. my lord. Therefore, my request was, my lord, still the general transfer period, my lord. This is passed in violation of transfer guidelines.
ಹೆಂಗ್ ಟ್ರಾನ್ಸ್ಫರ್ಗೆ ಇಲ್ಲ? ಫೆಬ್ರವರಿಗೆ ಮುಗಿದಿದೆ ಪೀರಿಯಡ್. ನೀವು ಆರ್ಡರ್ ಡೇಟ್ ನೋಡೋದಲ್ಲ, ಯಾವ ಇಫೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ನೋಡ್ಕೊ.
Yes, my lord. No, my lord. The transfer guidelines mandate, if any order is passed beyond the transfer season, which is ending on July 2024, reasons must be assigned for such transfer. And nobody is posted to my place, my lord. And I have stated in my application.
You were given
Yes, my lord.
well in advance the transfer intimation.
My lords, in February.
And only in February that is given effect to.
Yes, my lord. Now I don't have sufficient time also, my lords, to make arrangements. That's why my request is only till the transfer period, till April. I may be continuing. my lords.
ಬರ್ಕೊಳ್ಳಿ. Petitioner is knocking at the doors of writ court for assailing the tribunal's order dated
27th January 25.
27 January 2025.
It's an interim order, my lords.
Interim order
Yes,
dated 27/1/2025. Passed in a pending application number 261/2025, wherein he has laid a challenge to the transfer order dated
15/11/2024.
15/11 or 25/11?
No, my lords, 15/11 and 25/11. I have, the prayer is also there.
15/11/2024 and 25/11/2024.
Yes, ma'am. Yes.
Whereby he has been posted to a place at
No, my lords, I was only transferred out without posting.
whereby he has been transferred without assigning posting.
Yes.
First. Next paragraph. Learned AGA appearing for the respondents, official respondents, has placed on record the OM dated 24/2/2025, whereby petitioner is now given posting at Chintamani, so that he can move from Pavagad, and therefore his grievance as to not giving posting has withered away. First, the order, the said OM reads as under. One memo hike ಕೊಡ್ಬೇಕು, ಹಿಂಗೆಲ್ಲ ಪಾಸ್ ಆನ್ ಮಾಡಬಾರ್ದು. Okay? All right. Next paragraph. Learned counsel for the petitioner submits that his client is a physically handicapped candidate, semicolon. His two children are studying in Pavagad only.
Yes.
Only, semicolon. If in the middle of the academic year, comma, petitioner is shifted to a long away place, comma, much hardship would be caused to him. Semicolon. Therefore, he may be permitted to continue at Pavagad till the end of April 2025. First off, learned AGA opposes the said contention, said the submission, saying that it is the bounden duty of the civil servants to go and report for duty to whichever place they are posted. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are marginally granting relief to the petitioner in the sense that petitioners posting as given wide OM dated 24/2/25 would remain intact. Semicolon. However, the said OM shall be given effective with effect from 1/5/2025. First up, this order we are making in the peculiar circumstances of the case, and therefore this order shall not be construed as having any precedential value. Okay. But ordered accordingly and WP is disposed of. Yes. Yes, Mr. Raghavan. But
Let I go by your lordship's advice that if one judgment covers the entire scenario, there should not be repetition of the judgment.
Correct.
Therefore, my lord, I will take your lordships to
latest
the
one judgment
of the constitution.
What are the facts?
And then, no, I'll come to that. And this is a newly evolved principle by the constitution bench, of course, following the earlier judgment. Then, my lord, then what happens is a subjective assessment whether this principle will apply to the facts of the case. So therefore, my lord, I need your lordship permission to, my lord, just submit regarding the principle which the Supreme Court has promulgated now.
Yes.
And then I will say that
What are
based
the
on
facts
these principles, if they apply to the present case, based on subjective assessment, there is absolutely no case of made out to implicate me in the arbitration proceedings. But kindly similar to Cox and Kings. But I will only read, my lord, 1, 2.
These all facts, foundational facts.
Beda.
Huh?
I'll come to
Please.
the why and the why and the
Judgment.
I'll lay the foundation. Yes. Legal foundation, then I'll.
We can understand. Yes.
I'll only read, my lord, 5 paragraphs. Paragraph 5.1.
The Cox and Kings.
Yes, ma'am. Constitution bench judgment. Page number 33.
33.
Yes. Paragraph number 5.1. These are the questions which are referred to the larger bench. SCC, I think your lordships has.
SCC. Yes. 2024 SCC.
Yes, ma'am.
Page 1.
Yes, ma'am. Page 33 may kindly be seen.
Paragraph 33, na?
No, paragraph 5.1, page number 33. Because paragraph 5 is the.
You're right.
But they refer
In
to
concurring opinion.
Yeah, the opinion of Justice Surekan in fluoro control. That was an international arbitration. Therefore, there was not much a problem. Kindly see, these are the questions. Whether the group of companies doctrine should be read into Section 8 of the Arbitration and Conciliation Act 1996, or whether it can exist in Indian jurisprudence independent of any statutory provision. Whether the group of companies doctrine should continue to be invoked on the basis of principle of single economic reality. Whether the group of companies doctrine should be construed as a means of interpreting implied consent or intent to arbitrate between the parties. Whether the principle of alter ego, that is alternative personality, or piercing the corporate veil can alone justify pressing the group of companies doctrine into operation even in the absence of implied consent. We are not reproducing the factual matrix of the case. So as well. Now kindly similar to paragraph 106 at page number 69. Your lordships are aware that a non-signatory being dragged into arbitration proceedings, that is well established. Now it's a group of companies. Now, the group of companies doctrine was developed by International Arbitration Tribunal specifically in the context of arbitration, and it is not generally used in other areas of law. Although the existence of group of companies is a necessary condition, it is not sufficient condition to determine intention of the parties. In almost all formulations, the courts and tribunals have cautioned that the mere membership of a non-signatory in a group of companies is not enough to bind it in the arbitration agreement. Rather, the courts need to determine first the existence of a group of companies.
That is first essential.
Yes.
That is not sufficient.
That is not sufficient. This is a package deal. Second, conduct of the signatory and non-signatory parties which indicate their common intention to make non-signatory a party to the arbitration proceedings. Thus, the group of companies doctrine is similar to other consent-based doctrines such as agency, assignment, assumption, and guarantee to the extent that it is ordinarily applied as a means of identifying the common intention of the parties to bind the non-signatory to the arbitration agreement. Now, kindly see next, Miller. This is important. The above position was explicitly adopted in ICC tribunal in Dow Chemical, which it held that an arbitration agreement signed by certain companies or corporate group will bind the other non-signatory members only where all the parties intended and understood the non-signatories to be veritable parties to the underlying contract containing the arbitration agreement based on their participation in the conclusion, performance and termination of the contract. Conclusion of the contract, maybe performance of the contract, that is absolutely necessary, and my power, that is the person who is sought to be impleaded, his power to terminate the contract.
Or
all three together.
No.
Performance or termination. Performance, I will stick to performance or termination. Performance or termination. So I should be able to perform or I should be able to terminate the contract. Thus, the existence of group of companies is a factual element. That's why I said subjective word used. The court or tribunal has to consider when analyzing the consent of the parties. It inevitably adds an extra layer of criteria to an exercise which at its core is the predominant on determining the consent of the parties.
Preponderant.
Yes. In the case of complex transactions involving multiple parties and agreements. Now, kindly page 111, page 70. Left-hand side. The group of companies doctrine requires the courts and tribunals to consider commercial circumstances. Page 70, paragraph 111, left-hand side, bottom. 70. Left-hand. The group of companies doctrine requires the courts and tribunals to consider the commercial circumstances and the conduct of the parties to evince the common intention of the parties to arbitrate. It is important to note that the group of companies doctrine only concerns only the parties to arbitration agreement and not underlying commercial contract. Consequently, a non-signatory could be held to be a party to the arbitration agreement without becoming a formal party to the underlying contract. The existence of a group of companies is one of the essential factors to determine whether the conduct amounts to consent, but membership of group of companies is not sufficient in itself. This has been the considered position of law, starting from Dow Chemical Award, where it was observed that the common intention of the parties to bind the non-signatory party to the arbitration can be inferred from the circumstances that surround the conclusion and characteristics, the performance, and later the termination of the contract. In other words, it was held that a non-signatory party could be considered as a true party to the arbitration agreement on the basis of their role in the conclusion, performance, or termination of the underlying contract containing the arbitration agreement. Then 115 at page number 72, left-hand side again. In Discovery Enterprises, heavy reliance was placed even by the learned arbitrator. In Discovery Enterprises, this court refined and clarified the cumulative factor that courts and tribunals should consider in deciding whether a company within group of companies is bound by the arbitration agreement. Number one, 40 Miller. In deciding whether a company within the group of companies which is not a signatory to arbitration proceedings would nonetheless be bound by it. The law considers the following factors. Number one, the
mutual intent of the parties.
mutual consent of the party, the
non-signatory to a
relationship of the
party,
non-signatory party,
which is a signatory to the agreement.
commonality of the subject matter,
Matter,
composite nature of the transactions, and performance of the contract. But for the moment, I request your lordships to mark the last word, how the arbitrators dealt with this word, the performance of the contract. Now, the Constitution bench also uses the word termination, performance or termination. The discovery stops at 5, but the Constitution bench adds one more word, performance or termination. Then I'll read three more paragraph. Since the group of companies doctrine is a consent-based theory, its application depends upon consideration of a variety of factual elements to establish a mutual intention of all the parties involved. In other words, the group of companies doctrine is a means to infer mutual intentions of both signatory and non-signatory parties to be bound by the arbitration agreement. The relationship between among the legal entities within the corporate structure and involvement of the parties in the performance of the underlying contractual obligations or indicators to determine the mutual intentions of the parties. With the permission, I'll again repeat. The relationship between and among the legal entities within the corporate group structure and the involvement of the parties in performance of the underlying contractual obligations or indicators to determine the mutual intention of the parties. The other factors, such as commonality of the subject matter, composite nature of the transactions, and the performance of the contract ought to be cumulatively considered and analyzed by courts and tribunals to identify the intention of the parties to bind the non-signatory party to the arbitration agreement. The party seeking joinder of the non-signatory bears the burden of proof of satisfying the above factors to the satisfaction of the court or tribunal as the case may be. Then paragraph 127 at page 76, threshold standard. 127. In Cox and Kings, Justice Suryakant observed that Reckitt fixed a higher threshold of evidence for the application of group of companies doctrine as compared to the earlier decisions of this court. This court in Reckitt benches is indicative of the fact that the mere presence of group of companies is not the sole criteria or determinate factor to bind a non-signatory to an arbitration agreement. Rather, the courts or tribunals should closely evaluate overall conduct and involvement of the non-signatory in the performance of the contract. The nature or standard of involvement of the non-signatory, the performance of the contract should be such that the non-signatory has actively assumed the obligations or performance upon itself under the contract. In other words, the test to determine whether a non-signatory has a positive, direct and substantial involvement in the negotiation, performance or termination of the contract. Mere incidental involvement in the negotiation or performance of the contract, even then, is not sufficient to infer the consent of the non-signatory to be bound by the underlying contract or its arbitration agreement. The burden is on the party seeking joinder of the non-signatory to the arbitration agreement to prove a conscious and deliberate conduct of involvement of the non-signatory based on objective evidence. Paragraph 170 straight away at page 90, conclusions. Conclusion. In view of the discussed above, we arrive at the following conclusion. The definition of parties in section 2(1)H, read with section 7 of the Arbitration and Conciliation Act 1996, includes both signatory as well as the non-signatory. Conduct of the non-signatory parties could be an indicator of their consent to be bound by the arbitration agreement. The requirement of a written arbitration agreement under section 7 does not exclude the possibility of binding non-signatory. Under the Arbitration Act, the concept of a party is distinct and different from the concept of persons claiming through or under a party to the arbitration agreement. The underlying basis for the application of the group of companies doctrine rests on the maintaining the corporate separateness of the group of companies while determining the common intention of the parties to bind the non-signatory party to the arbitration agreement. The principle of alter ego or piercing the corporate veil cannot be the basis for the application of group of companies doctrine. The group of companies doctrine has an independent existence as a principle of law which stems from an harmonious reading of section 2(1)H along with section 7. To apply the group of companies doctrine, the courts or tribunals, as the case may be, have to consider all the cumulative factors laid down in ONGC versus Discovery Enterprises, resultantly, the principle of single economic unit cannot be the sole basis for invoking the group of companies doctrine. The persons claiming through the under can only assert a right in the derivative capacity. The approach of this court in Chloro controls to the extent that it traced the group of companies doctrine to the phrase claiming through or under is erroneous and against the well-established principles of contract law and corporate law. The group of companies doctrine should be determined in the Indian arbitration jurisprudence, considering the utility in determining the intention of the parties to the extent of complex transactions involving multiple parties and multiple agreements. Lord Justice Narasimha also adds, my Lord, of course, his lordships agrees with this. Therefore, my Lord, it's a premium judgment. But I will now take your lordships to the document.
Concurring judgment.
Yes, ma'am, concurring judgment.
Page.
The same page. That is next page, 92. Paragraph 230, conclusion. In view of the above, while considering the judgment of the Chief Justice, my conclusions are as follows. An agreement to refer disputes to arbitration proceeding must be in written form. Lordship got it?
Yes. You were reading paragraph 172 in the begin madiddu.
172, my lord. Yes, ma'am. I shall read that. The reference to this constitution bench for an authoritative determination of the applicability of group of companies doctrine to proceedings under the act, and if found to be applicable and statutorily anchored to delineate its precise contours. In the reference, Justice N.V. Ramana, Chief Justice, highlighted the variations in the exposition and application of the doctrine as it evolved in India. He questioned the statutory source of the doctrine in the phrase claiming through or under, which appears in section 8 and 45 of the Act. He also cautioned that maintaining the separate legal identities of members within the same group of companies is a fundamental principle of corporate and contract law. In this light, specific questions formulated and referred to in this constitution bench. So, whether the phrase claiming through or under in section 8 and 11 could be interpreted to include group of companies, whether group of companies doctrine as expounded by Chloro controls and subsequent judgments are valid in law. Justice Suryakant concurred with Chief Justice Ramana and supplemented his reasons for the reference. At the outset, he emphasized the need to retain the doctrine in India to keep pace with the complexity of multi-party business transactions, where certain persons do not formally sign the contract but are involved in the negotiation and performance, especially India with large number of family-run business groups. He expressed that inclusion of a non-signatory company is essential for effective and complete dispute resolution through arbitration. However, he also indicated the need to iron out inconsistencies in the formulation of the doctrine. He questioned the reliance on equity considerations and single economic reality to determine non-signatories to be parties, as these undermine well-entrenched principles of party autonomy and separate legal entity. In this light, for an authoritative determination of the contours of the doctrine, he framed the following questions. But questions are...
Come to 177.
I shall do that. 177. Yes, Miller. It is evident from the above said statutory prescription that an arbitration agreement is described in 7.1 as an agreement by the parties. Both these expressions, agreement and parties, are important for our consideration. For a proper understanding of these expressions, it is necessary to examine the place of arbitration as a dispute redressal mechanism in the larger body of institutional remedies in civil law. Then civil remedy and arbitration. Then 7, arbitration agreement is a contract. Section 7(4)(b).
What is the extra reasoning given by learned judge?
The
learned judge says, I want to supplement the reasoning of the Honorable Chief Justice. What is that reasoning?
This lordships refer to the international perspective. This is one thing I found. Paragraph page 101.
101.
How the doctrine evolved outside India. I'm in complete agreement. 101, page 101, para
Companies,
190, my lord.
Group of companies doctrine.
187.
187.
187. That can be answered.
This principle,
Been consistently applied by the courts to
court determine whether a non-signatory is a party to arbitration proceeding in accordance with section so and so. Our courts and tribunals have sufficiently developed the interpretive tools to determine the intention of the parties to refer disputes to arbitration by construing the express language. It has also been held that once the terms of the contract show there is an intention to refer disputes to arbitration, parties cannot wriggle out of the arbitration agreement. But what's his lordship? I'm sorry.
Answer to your lordship question, what is additional reason? His lordship also approached it from the point of view of section 7(4)(b), which was not there in the
earlier.
the opinion of the Honorable Chief Justice. His lordship said, let me look at it from the point of view of 7(4)(b) also, and then said, who is a party? When is there an arbitration agreement? And then came to the same conclusion as my lord, the Honorable Chief Justice.
Because the expression is agreement by parties.
Exactly.
Lord, I was coming to that.
Exactly.
That reasoning is that.
the answer. What is the additional reason, my lord? I thought that this was what I could discern.
But that is at 225. I was coming to that. Paragraph 225. 225.
Can we reassemble after?
Yes, I shall do. I'm sorry.
Report over object ಮಾಡ್ಕೊಳ್ಳಿ. That's it. Report then maybe, but why do you rely upon that? P50 inside your pocket. I tell you. I'll copy ಕೊಡಿ. ಕೊಡ್ಲಿಲ್ಲ ಕೇಳಿದ್ರು ಕೊಡಲ್ಲ ಅಂತಾರ ಬಟ್ ಡೈರಿ ಇಲ್ಲ ಹಾಕೊಂಡೆ ಏನು ಬೇಡ ಕಮಿಟಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಗೌರ್ಮೆಂಟ್ ಎಲ್ಲ I understand the first case. I have files. I have. ಹೊಸ ಸೇರಿ ಇದು ಹೊಸ ಸೇರಿ ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ ನನಗೆ ಗೊತ್ತಿದೆ ಬೇಡವಾ ನೀವು ನಾ ಹೆಂಗ್ ಮಾಡ್ತೀನಿ ಹೇಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ಬಂದಿದ್ದೆ ಮಿಡಿದ್ರೆ ಬೇರೆ ಆಗ್ತದೆ ಏನಿದು ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಇರ್ತೀರಲ್ಲ ಇನ್ಸಿಡೆಂಟ್ ಬಂದಿರ್ತೀವಿ
Yes, Mr. Advocate General, thank you for coming here. Yes.
Went through the same, my lord. In fact, my lords, on the larger scale, my lords, in fact, yesterday's cabinet and today's cabinet, my lord, decisions are being made to overhaul the Public Service Commission itself, my lords. Insofar as its member constitution, power, the decision-making process, how the whole number of members to be there, interviews to be conducted on deputation, because all of them are on permanent basis, my lords. over there. In fact, the draft rules also are being prepared. In fact, most of them are being on circulation. Manoj. When it was being circulated, all the information used to go get leaked. Manoj. And prior permission of the commission was sought to be taken for any decision to be taken. So we are tinkering with the act, then coming up with comprehensive rules also. Rules are insofar as this Public Service Commission is concerned. Manoj. I've gone through the facts, Manoj. It's sorry state of, affair, Manoj.
What should be done? At least on the 50% ಆದ್ರೂ ಯಾವುದೇ ಅಮಿಷಕ್ಕೆ ಒಡ್ಡಾಗದಂಗೆ ಅಪಾಯಿಂಟ್ ಆಗ್ಬೇಕಲ್ಲ. ಇನ್ನು 50% ಏನಾದ್ರೆ
Correct. Therefore, Manoj, out of 24, Manoj, let what is finding is only with regard to 10, Manoj. Insofar as those 14, let them continue, Manoj. Your Lordship may direct us to complete the inquiry within a limited period, Manoj.
all that we'll do.
Please, Manoj.
But when the subcommittee comprising of 3 members was constituted,
Please, Manoj.
after holding 4 consecutive meetings,
Please, Manoj.
and after information was received from the secretary concerned.
Correct. 22nd February, Manoj.
Correct. On 24th
June 2024.
24, why the KPSC finalized the list? Still inquiry is going on.
Correct.
3-member committee is looking into. Why government did not ask, why did you send this before inquiry is completed?
Correct. That's the question here. What is the 3-member committee, Manoj, were disbanded on 4th March 2024. Subsequently, a 5-member committee was constituted.
Then it is a larger reason why government did not send it back, saying that the matter is being investigated into by 5-member committee. Very fact that from 3 to 5 we have moved indicates the seriousness. At least ಒಂದು 100 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗೋದಿದ್ರೆ ಒಂದು 25-30 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದ್ರೂ ಏನು ಅಮಿಷ ಇಲ್ಲದಂಗ ಆಗ್ಬೇಕಲ್ಲ. 25%.
In fact, one of the
25 and 24.
They have less. Let's set the better of the. Your Lordship may kindly. I'll not come to the petition sequence of events, Manoj. Your Lordship may kindly see appointment notification is given on 25th June.
Correct.
They approached this court on 10th February.
ಅವ್ರು ಬಿಡಿ.
That's why I don't want to go into. I understand where we are, Manoj. My house in order. I have to get my house in order.
But we want to tell you one thing. The Constituent Assembly debates relating to grant of constitutional status to the state public service commissions and central public service commission.
Please.
How that was under the Government of India Act 1935, Government of India Act 1990.
Please.
How they were. Why Baba Sahib made all this change? Just see the.
I'll go through that.
Yeah. What is the object?
So
We
independent
wanted to have robust executive. Robust executive we wanted to have, who will not budge to political pressure, who will not budge to such other pressures. ಆ ರೀತಿ ಇದ್ದಂಥ ನಾವು ಬೇಕು ಅನ್ನೋದಕ್ಕೆ ನಾವು ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡ್ವಿ.
Correct.
At least ಒಂದು 100 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಒಂದು 50 ಬೇಡಪ್ಪ, ಒಂದು 30 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದ್ರೂ ಜನರಿಗೆ ಅನ್ಸ್ಬೇಕಲ್ಲ. ಇಲ್ಲಿಲ್ಲ ಒಂದು 70% ನಲ್ಲಿ ಏನೋ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗ್ತದೆ, ಇನ್ನು 30% ಸರಿ ಆಗ್ತದೆ ಅನ್ನುವಂಥದ್ದು ಒಂದು ಫೀಲಿಂಗ್ ಬರ್ಬೇಕಲ್ಲ. ಯಾವ ಕ್ಯಾಂಡಿಡೇಟಿಗೆ ಬರ್ತದೆ? ಆಮೇಲೆ ಹಿಂಗೆಲ್ಲ ಅನ್ಸ್ಬಿಟ್ರೆ ಯಾವ ಒಳ್ಳೊಳ್ಳೆ ಕ್ಯಾಂಡಿಡೇಟ್ ಈ ದೇಶದಲ್ಲಿ ಉಳಿತಾರೆ? ಅವ್ರು ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾರೆ. ನೋಡಿ, ಎಲ್ಲೆಲ್ಲಿ ಮೆರಿಟ್ ವಿಜೃಂಭಿಸಿದೆ ಅಲ್ಲೆಲ್ಲ ದೇಶಕ್ಕೆ ಉಪಯೋಗ ಆಗಿದೆ. ಅಂಬೇಡ್ಕರ್ ಜಿ ಮೆರಿಟೋರಿಯಸ್ ಇದ್ರು, ಒಳ್ಳೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಒಬ್ಬ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಇದ್ದದ್ದಕ್ಕೆ ಲಕ್ಷ ಎಕರೆ ಇರಿಗೇಷನ್ ಆಯ್ತು, ಡ್ಯಾಮ್ಗಳು ತಯಾರಾದವು, ಐರನ್ ಸ್ಟೀಲ್ ಫ್ಯಾಕ್ಟರಿ ಆಯ್ತು, ಸೆಂಚುರಿ ಕ್ಲಬ್ ಆಯ್ತು, ಮೈಸೂರು ಬ್ಯಾಂಕ್ ಆಯ್ತು, ಇರಿಗೇಷನ್ ಫೆಸಿಲಿಟೀಸ್ ಆಯ್ತು, ಹೆಲ್ತ್ ಫೆಸಿಲಿಟೀಸ್ ಆಯ್ತು. ಒಂದು ಬ್ರೈನ್, ಒಂದು ಸಿಂಗಲ್ ಬ್ರೈನ್ ಇಂಡಿವಿಜುವಲ್. ಆ ರೀತಿ ಒಬ್ಬ ಕೆಂಪೇಗೌಡ ಇದನ್ನ ಬಿಲ್ಡ್ ಮಾಡಿದ್ದು ಬೆಂಗಳೂರನ್ನ. ಒಂದು ಬ್ರೈನ್ ವಿತ್ ಗುಡ್ ಹಾರ್ಟ್. ಎಲ್ಲ ನೀವು ಗಟ್ ಜನರನ್ನು ಅಷ್ಟು ಎಲ್ಲ ಕೊಳಚೆ ನೀರು ಅಷ್ಟು ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ರೆ ಮುಂದೆ ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ಜನರ ಗತಿ ಏನು? ಕಾಮನ್ ಮ್ಯಾನ್ ಅವ್ರನ್ನ ಅಪ್ರೋಚ್ ಮಾಡಿದ ಕೆಲಸ ಆಗೋದು ಹೆಂಗೆ?
In fact, yesterday's cabinet meeting, what your lordships were saying, same was discussed today also it is, in fact, my lords, I happened to be there, my lords. This is what the feeling of the whole thing was.
ಇಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ಗೆ ಹೊರಗೆಲ್ಲ
As you law confidence,
ಸ್ವಲ್ಪ ನೀವು ಸ್ವಲ್ಪ ಮಾರ್ನಿಂಗ್ ವಾಕ್ ಮಾಡಿ, ಸ್ವಲ್ಪ ಪಾರ್ಕ್ ನಲ್ಲಿ ಮಾರ್ನಿಂಗ್ ವಾಕಿಂಗ್ ಮಾಡಿ. ಜನ ಏನ್ ಮಾತಾಡ್ತಾರೆ ಗೌರ್ಮೆಂಟ್ ಬಗ್ಗೆ, ಕೋರ್ಟ್ ಬಗ್ಗೆ, ಲಾಯರ್ಸ್ ಬಗ್ಗೆ ಅಂದ್ರೆ ಆ ಮಾರ್ನಿಂಗು ಒಂದ್ ಸ್ವಲ್ಪ ಸತ್ಯ ಮಾತಾಡ್ತಿರ್ತಾರೆ. ಇನ್ನು ಮನಸ್ಸು
ಕೆಲ್ಸಕ್ಕೆ ಹೋಗೋದ್ಕಿಂತ ಕೆಲ್ಸಕ್ಕೆ ಶುರು ಆದ್ಮೇಲೆ ಅವ್ರು
ಅಟ್ಲೀಸ್ಟ್ ಒಳ್ಳೊಳ್ಳೆರಲ್ಲ. ಈಗ ಒಬ್ಬ ಬಾಳೆ ಕುಂದ್ರಿ ಇರೋದಕ್ಕೆ ನಮ್ಗೆ ಎಷ್ಟು ರಿವರ್ ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಲ್ಲಿ ಎಷ್ಟು ಇನ್ಪುಟ್ ನಮಗೆ. ಹಾ, ಈಗ ಆ ರೀತಿ ಬರಂಗಿದ್ರೆ ಕೆಲ್ಸ ಆಗ್ತದೆ, ದೇಶ ಉಳಿತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನೂರಕ್ಕೆ 100 ವ್ಯವಹಾರ ಆಗ್ತದೆ ಅನ್ನೋ ಫೀಲಿಂಗ್ ಇದ್ಬಿಟ್ರೆ ಕಾಮನ್ ಮ್ಯಾನ್ಗೆ ಯಾಕೆ ಓದ್ಬೇಕು ನಾವು?
That is all being changed, my lords. Your lordship, in fact, is going to be placed this time, my lords. The number of members in the highest in India is in Karnataka, 10+1, more than UPSC, my lords. All, and interview also we are cutting short. We're getting only experts, my lords. All that is being sought to be done, so that external experts who are subject experts, all that. In fact, I'll place it today after that thing. On next date of hearing, I'll place all the amendments to your lordships, my lords.
ಅಲ್ಲ, ಬರೀ ಎಕ್ಸ್ಪರ್ಟ್ ನಮ್ಗೆ ಎಷ್ಟೋ ಸಾರಿ ಈ ಇಂಟೆಲಿಜೆಂಟ್ ಕ್ಲಾಸ್ ನಿಂದನ ಸಮಸ್ಯೆ ಆಗ್ಬಿಟ್ಟದೆ. ಹೌದು, ಈ ಇಂಟೆಲೆಕ್ಚುವಲ್ ಪವರ್ ಅನ್ನ ಪೊಲ್ಯೂಟ್ ಆಗೋ ಪ್ರೊಸೆಸ್ ನಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
We have to trust.
ಅದನ್ನ ನಾವು ಏನಾರ ಮಾಡ್ಲೇಬೇಕು. ಈಗ
Good people, my lords.
good people even with bad ideas will work wonderful.
That is true. Intent.
ನೀವು ಬಹಳ ಬ್ರಿಲಿಯಂಟ್
ಜಾಸ್ತಿ
ಬಂದ್ರೆ ಬಹಳ ಸುಂದರವಾಗಿ ಮರ್ಡರ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ ಅವರು. ನಮ್ಗೆ ಅಷ್ಟು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ಈಗ ನೋಡಿ ಎಲ್ಲಾ ಕಡೆ, ಬಿಕಾಸ್ ಐ ಗೋ ಆನ್ ಕೀಪಿಂಗ್ ಐ ಗೋ ಟು ಮೆನಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್, ಅಲ್ಲಿಗೆಲ್ಲ ಸ್ಪೀಚ್ ಗೀಚಿಗೆ ಹೋದಾಗ ನನ್ಗೆ ಸ್ಟೂಡೆಂಟ್ಸ್ ಎಲ್ಲಾರು ಅಥವಾ ಆಡಿಯನ್ಸ್ ಅವ್ರ ಪ್ರಶ್ನೆ ಕೇಳುವಾಗ ಬಹಳ ಮುಜುಗರ ಆಗ್ತದೆ, ತುಂಬಾ ಮುಜುಗರ ಆಗ್ತದೆ. ನಾವ್ ಹೆಚ್ಚಿಗೆ ಹೇಳಿಕ್ ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಪಬ್ಲಿಕ್ ಎಲ್ಲ ನೋಡ್ತಿರ್ತಾರೆ. ಹೌದಾ? ಅಲ್ಲಿ ನಿಮ್ಗೂ ಸಮಸ್ಯೆ ಇದೆ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಆದ್ರೆ ನೀವು ಮನಸ್ಸು ಮಾಡಿದ್ರೆ ಏನ್ ಬೇಕಾದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ. ನಾವ್ ಹೆಸರು ಹೇಳಲ್ಲ. ಕೆಲವು ರಾಜ್ಯಗಳಲ್ಲಿ ನಾವ್ ಹೆಸರು ಹೇಳೋ ಅಗತ್ಯ ಇಲ್ಲ. ಕೆಲವು ರಾಜ್ಯಗಳಲ್ಲಿ 4 ಲಕ್ಷ ಕೋಟಿ ಇನ್ಕಮ್ ಅನ್ನು ಜನರೇಟ್ ಮಾಡ್ತಾರೆ. ಹೌದಾ? 2,55,000 ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಜನರೇಷನ್ ಆಗ್ತದೆ. ಹೆಸರು ಹೇಳಲ್ಲ ನಾವು, ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಏನೋ ಬಣ್ಣ ಹಚ್ಚೋದು ಬೇಡ ಅನ್ನೋದಕ್ಕೆ. ಇವೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. ಹೌದಾ? 2,55,000 ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಜನರೇಟ್ ಆಗ್ತದೆ. ನಮ್ಮಲ್ಲಿ ಯಾಕೆ ಆಗ್ತಾ ಇಲ್ಲ? ಎಷ್ಟು ಡ್ಯಾಮ್ಸ್ ಇದಾವ, ನಮ್ಮ ಎಷ್ಟೊಂದು ರಿವರ್ಸ್ ಇದಾವೆ. ನಮ್ಮಲ್ಲಿರುವಂಥವು ಇಲ್ಲೇ ಇಲ್ಲ. ನಾವು ಅವ್ರನ್ನ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡ್ಕೋತ ಹೊಂಟ್ರೆ ಇಲ್ಲಿ ಉದ್ಧಾರ ಆಗೋದು ಯಾವಾಗ?
Highest number of education institutions.
ಅಲ್ಲಿ ಯಾಕೆ ಆಗ್ತದೆ, ಇಲ್ಲಿ ಯಾಕೆ ಆಗಲ್ಲ? ಎಲ್ಲ ಮೆಡಿಕಲ್ ಕಾಲೇಜಸ್, ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜಸ್, ಎಲ್ಲ ಫಾರ್ಮಸಿಗಳು ಅಷ್ಟು ಇಲ್ಲಿದಾವೆ.
Talent is also here only.
Natural resource ಸಿಕ್ಕಾಪಟ್ಟೆ ಇದೆಯಲ್ಲ,
ತುಂಬಾ ಇದೆ, ಸಿಕ್ಕಾಪಟ್ಟೆ.
Karnataka is
highest. In fact, the rest of the country have followed Karnataka.
ಮತ್ತೆ ಯಾಕೆ
all the TMA, PI, Inamdar, Islamic, all from Karnataka.
ಅಷ್ಟು ಇಲ್ಲಿಂದ ಎಲ್ಲ ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್
ಇಲ್ಲಿಂದಾನೆ ಎಲ್ಲ ಕರ್ನಾಟಕ,
ಇನ್ಕ್ಲೂಡಿಂಗ್ ಕೇಶವಾನಂದ is just beside ಕರ್ನಾಟಕ.
Neighboring almost.
ಯಾಕೆ ನಮ್ಮ ಸ್ಟೇಟ್ ನಾಗ ಯಾಕೆ ಹಿಂಗ ಆಗ್ತಾ ಇದೆ? ಇದು ದಿಸ್ ಇಸ್ ಎ ಫಸ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದು ನಮ್ ಒಳ್ಳೆ ಆಫೀಸರ್ಸ್ ಬೇಕು.
Most important.
This is what Jawaharlal Nehru wrote in his first autobiography, which he published in 1930s. He said, Indian civil service is neither Indian nor service. Same thing will happen if bad people are appointed, ignoring men of integrity. Merit, all right, we can understand. Anyway, we are not much bothered about merit. Somehow we will understand that. What about the integrity? Integrity ಇಲ್ದಂಗೆ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು? ಮೆರಿಟ್ ಅನ್ನು ಲೂಸ್ ಮಾಡಿಕೊಂಡ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇಂಟಿಗ್ರಿಟಿಯಲ್ಲಿ ನೀವು ರಿಬೇಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿಲ್ಲ. All those judgments, they said merit is not the only mantra. We can understand it cannot be the only mantra, but is there one single decision which says even if integrity is not there,
That's well.
Go for that ಅಂತ ಹೇಳಿದಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್.
ಕಂಡೀಷನ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಹೇಳ್ಬೋದು.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀವಿ? ವಾಟ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡು? ಅದನ್ನ ಬೇರೆ ರೂಲ್ಸ್ ಚೇಂಜ್ ಮಾಡೋದ್ರಿಂದ ಆಗಲ್ಲ. ಅದು ಯಾವ್ದೋ ರಾಜ
ಪ್ರೊಸೆಸ್ ಆಫ್ ಸೆಲೆಕ್ಷನ್ ಶುಡ್ ಬಿ
ಸೆಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್, ಅವ್ರ ಬಗ್ಗೆ ಇನ್ಪುಟ್ ಎಂಥವ್ರು ಯಾರು ಇವರಲ್ಲ, ಇವರನ್ನ ತಯಾರಿ ಮಾಡೋರು. ನಮಗೆ ನಾವು ವಿ ಆರ್ ನಾಟ್ ಮಚ್ ಬಾದರ್ಡ್ ಅಬೌಟ್ ದ ಗುಡ್ಸ್. ನಾವು ವಿ ಆರ್ ಬಾದರ್ಡ್ ಅಬೌಟ್ ದಿ ಫರ್ನೇಸ್ ಇಟ್ ಸೆಲ್ಫ್, ಫ್ಯಾಕ್ಟರಿ ಇಟ್ ಸೆಲ್ಫ್. ದಿ ಪೊಲ್ಯೂಷನ್ ಬಿಗಿನ್ಸ್ at Gangotri. That is our problem.
If that gets polluted, the whole thing.
Everything will.
That is at the process of selection.
ನೀವು ಏನ್ ಮಾಡ್ತೀರಿ ಅಂತ ನಮ್ಗೆ ಹೇಳ್ಬೇಕು. ಇದೊಂದೇ ಕೇಸ್ ಪ್ರಶ್ನೆ ಅಲ್ಲ.
I understand. The permanent solution, Manoj, which will please get.
ಒಂದ್ ಸ್ವಲ್ಪ ಒಳ್ಳೆಯ ಸೊಲ್ಯೂಷನ್ ನಮ್ಗೆ ತಂದ್ಕೊಡಿ. ಏನ್ ಮಾಡ್ತೀರಿ ಅಂತ ನೋಡ್ಕೊಂಡು. ನೀವು ರೂಲ್ಸ್ ಚೇಂಜ್ ಮಾಡಿದ್ವಿ, ಬಹಳ ಒಳ್ಳೊಳ್ಳೆ ರೂಲ್ಸ್ ಚೇಂಜ್ ಮಾಡಿದ್ವಿ. ರೂಲ್ಸ್ ಇಂದ ಏನಾಗಲ್ಲ. ಯಾವ ರೂಲ್ಸ್ ತನ್ನಷ್ಟು ತಾನೇ ಏನ್ ಕೆಲಸ ಮಾಡಲ್ಲ. ಅದಕ್ಕೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ಮನುಷ್ಯರೇ ಬೇಕಾಗ್ತದೆ. ಎಂಥ ಮನುಷ್ಯರನ್ನ ಒಂದು ರೀಡರ್ಸ್ ಡೈಜೆಸ್ಟ್ ನಲ್ಲಿ ಒಂದು ಸ್ಟೋರಿ ಬಂದಿದೆ. ಭಗವಂತ ಎಲ್ಲಾ ದೇಶಗಳನ್ನ ಒಂದ್ ರೀತಿ ತಯಾರಿ ಮಾಡಿದ್ನಂತೆ, ಬ್ರಾಜಿಲ್ ಅನ್ನ ಅತ್ಯಂತ ಸುಂದರವಾಗಿ ಮಾಡಿದ್ನಂತ. ಅವಾಗ ದೇವದೂತ ಕೇಳಿದ್ನಂತ, ಭಗವಂತ ನೀನು ಒಂದ್ ದೇಶಕ್ಕೊಂದು ಇನ್ನೊಂದ್ ದೇಶಕ್ಕೊಂದು ಎರಡು ನಮೂನಿ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಹಂಗ್ ಮಾಡಬಾರ್ದು ನೀನು. ಹಿಂಗಾಗಿ ಯಾಕೆ ಏನ್ ಮಾಡಿದ್ದೇನೆ ನಾನು? ಬ್ರಾಜಿಲ್ ದೇಶವನ್ನು ಎಷ್ಟೊಂದು ಸುಂದರವಾಗಿ ಮಾಡಿದಿ, ಬೇರೆ ದೇಶಗಳು ಆಫ್ರಿಕಾದವು ಇವು ಹೆಂಗ್ ಮಾಡಿದೀಯಾ ನೀನು? ಇರು ಅಲ್ಲಿ ಎಂತ ಜನರನ್ನ ಹುಟ್ಟಿಸ್ತೇನೆ ನೋಡು, ಆಮೇಲೆ ಮಾತಾಡು. ಜನರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ
ಅಲ್ಟಿಮೇಟ್ಲಿ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್.
ಹಂಗಾಗಿ ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ಅಂತ
ನಮ್ಗೆ
ಏನಾಯ್ತು ರಿಪೋರ್ಟ್ ಏನೇನಾಯ್ತು. ಆಮೇಲೆ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಕಳ್ಸ್ಯಾರ ಅವರು. ವೈ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಡಿಡ್ ನಾಟ್ ಆಸ್ಕ್ ದಿ KPSC? Why investigation is still going on? Why did you finalize the list? ಅಂತ ಯಾಕೆ ಕೇಳಲಿಲ್ಲ? ಸರ್ಕಾರ ಆ ಲಿಸ್ಟ್ ಆಪರೇಟ್ ಮಾಡುವಾಗ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ಸ್ ಕೊಡುವಾಗ ಯಾಕೆ ಅಷ್ಟೊಂದು ಆತುರದಲ್ಲಿ ಮಾಡ್ತು? ಆಮೇಲೆ ಅಂತ ಕಂಡೀಷನ್ ಹಾಕೊಂಡು ಇಮಿಡಿಯೇಟ್ಲಿ ಕೊಡುವಂತಹದ್ದು ಏನಿತ್ತು? ಅದನ್ನ ಉತ್ತರ ಕೊಡ್ಬೇಕು. ಉತ್ತರ ಕೊಡಬೇಕು. ಇದಕ್ಕೆಲ್ಲ ನಾವು ಇಷ್ಟಕ್ಕೆ ಬಿಡಲ್ಲ ನಾವು. We will take this to its logical conclusion. We know our limitations.
No, but this is the case which your lordships will not go on technicalities in Manoj. Will assist your lordships in.
ಹೇಳ್ಬೇಕು ಯಾರು ಡಿಸಿಷನ್ ತಗೊಂಡ್ರು ಇದನ್ನ ಕಳಿಸ್ಬೇಕು, ಫೈನಲೈಸ್ ಮಾಡ್ಬೇಕಿದ್ನ ಇಮಿಡಿಯೇಟ್ಲಿ ಕಳಿಸ್ಬೇಕು ಅಂತ ಯಾರು ಡಿಸಿಷನ್ ತಗೊಂಡ್ರು ಅವ್ರ ಹೆಸರುಗಳನ್ನು ಕೊಡಬೇಕು. ಈಗ ಆಫ್ಟರ್ ಕ್ಯಾಪ್ಟನ್ ಸತೀಶ್ ಶರ್ಮಾ ಜಡ್ಜ್ಮೆಂಟ್, ಈಗ ಅವ್ರನ್ನೆಲ್ಲ ಹಂಗ ಬಿಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ನಾವು. ಅಲ್ಲಿ ಕ್ಯಾಪ್ಟನ್ ಸತೀಶ್ ಶರ್ಮಾದಲ್ಲಿ 50 ಲಕ್ಷ ರೂಪಾಯಿ ದಂಡ ಹಾಕಿತ್ತು ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಹಂಗೆ ಬಿಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಾವು ಡಿಸ್ಟ್ ಮಾಡೇವಿ ಅಂತ. ಸಮಥಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಟು ಡೂ ಟು ದೆಮ್. ಇಸ್ ಇಟ್ ನಾಟ್? ಸಮಥಿಂಗ್ ಶುಡ್ ಹ್ಯಾಪನ್ ಟು ದೇರ್ ಇಂಟರ್ನಲ್ ಆರ್ಗನ್ಸ್. ಒಂದು ಕಿಡ್ನಿಗೋ, ಒಂದು ಸ್ವಲ್ಪ ಹಾರ್ಟಿಗೋ, ಇಲ್ಲ ಒಂದು ಸ್ವಲ್ಪ ಬಿಗಿ. ಅದರ್ವೈಸ್ ಹಿಂಗೆಲ್ಲ ಆಗಕೊಟ್ಟು ಮುಂದೆ ಗತಿ ಏನು ಒಳ್ಳೊಳ್ಳೆ ಇರ್ದು. ಸಮ್ ಆರ್ಗನ್ಸ್ ಶುಡ್ ಸಫರ್. ಅವ್ರು ಯಾರು ಅಂತ ಅನ್ಕೊಂಡು ಹೆಸರು ಕೊಡ್ಬೇಕು ನೀವು. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಏನೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಅಂತ ಹೇಳ್ಬೇಕು.
So insofar as Manoj, now the report has come in the month of January, 31st January 2025, Manoj. That from the KPSC, which has not yet been received, but anyway, now that we have come to know, Manoj, I'll place what decisions we are going to take insofar as this 10 candidates are concerned.
Then ಅಷ್ಟಲ್ಲ, overall ಏನ್ ಮಾಡಕ್ ಹೊಂಟ್ರಿ ನೀವು ಇದನ್ನ?
That I'll
ಇವ್ರದಷ್ಟೇ ಅಲ್ಲ.
No, ಅಲ್ಲ, overall I'll tell, Manoj. In fact specific also I will tell. That's what your lordship.
ಮತ್ತೆ ಯಾಕೆ ಅವಸರದಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ಲಿ ನಾವಂತ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡುವಂತದ್ದೇನಿತ್ತು ಗವರ್ಮೆಂಟ್ ಬೀಳ್ತಾ ಇತ್ತಾ? ಏನ್ ವೈ ಸೋ ಹರಿ? Supreme Court says
between
much hurry.
22nd February and 25th June, what would have, why did we do it?
Why did
we could have awaited the report, then we could have proceeded for.
You should have asked it. ಏನಯ್ಯ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಾ ಇದೆ, 5 member ಕಮಿಟಿ ಇದೆ, why did you send that final list? This cannot happen without involvement of some people. It's so obvious.
Petitioners only.
We do not know.
Ultimately, Manoj, is the beneficiary, the petitioner.
Ultimately, government issues the order.
Correct. I mean, they issue the order.
Government issues the order. They will not give the format to you and bring it to you saying that sign. They may have done something else. That's another thing. But it is you who will issue the order.
That one.
And you have issued once.
25th June 2024, we have appointed 24 people, Manoj. So, in fact, Manoj, just kindly grant few days time, Manoj. I'll get
ಬಟ್ ಈ ಕಾರಣ ಹೇಳ್ಬೇಡಿ, ಏನೋ ಸೆಷನ್ ನಡೀತದೆ ಹಂಗೆ.
ಇಲ್ಲ ನಾನು
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಬೇರೆ. ಇದು session.
ಇಲ್ಲೇ ನಡೀತಾ ಇದೆ
ಹೌದು.
ಧಾರವಾಡ ಆಗಿದ್ರೆ ಹೇಳ್ಬೋದಾಗಿತ್ತು, ಬೆಳಗಾವಿ ಆಗಿದ್ರೆ ಹೇಳ್ಬೋದಾಗಿತ್ತು.
I have one submission. Your Lordship permits me. 25/1/24, the then secretary with various complaints attached to Lord, she sent a complaint.
ಅದೊಂದು ಯಾವ್ದೋ ಲೆಟರ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನೊಂದು ತರ್ಸ್ಕೊಂಡು
Very
ಮಾರ್ಕ್ ಶೀಟ್ ಗಳನ್ನ ನಾವು ನೋಡೋದಿದೆ.
Please, we have got it.
ಒಂದ್ ಸ್ವಲ್ಪ
It is ready, my lords.
But
Should I pass it
24
on now
members
or
told me
next
after
day?
my-
ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿ.
ಅದೇ ಬರ್ಲಿ.
And will let
ಮಾಡಿ.
the Oma sheet come.
ಅವುಗಳನ್ನೆಲ್ಲ ನಮ್ಮ ಆರ್ಜಿಗೆ ದಿ learned AAG appearing for the KPSC on instructions of this court has produced 2 envelopes, sealed envelopes,
Original, sir. Please. Original.
allegedly containing the original documents.
Correct.
Document.
But
And
24 members told my.
kindly hold back.
Lords, it contains,
This
the-
will be, the contents are not known to court.
Lords,
Not
we
known
have
to court.
stated in the, on the sealed cover that one contains the original OMR sheets of the 24 candidates. The other cover contains the FSL report along with hard disk and pen drive. ಅದು ಕೊಡಿ sir.
ಅದು ತಕೊಳ್ಳಿ,
The-
ಕೋಡ್ ಆಫೀಸರ್, ಕೋಡ್ ಆಫೀಸರ್.
ಹಾ.
ಅದು ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
The one contains the contents of the envelope, the confidential envelope are mentioned from serial number 1 to 5 on the face cover,
I don't need it.
on the face cover.
Okay, that quote you have.
On the second envelope, which again is a confidential document, cover,
Five-member committee report.
has 3 items within allegedly. That is 1, 2, and 3. A short description of the same is given on the face cover itself. First off, these 2 shall be preserved by the Registrar General of this court until further orders.
The
But they
31st
not given the
January
letter.
There are copies ನಿಮ್ಮಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರಾ?
Please.
Copies of this ಅಲ್ಲಿ in the safe custody, preserved in the safe custody. ಇದ್ರ
Photocopy.
copies ಇಟ್ಕೊಂಡ್ರಾ?
photocopies ಇಲ್ಲ.
ಕೇಳಿ ನಿಮ್ಮ ಅವ್ರು ಹೌದು ಅಂತಾರೆ, ನೀವಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಿ, ಸರಿಯಾಗಿ ಕೇಳ್ಕೊಳ್ಳಿ. ಇದ್ರದ್ದೆಲ್ಲ ಕಾಪೀಸ್ ಇಟ್ಕೊಂಡ್ರಾ ನೀವು? ಹಾ, ಕಾಪೀಸ್ ಆಫ್ ದಿಸ್.
We have minutes.
First off, we are told that the copies of the contents of these 2 envelopes are retained by the KPSC.
ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, kindly listen.
ಇದ್ರೊಳಗಡೆ ಏನೇನಿದೆಯಲ್ಲ ಅದ್ರದ್ದು ಒಂದು ಕಾಪಿ ನಿಮ್ಮಲ್ಲಿ ಇದೆಯಾ? First off,
Kindly
this
watch
is
your-
ascertained,
What's your name? Chandrasekhar.
this is ascertained by putting question to Mr. So and so NU,
Head of legal cell, my lords.
Shri so and so, who is head of legal cell, comma KPS. So, Mr. AG, which date will be convenient?
Sir, on,
ಆಮೇಲೆ ಇದು ಓಪನ್ ಮಾಡಿದ್ಮೇಲೆ ಇದರಲ್ಲಿ ಸಿಡಿ ಗಿಡಿ ಎಲ್ಲ ಇದೆಯೇನು?
yes,
Please,
yes.
my lords.
ನಾವು ಆಮೇಲೆ ಒಂದು ಇಲ್ಲೊಂದು ಅದನ್ನೆಲ್ಲ ನಾವು ಪ್ಲೇ ಮಾಡೋಣಂತೆ, ಫ್ಯೂ ಪರ್ಸನ್ ಇದ್ಕೊಂಡು
Please, madam.
ಈ ಅವಶ್ಯಕತೆ ಬಿಟ್ರೆ ಪಬ್ಲಿಕ್ಕಿಗೂ ಡಿಸ್ಪ್ಲೇ ಮಾಡ್ಬೋಣ ಏನೇನಾಗಿದೆ ಅಂತ, ಸೊ ದಟ್ ಪೀಪಲ್ ಆಲ್ಸೋ ಶುಡ್ ನೋ. People should know how courts function, how various constitutional bodies function. There is nothing secret,
Nothing secret.
except ಈ ಮಾರ್ಕ್ಸ್ ಮತ್ತು ಇಂಥವೆಲ್ಲ ಬಿಟ್ರೆ ಉಳಿದಿದ್ದು ಸೀಕ್ರೆಟ್ ಆಗಿರೋ ಅಗತ್ಯ ಇಲ್ಲ. ಇನ್ನು ಒಂದ್ಸರಿ ನಾವು ನೋಡೋಣ, ನೋಡ್ಕೊಂಡು
No, no, there's not,
ವೆರಿ ಸೆಲೆಕ್ಟ್ ಫ್ಯೂ ಇಟ್ಕೊಳ್ಳೋಣ, ನೋಡ್ಕೊಂಡು ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಅಬ್ನಾಕ್ಷಿಯಸ್ ಇತ್ತು ಅಂದ್ರೆ we will show it to people also. Let people judge.
what
We have
else?
to go to people now. There is no other alternative.
In fact, Manoj, that PSI scam also, Manoj. Even that is thing, ultimately we have to scrap it, redo the whole examination, Manoj. In fact, now the technologies, who write the
ಇದು
exam,
ಹೊಸದಲ್ಲ.
ಇದು ಹೊಸದಲ್ಲ.
Three committees were formed. Huta committee report had
Correct.
come
Correct, my lord.
more than a decade ago.
Pursuant to Justice Ravindran judgment, my lord.
Yes, Huta
Oh,
committee was
correct, my lord.
appointed. Thereafter, another committee came. I think it was
In fact, we are, what the Kota committee's report, we have taken everything, every recommendation is being implemented. I'll show the
but
recommendation.
how these things happen?
As this lordship said, people who are manning it is the
Ah.
process of, I've got bow down to your lordship. my lord.
ಅದ್ ನೀವು ಆ ಕಡೆ ನೋಡ್ಬೇಕು.
In fact, I'll just place that also, my lord, because limited time, I'm not able to get gathered.
ಆಯ್ತು ಆಯ್ತು ನಿಮ್ಗೆ ಈಗ ಅರ್ಜೆನ್ಸಿ ಬಂದಿದೆ.
Not 25/1/24 letter
ಹಾ.
before constitutional committee, then
ಅದೊಂದು
secretary
letter-
made allegation.
ಹೇಳಿದ್ರೆ ಪ್ರಕಾಶ್ ಅಲ್ಲಿ
Letter is there. We have got the letter, Milords.
The those members are heading the committee.
Let us see.
Kindly see that.
ಅಲ್ಲಿ ಈಗಿರುವಂತ ಯಾವ್ದಾದ್ರು ಮೆಂಬರ್ಸ್ ಮೇಲೆ ಏನಾದ್ರೂ ಕ್ರಿಮಿನಲ್ ಕೇಸು ಹಿಂದೆ ಇದ್ದಿದ್ದಾಗ್ಲಿ ಈಗ ಇರೋದಾಗ್ಲಿ ಇದೆಯಾ?
We'll verify and.
ಯಾವ್ದಾದ್ರು ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿ ಕಮಿಟಿ ಮೇಲೆ, KPSC ಮೆಂಬರ್ಸ್ ಮೇಲೆ,
We will get that.
ಆಫೀಸ್ ಅಲ್ಲಿರುವಂತ ಅಫಿಷಿಯಲ್ಸ್ ಮೇಲೆ,
Please, you take instructions and we'll place it.
ಹಾ.
ಅದೇ ಹೇಳ್ತೀನಿ.
ಯಾರ ಮೇಲೆ ಈಗ ಹಿಂದೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದ್ದಿದ್ದಾಗ್ಲಿ ಈಗ ಇರೋದಾಗ್ಲಿ
Please.
ಅಥವಾ ಅಲ್ಲಿರೋ ಆಫಿಷಿಯಲ್ಸ್ ಪೋಸ್ಟ್ ಆದ್ರ ಮೇಲೆ ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಆಗ್ಲಿ ಇದೆಯಾ? ಲಿಸ್ಟ್ ಕೊಡ್ಬೇಕು.
we'll do that.
ಅವ್ರ ಕ್ರೆಡೆನ್ಶಿಯಲ್ಸ್ ಕೊಡ್ಬೇಕು ನಮಗೆ.
Please, Milords. Let's,
Basically,
once submitted.
biodata.
All these petitioners were secured distinction and gold medal in the
Not
degree.
not.
Kindly appreciate this.
ಅಲ್ಲ, ಇದನ್ನ ಈಗ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಲ್ಲ. ಈಗ ಬೇರೆ ಅಪ್ರಿಶಿಯೇಷನ್, ಈಗ ಬೇರೆ
ತಾವು ಅದನ್ನ ನೋಡಿ ಆ ಕಮಿಟಿ ಮೇಲೆ ಆ ಕಮಿಟಿ ಮೆಂಬರ್ಸೇ ಕಮಿಟಿ ಕ್ವಶನ್ ಮಾಡಕ್ಕೆ.
Let's, in this
ಆ
letter,
examination ನೋಡ್ಬೇಕಾಗತ್ತೆ.
the allegation.
ಎಲ್ಲ ನೋಡೋಣ.
ನೋಡಿ ಪರವಾಗಿಲ್ಲ.
Lords, this is a letter that is written by the secretary, my lords, making certain allegations, but not in the context of this recruitment, I'm told. It is generally, my lords, again, with regard to the functioning. So that also was in the cognizance of the government, that I brought it to the notice of the learned AG. So we'll also place with regard to what action was taken on the basis of that.
No, I think that was the only thing, Manoj, in the month of March of 2024, this is in the month of February, March, Manoj, the officer was the secretary of KPSC was transferred.
Because
Of this recommendation. Complaint and recommendation was there, she was transferred pursuant to that.
so the complainant was punished.
No, my lords.
No,
My lords,
Secretary, KPSC who sent the recommend,
But she had made, that person had made allegations.
no.
no, my lords. The
She-
chairman of the commission
Yes.
wrote to the government stating that this list ought to have not been sent. Please don't make appointments on the basis
By
of
the
this.
secretary.
By the secretary. On that basis, my lord, secretary was transferred, but before she was transferred, she also officially wrote a letter to the
On
government.
22nd of February.
Lords, one submission. In that cover, my lords, I am informed, there is a pen drive and a hard disk. Except those two remaining, we have copies. Pen drive and hard disk, we don't have copies.
ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಆಡ್ ಮಾಡ್ಕೊ. We are told by the learned AAG
My lords,
appearing
I'm
for
appearing
the
as senior counsel. It's not as.
learned senior advocate appearing for the KPSC that one of the envelopes contains
Hard disk?
a hard disk and a pen drive. And they don't have duplicates of the same.
Please.
ಒಂದು ಮಾಡಿ ಕೊಟ್ಬಿಡ್ಬೋದಿತ್ತು. ಹಾ, ಇರ್ಲಿ, ನಮ್ಮಲ್ಲಿ ಈಗ ಸ್ವಲ್ಪ
25/1/24 ಲೆಟರ್
ಇದೆ ಇಲ್ಲಿದೆ.
ಅವರೇ ಮೆಂಬರ್ಸ್ ಕಮಿಟಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಇದನ್ನ ಇನ್ನೊಂದೊಂದು ಅನುಲೋಪನೆ ಹಾಕಿದ್ವಿ, ಕವರ್ನೆ ಹಾಕಿದ್ವಿ. ಎಸ್, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್.
But they are relying upon the report which we have not been given a copy.
ಅದು ನಿಮ್ಗಲ್ಲ,
No, reports cannot.
ನೋಡ್ಲಿಕ್ಕೆ ನಿಮ್ ಕೇಸ್ಗಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಯಾಕೆ ನಮ್ಮ ವಿರುದ್ಧ ಇದೆ ರಿಪೋರ್ಟ್, ನಮ್ ಕಾಪಿ
ನೋಡೋಣ ಅವಾಗ ನಿಮ್ಗೆ ಇಫ್ ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಯು ವಿಲ್ ಟೇಕ್ ಟು ಯು, then you can will have your say and then
yes,
what should be done, we'll do that. Not, we'll see, we'll look at. Yes.
ಎಂಟ್ರಿ ಮಾಡಿತ್ತು ತಾವು ಅಲ್ಲಿವರೆಗೆ ತಾವು ಮಾಡುವಲ್ಲಿವರೆಗೆ
Not a case for continuing the entry order. Please continue.
ಬಹುಶಃ ತಾವು
Yes, my lords.
ನನ್ನ ಪ್ರಿಜುಡಿಸ್ ಕಾಣುತ್ತೆ.
ನಿಮ್ಮ this prejudice ನಮ್ಗೆ ಹಂಗೆಲ್ಲ ಅನ್ಬಾರ್ದು. ನಮ್ಗೆ ಏನಿರ್ತದೆ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
KPSC
ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂದ್ರೆ ಒಂದು ನಾನು ಇತ್ಲಾಗರ ಮಾಡ್ಬೇಕು ಅತ್ಲಾಗರ ಮಾಡ್ಬೇಕು,
ಅಲ್ಲ
ಹೆಂಗೆ ಸಾಧ್ಯ ಇದೆ? ನೀವೆಲ್ಲ ನಮ್ನೆಲ್ಲ ಡೌಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಹಾಗಲ್ಲ.
ಆಲ್ ರೈಟ್, ಏನ್ ನಡೀತು ನಡೀಲಪ್ಪ, ನಾವು
ಹೌದು.
ಮಕ್ಕಿ ಮಾಡ್ಕೊಂಡು
Attorney Milord,
ಹಾ.
Your lordship, your lordship are more worried about the system in place rather than this case, my lord.
ಏನಿಲ್ಲ, ಮುಂದೆ ನಮ್ಮ ಮೊಮ್ಮಕ್ಕಳು ಆದ್ರೆ ಅವು ನಾಳೆ ನಮಗೆ ಕೇಳ್ತಾವು, ಅಜ್ಜ ನೀನು ಇದ್ದೆಲ್ಲ ಕೋರ್ಟ್ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಿ ಅಂತ ಕೇಳಿದ್ರೆ ನಾವ್ ಏನ್ ಹೇಳ್ಬೇಕು ಅಲ್ವಾ? ಆ ರಷ್ಯನ್ ರೆವಲ್ಯೂಷನ್ ಆದಾಗ, ಐ ಥಿಂಕ್ ಫ್ರೆಂಚ್ ರೆವಲ್ಯೂಷನ್ ಆದಾಗ ಬಿಥೋವನ್ನಿ ಕೇಳಿದ್ನಂತ ಅವನ ಮೊಮ್ಮಗ, ಅಜ್ಜ ರೆವಲ್ಯೂಷನ್ ಆಗುವಾಗ ನೀ ಇದ್ದಲ್ಲ, ಮತ್ತೆ ನಿಂದೇನು ಅಚೀವ್ಮೆಂಟು? ಮೈ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಐ ಸರ್ವೈವ್ಡ್ ಅಂತ. ದಟ್ಸ್ ಮೈ ಅಚೀವ್ಮೆಂಟ್. ಹಂಗ ಆಗ್ಬಾರ್ದು. ಅದರ್ವೈಸ್ ಹೀಗೆ ಯಾರೋ ಒಬ್ರು ಮಾಡ್ಬೇಕಲ್ಲ.
As your lordship said, my lord, the process of selection
ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕು.
there should be a start beginning, man. In fact, the timing is also absolutely right. Between yesterday and today, at least we are thinking of it. It's coming in the papers. What is
something should happen. ಇಲ್ಲ, ಅದನ್ನ ಅದೇನಿದೆ ಅಲ್ಲ, ಇದು ಈ ಪೆನ್ ಡ್ರೈವ್ ಇವೆಲ್ಲ, we are just thinking we'll have.
Sir, lordship can go through it so that.
ಅಲ್ಲ, ನೋಡ್ತೇವೆ ಮೊದಲು, ನೋಡಿ ನಿಮ್ಮೆಲ್ಲ ಇಟ್ಕೊಂಡ ನೋಡಿ.
First, your lordship may go through it independently or with the assistant.
ಅದನ್ನೆಲ್ಲ ನಿಮ್ ಇಟ್ಕೊಂಡ ಮಾಡಿ ನಾವು ಹಂಗ.
Okay, leave it.
ಯಾಕಂದ್ರೆ ನಾಳೆ ಜಡ್ಜ್ ಅದ್ರಾಗಿರುವಂತ ಪೆನ್ ನಾವು ಬೇರೆ ಕೊಟ್ಟಿದ್ವಿ, ಇವರು ಇನ್ನೊಂದು ಇಟ್ಕೊಂಡಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸಮಸ್ಯೆ ಆಗ್ತದೆ. ಅದಕ್ಕೆ ಅದನ್ನೆಲ್ಲ ಓಪನ್ ಮಾಡುವಾಗ ನಿಮ್ ಪಂಚ್ ಕಮಿಟಿಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ನಮ್ಮ ರಾಘವನ್ ಅವ್ರನ್ನ, ಬಸವರಾಜನ್ನ, ಇವ್ರನ್ನೆಲ್ಲ ಇಲ್ಲಿ ವಿಟ್ನೆಸ್ ಆಗಿ ಇಟ್ಕೊಂಡು ಮುಂದೆ ನಾವು ಅದನ್ನೆಲ್ಲ ಮಾಡ್ತೇವೆ. ಮಾಡಿ ವಿಲ್ ಟೇಕ್ ಎ ಡಿಸಿಷನ್ ವೆದರ್ ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಏನು ರಿಲೇಡ್ ಇನ್ ಅವರ್ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸೊ ದಟ್ ಪೀಪಲ್ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು. ಜನರಿಗೆಲ್ಲ ಗೊತ್ತಾಗಬೇಕು ಏನ್ ನಡೆದಿದೆ, ಎಲ್ಲೆಲ್ಲಿ ಸಗಣಿ ತಯಾರಾಗ್ತದೆ, ಎಲ್ಲೆಲ್ಲಿ ಸಗಣಿ ತಿನ್ನುವಂತರಿದ್ದಾರೆ, ಎಲ್ಲೆಲ್ಲಿ ಸಗಣಿಯನ್ನು ತಾವು ತಿನ್ಕೊಂಡು ಬೇರೆಯವರು ವರ್ಷೋರಿದ್ದಾರೆ, ಇದೆಲ್ಲ ಗೊತ್ತಾಗಬೇಕಾಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಕ್ಲೀನ್ ಆಗಲ್ಲ ಸಿಸ್ಟಮ್. Somebody should do that. Somewhere it should begin. ಇವೆಲ್ಲ ಈ ಗುಳಿಗಿ ನುಂಗ್ಯೋದ್ರಿಂದ ಸರಿ ಆಗಲ್ಲ ಇದೆಲ್ಲ. ಇದಕ್ಕೊಂದು 4-6 ತಲೆಗಳು ಬೀಳ್ಬೇಕು, ಅವಾಗ ಏನಾದ್ರೂ ಉಪಯೋಗ ಆಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಎಲ್ಲ ಅಷ್ಟು ಡಿಸ್ಆನೆಸ್ಟ್ ಅನ್ನಂಗಾಗ್ತದೆ. Those who look and keep quiet, they are also dishonest people. They are really seeing and you don't want to do anything. ಹಂಗಾಗಿ ಎಲ್ಲ ಕಡೆ ಎಲ್ಲ ಕಡೆ ಕೆಟ್ಟ ಜನ ಇದ್ದಾರೆ, ಆದ್ರೆ ಎಲ್ಲ ಕಡೆ ಒಳ್ಳೆಯವರು ಇದ್ದಾರೆ. ಕೆಲವು ಸರಿ ಏನಾಗ್ಬಿಡ್ತದೆ, ಕೆಟ್ಟ ಜನರು ಒಳ್ಳೆಯವರಿಗೆ ಮುಖಕ್ಕೆ ಏನೇನೋ ಹಚ್ಚಿಬಿಡ್ತಾರೆ. ಇದೆಲ್ಲ ಸಮಸ್ಯೆ ಇದಾವೆ, ಇದು ಎಲ್ಲಾ ಕಡೆ ಇದೆ ಇದು. ಹಂಗಾಗಿ ನಾವು ಬಹಳ ಹುಷಾರಿಂದ ಹೋಗ್ಬೇಕು. ಇದನ್ನ ಹಂಗೆ ಬಿಡಲ್ಲ ನಾವು ಹಂಗೆ ಬಿಡಲ್ಲ. ನಮಗೆ ನೀವು ಇದರಲ್ಲಿ ಸಹಾಯ ಮಾಡ್ಬೇಕು.
ಖಂಡಿತ ನಾವು ತಪ್ಪು ಮಾಡಿದ್ರೆ ಹೋಗ್ತಾರೆ. ಐ ಆಮ್ ನಾಟ್.
We want transparency.
Transparency
everywhere. We want transparency.
ಆಮೇಲೆ ಒಂದು ಹೇಳ್ತಾ ಇದ್ದೇವೆ ನಿಮ್ಗೆ, ಇದನ್ನು ಅಷ್ಟು ಪಬ್ಲಿಕ್ ಈಗ ನಾವು ರಿಲೇ ಮಾಡಿ ಬಿಡ್ತೀವಿ. ಏನು ನಡೆದಿದೆ ಗವರ್ಮೆಂಟ್ ಅದ ಎಲ್ಲೆಲ್ಲಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ನೋಡಿ, ಈಗ ನಾವು ಓಪನ್ ಇಟ್ಟೇವಪ್ಪ, ಹೌದಾ? ಎಲ್ಲರೂ ನೋಡ್ಬೋದು ನಮ್ದು, ನಾವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀವಿ, ನಾವೇನ್ ಮಾತಾಡ್ತೀವಿ, ಹೌದಾ? ಎಲ್ಲರೂ ನೋಡ್ತಾರೆ. ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀವಿ ನಿಮ್ಮನ್ನು ನೋಡುತ್ತಾರೆ. ಹಂಗೆ KPSC ಏನೇನ್ ನಡೆದಿದೆ ಮತ್ತೆ ನೀವೇ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಾವೇನ್ ಜನರೇಟ್ ಮಾಡಿಲ್ಲ. ನಿಮ್ಮಲ್ಲಿಂದ ಹುಟ್ಟಿದಂತ ಡಾಕ್ಯುಮೆಂಟು, ಪೆನ್ ಡ್ರೈವ್ ನಿಮ್ಮವೇ. ಇದೆಲ್ಲ ಇಡೀ ಮಾರ್ಕೆಟ್ ಪ್ಲೇಸ್ ನಾಗೆಲ್ಲ ಒಂದೊಂದ್ ಕಡೆ ಒಂದೊಂದು ಟಿವಿ ಹಾಕ್ಸಿ ಇದನ್ನೆಲ್ಲ ಪಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಮಾಡ್ಬೋದು ನಾವು. ಲೆಟ್ ಪೀಪಲ್ ನೋ. ಅದು ದಿ ಸನ್ಲೈಟ್ ಈಸ್ ದ ಬೆಸ್ಟ್ ಡಿಟರ್ಜೆಂಟ್. ಲೆಟ್ ಪೀಪಲ್ ನೋ. People should know what is happening, who are working, who are not working, how they are working. Let people know. ಬೇರೆ ಸಿಸ್ಟಮ್ ಇಲ್ಲ, ಏನು ಬೇರೆ ಸಿಸ್ಟಮ್ ವರ್ಕ್ ಆಗಲ್ಲ.
As your lordship will be very transparent, will place all the material, will assist your lordship.
ಇದನ್ನ ತಾವು ನೋಡ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ, ನಮ್ಗೆ ತಪ್ಪಿಲ್ಲ, ತೊಂದ್ರೆ
ತಪ್ಪಿಲ್ಲ ಅಂತ ಹೇಳೋದು ನೋಡ್ರಿ ನಮ್ಗೆ ಡೌಟ್ ಬರ್ತಾ ಇದೆ ನಿಮ್ಮ
ಆದ್ರೆ ಧೈರ್ಯ ಹೇಳಲ್ಲ.
When will 18th? Call this matter on 18th for heard learned advocate general and learned senior advocate appearing for the KPSC, assisted by the panel counsel Prakash. We have also heard learned senior advocate Mr. Bhagwat and learned senior advocate Mr. First Lakshmi Narayana and Mr. Bhagwat, senior advocate Bhagwat, appearing for the petitioner's side. First up, learned advocate general assures us that something is being done to ensure transparency and integrity of KPSC as an institution. having taken cognizance of certain bad things perpetrated there. First off, we have notified to the learned learned Advocate General that when initially committee comprising of 3 members of KPSC and later committee comprising of 5 members of KPSC was looking into serious allegations of malpractices, how is that the KPSC could finalize the select list and send it to the government for operation? First off, we are also bewildered, to say the least, that even the government of the day did not bother to look into the affairs of KPSC. And very strangely, pending conclusion of the ongoing inquiry committee proceedings, the appointment orders have been issued to certain candidates.
All the candidates.
All the candidates.
All 24 candidates.
First off, the government cannot feign ignorance in as much as it has stipulated the condition in the appointment orders only about this. First off, such things can happen only in Alice in Wonderland. First off, much is not necessary to specify at this stage. First off, call this matter on 18th for further hearing.
Only one question, the fact that KPSC is a constitutional body by itself,
Correct.
the state government can't interfere in the functioning of the KPSC.
We agree, we agree that the government has some constraints, since KPSC is also a constitutional entity. First off, but both they have their own spheres of action. And to that extent, they can set their houses all right. Okay. Nim level nallu madlik bartade.
No, we'll do, that ought to have been done. We'll rectify, we'll come. I'll answer, I'll assist my lords to see that past and future, how we'll go about it.
Something has to be done.
And my submission also that government can or certainly can take action.
Okay, is it possible to take on 230 on 18th so that?
At 2:30. At 2:30.
230. So
Very. Avat ಬೇರೆ ಕೇಸ್ಗಳನ್ನು ಹಾಕೋಬೇಡ 18th ಇದರಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗಬೇಕು ಹಿಂಗಂತ ಇದರಲ್ಲಿ we may appoint some amicus curiae to assist us
Please,
independently.
please.
What do you say?
Your worship may totally enumerate our
Lord,
ask us also.
Since we are appearing for the Lord petitioners, an impartial amicus curiae should be
ಒಬ್ರು ಬೇಕಾಗ್ತಾರೆ
better.
Let's,
ಹೇಗೆ ಅಂತ
if my lords may,
ಹಾ
lords, if my lords may defer that by 18th, because earlier, my lords, we had, as an officer of the court, I'm saying this, I've been appearing for KPSC, my lords, as a panel counsel also earlier for the last 15 years. Quota committee report came about. There were certain reforms. An officer of the controller of examination was created. Then, my lords,
thereafter 2 more committees were.
thereafter 2 more committees.
Correct.
I will also get everything, what was done, what recommendations were taken, and in fact, my lords, I can tell out of my experience that this officer of controller of examination was created, and Hota committee had recommended that a direct IAS officer should be posted. Now, direct IAS officer, controller of examination was given, my lords, all confidential work was his. But out of experience, I can also say recently, my lords, we have the gazetted probationers recruitment that took place where I had appeared. First, my lords, when the preliminary examination took place, there was a translation error that happened. Thereafter, a decision was taken, my lords, to scrap the to rehold the examination. Then there was a litigation with regard to that. Finally, my lords, court vacated the stay. We were all able to hold a re-examination. Even in the re-examination, unfortunately, there was again translation errors that took place. Now, my lords, commission also is, what has happened is the controller has some exclusive control over confidential information. Even confidential information will be given to secretary and only to the chairman, only on need to know basis. So therefore, in the functioning of the commission, there have become certain islands, and which has resulted in these kinds of secretary speaking.
ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಡಿಸಿಷನಿಂಗ್
Decisioning.
ಐಲ್ಯಾಂಡ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
Island start agide. Because of that, there is delay in the decision making process. Recruitments are being held up, and therefore, my lords, these aspects are there, which, my lords, I will also place it on record. But if my lords may defer regarding the amicus, because maybe more
next date
next date of hearing, I'll also say.
Having said that, my lord, today Karnataka Public Service Commission Conduct of Business and Additional Function Amendment is being placed before the cabinet, addressing all this issue and your apprehension, what your lordships are saying. I'll place that being a thing on the next date of hearing, my lord, to see, and your lordship may go through it. Any other suggestions, my lord, we are open to it. In fact, we are looking into all that also.
ಇದ್ರ ಬಗ್ಗೆ ಥಿಂಕ್ ಮಾಡಿ, ನಾವು ಇದನ್ನೇನು ಪಬ್ಲಿಕ್ ರಿಲೇ ಮಾಡೋಕಂತ ಮಾಡಿದೇವಲ್ಲ, ಸೊ ದಟ್ ಆಲ್ ಪೀಪಲ್ ಇನ್ ಮಾರ್ಕೆಟ್ ಏರಿಯಾಸ್, ಪಾರ್ಕ್ಸ್ ಎಕ್ಸೆಟ್ರಾ, ಪೀಪಲ್ ಶುಡ್ ನೋ. ಹೌದು,
We'll come to that.
ಪೀಪಲ್ ಅದ್ರ ಬಗ್ಗೆ
Come to that.
ಪ್ರಿಪರೇಷನ್
We'll come to that, my lord.
ಪೀಪಲ್ ಶುಡ್ ನೋ. ಅವಾಗ ಅರ್ಧಕ್ಕರ್ಧ ಸಮಸ್ಯೆ ಹೋಗ್ತದೆ, ಜನರಿಗೆ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ.
In fact,
After our progress, we'll see, my lord, if we are still not convinced, my lord.
Yesterday, my lords were seeing one tabulated statement with regard to CCTV camera footages.
Correct.
In fact, my lords, when we were appearing in respect of D-Pharma exams and nursing examinations where the malpractices were a bit rampant, state decided to give it to the RGHS centers, where they have now live streaming of the examination centers and a control room. Maybe, my lords, will all place it on record so that, my lords, what the government can do is also certain things. The court also, my lords, we will place it, my lords, so that this case, my lords,
In fact, now every examination, my lord, there's 360 cameras, my lord.
Okay.
Earlier, they used to have earplug, camera in the thing, all that video, all that. my lord. Now, at least to see that what exactly is happening, anyway, we'll place it, everything in black and white before your lordships, my lord. As the lordship says, the input is good, then only the output will good. If people who enter in are bad, or the people who make the selections are bad, the whole systems gets corrupted.
Well,
we'll come
for
prepared.
further hearing on 18.
But here
18.
provisional list is not in the month of September. They took 4 months to finalize the list. 4 months. In between 4 months, otherwise, if the law mandates 15 days, probably this would have happened. 4 months they took.
Call on 18th at 2:30 as requested.
Please, great.
My lord, ಅಲ್ಲಿವರೆ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಆಕ್ಟ್ ಮಾಡಬಹುದು ಟಿಲ್ ಮೈ ನಾಟ್ ಟೇಕ್ ರಿಸ್. ಯಾಕೆ ನನಗೆ ನಮ್ಮ ಮತ್ತೆ
ಅದೇನೋ ಅವರನ್ನೇನೋ ಹೊರ ಕಳಿಸ್ತೀರಿ ಈಗ
ಅಲ್ಲಿವರೆ ತಾವು ಡಿಸಿಷನ್ ತಗೊಳ್ಳಿವರೆಗೆ. ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಮೈ ಲಾರ್ಡ್
ಟಿಲ್ ದೆನ್ ಏನು ಪ್ರಿಸಿಪಿಟೇಟ್ ಮಾಡಬೇಡ್ರಿ.
ಅಷ್ಟೇ ಮತ್ತೆ
ಅಡ್ವರ್ಸ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಮಾಡಬೇಡ್ರಿ ಅವ್ರ ಮೇಲೆ. ಮುಂದ್ ಮಾಡೋದು ಬಂದ್ರೆ ಮಾಡೋಣಂತೆ.
ತಾವು ಮಾಡಿ ಪರವಾಗಿಲ್ಲ ಮಾಡಿ. ಮೈ ಲಾರ್ಡ್
till next date of hearing, no precipitatory action shall be taken against the petitioners, and that they shall be continued in employment.
But continued, madam.
He continue ilva avaru
ಮಾಡಿದ್ದೆ 7 ತಿಂಗಳ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
They are working.
They are working, madam. The only thing is in
this subject to this.
Insofar as interim relief was concerned, there was no precipitatory action that was sought to be taken up.
Now we are asking you, do you want to take it?
No, with regard to appointment, the government.
At least till next date of hearing, ultimate no precipitatory action shall be taken against the petitioners till next date of hearing.
including.
Full stop. However, petitioner shall not seek or plead any equity on the basis of this arrangement.
Like that condition number 8.
That's that's.
Condition number 8 itself we are agreeing.
ಆ ರೀತಿ ಮಾಡಂಗಿಲ್ಲ. You are right, we agree with that.
Sir, my lords, one submission. The stage insofar as the KPSC was concerned, it was at the stage, my lords, when the commission accepted the final report of the subcommittee and directed further action. We were at that stage. The general interim order was not to precipitate. Now, my lords have clarified it's only as against their appointments. My lords, can it be clarified that we can go ahead with the further action or should we hold it?
ಏನು ಮಾಡ್ಬೇಡಿ.
I'll hold it.
ಈಗ ಆಲ್ರೆಡಿ ಮಾಡಿದ ಸಾಕಷ್ಟು ಹೊಲ್ಸಿ.
ಇಲ್ಲ, ಇಲ್ಲ, then there,
ನೋಡೋಣ.
I will hold it. I just wanted, please.
The KPSC shall keep its hands away from all other proceedings.
Please,
Okay.
great, great.
Then both the KPC and the state and because
The state and KPSC shall keep off their hands. Till next date of.
Please, please,
Okay.
great.
His background has come out now from KPS.
ಆಮೇಲೆ ಅಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡಿದವರಿಗೂ ಗೊತ್ತಾಗಬೇಕು. ಬರೀ ಅಲ್ಲೇ ಆಗ್ಬಿಟ್ರೆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಉಳಿಯಕ್ ಸಾಧ್ಯ ಇಲ್ಲ ಅನ್ಕೊಂಡು ಗೊತ್ತಾಗಬೇಕು. ಅದು ಬೇಕಾಗಿದೆ.
ಇನ್ನೊಂದು
In that what
ಅವಾಗ
is,
at least ರೇಟ್ಸ್ ಆರು ಕಮ್ ಡೌನ್ ಆಗ್ತದೆ. ಹೌದು ಕರೆಕ್ಟ್. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಇಲ್ಲಿ ಆಗ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಯ್ತು ಅನ್ನೋ ಮನ್ಸು ಬಂದ್ಬಿಡ್ತು ಅಂದ್ರೆ ಮುಂದೆ ಕೋರ್ಟಿಗೆ ಹೋದ್ರೆ ಅಷ್ಟು ಹೋಗ್ಬಿಡ್ಬೋದು ಅನ್ನೋ ಭಯ ಇರ್ಬೇಕು.
ಯಾರು ಬರ್ಬೇಕು? ಖಂಡಿತ.
blood in this case, what is not there in the constitution, your lordships can removal constitution says. For appointment, the guidelines are not there. Your lordships can.
ನೋಡು. ಓಕೆ.
Great.
ಸಾಲು. ಬನ್ನಿ. ಹಾ. ಇವ್ರನ್ನ ಕರೀರಿ. ರಾಘವನ್. ರಾಘವನ್ ಅಂಡ್ ಬಸವರಾಜ್.
Blood, you understand what his lordship felt in the additional judgment. I was reading paragraph 225.
Paragraph 172 ಓದ್ತಾ ಇದ್ರಿ.
225 is the answer. But what happens is this.
225.
Reading judgment was written by the Chief Justice.
Correct.
The Chief Justice traced the origin of the group of companies to France.
You are right. 225 you were reading.
France, Paris and other.
Correct,
popular-
correct.
His lordship Narasimha says that he stressed the fact itself. Let us not go into
Sir, make use of.
the Honorable Chief Justice, my lord, he traces the origin to several other, my lord,
Correct.
the tribunals like in France and others.
Yes.
But his lordship Justice Narasimha traces to the act itself, just to be
Section
on the safer
7.
side.
7.
So 7 itself. The other origin, blood origin is at page 40. That is the Chief Justice's view.
Order.
Blood, his lordships refer to the Dow Chemicals of France and then
Correct.
Paris.
Lot of international jurisprudence has
International
entered this
jurisprudence.
judgment.
So therefore, my lord, his lordship wanted it to pin it.
That is
down to the-
development of law after chloro controls.
Yes, chloro control, my lord, that's an international arbitration. So
Correct.
therefore, there is some provision in the act itself. Therefore, there shouldn't be any problem. Then after the Chief Justice refers to my lord, France, Paris and all that, Justice Narasimha, my lord, page 225, paragraph 225, my lord, wants to pin it to the section itself so that there shall not be any, it becomes part of a substantive legal provision itself.
Provision itself.
Substantive legal provision itself, so that there will not be any confusion. But I'll only read paragraph 225.
Yes.
In this reference, we are tasked to determine whether the group of companies doctrine is in accordance with the statutory regime of the Arbitration and Conciliation Act 1996, defining an arbitration agreement and parties thereto. The adaptation of the doctrine has been doubted, and this is the reason for the reference. While dealing with the international perspective on the doctrine, of my opinion, it was noticed that the doctrine could not attain any conceptual singularity, and it remains contested. Perhaps this is for two reasons. First, the expression single economic reality employed in Dow is not in line with the concept of separate legal personality of a company. And second one, the doctrine is applied for determining the intention of the parties, which is completely fact-based. But Chief Justice also uses the word facts-based. It's a facts-based doctrine. For the reasons, the doctrine has remained dynamic, if not uncertain, is subject to many qualifications and expressions. At the same time, there are certain advantages of adopting the doctrine considering the modern business practices. I am of the opinion that it is necessary to entrench the doctrine within the statutory regime of the Act to enable a court or tribunal to apply it as a principle to decipher the intentions of the parties. I find it necessary to subsume the doctrine of group of companies within the judicial process under section 7(4)(b), where a tribunal or arbitration tribunal is called upon to determine the existence of arbitration tribunal and parties to it. Therefore, my lord, even the Honorable Chief Justice says it's a fact-based doctrine. Now, my lord, it is very clear that it is not, my lord, what happens is this. In case of a non-signatory being dragged to the arbitration proceedings because of the contract, for example, a partner or even a co-partner, that is an entirely different doctrine. Now, this doctrine is strictly applicable to group of companies. There cannot be a hybrid system of approach which the respondents are trying to do. They are bringing this, they are bringing the non-signatory being a part of the arbitration proceedings into a group of company doctrine. Now, this
doctrine
the
applies.
exact
Basura, this doctrine is invented or evolved only in respect of non-signatories, not for anybody else.
Yes, certainly. Group of companies also, it's a non-signatory. But here it's a bit narrow in the sense that conclusion of a contract, number one. Second one is performance of the contract or termination of the contract. When we see performance of the contract, we need not look into the dictionary meaning, or we have to look into the joint development agreement itself. What is the performance expected of the developer, and whether this person who stood as a guarantor
to do something with that.
Yes. Therefore, now I'll bring your lordship's kind attention.
Conclusion of these are all ಇವೆಲ್ಲವೂ ಇರಬೇಕು ಅಂತಿಲ್ಲ. Because word conclusion, performance or termination ಅಂತ ಉಪಯೋಗಿಸ್ತಾರಲ್ಲ word.
Performance is the main entire case revolves around performance. Conclusion may be, but performance is concerned, it is singularly absent, even as per the arbitration notice issued by them. But kindly see now with this legal background.
Do you fit into the concept of group of companies?
Group of companies, yes, because he is my holding company. He is my subsidiary, 100%. CVPL is my 100. Earlier it was called Landmaster. Then it became Mantri Castles. Now it has become CVPL. It is my there is no doubt about it.
No doubt.
Horizontally speaking, vertically speaking.
Basuraj Larnet, senior advocate appearing for the petitioner, in all fairness,
it's a fact.
Agrees that his client happens to be one of the entities of the group of companies.
No, it's a subsidiary of.
Therefore,
no, it's the other way. It is the other way.
Group of companies andre en artha?
Group of companies and I want to draw the attention. For example, what we are looking at from my perspective is vertical. That means there is a MDPL, Monthly Developer Private Limited. Under it, there is CVPL, Landmaster and all that. Suppose I give an example of horizontal. For example, one company is formed for the purpose of entering into an agreement to another. Another company is formed as a special purpose vehicle. Three more companies are formed. They come together with a joint understanding to perform the job. Some of the work is outsourced. For example, some of the machineries work is outsourced. That is a group of company horizontally. In vertical, that means MDPL holds.
Where is the treatment? What is meant by group of companies?
Group of companies.
Which paragraph? Which paragraph treats it?
Yes, ma'am. Again, I draw your lordship's attention to paragraph 106 only.
106, huh?
Yes. 106.
Basic idea.
Basic idea, my lord. In the beginning, that your lordship get at page 62. Page 62. Group of companies doctrine itself is discussed. Paragraph 60, paragraph 87, page 62. The respondents may draw your lordship's attention to paragraph 91, but I'll start with 87.
ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಇದೆ, you are right. The phenomenon of group of companies is the modern reality of economic life and business organization. Group companies are a set of separate firms linked together in formal or informal structures under the control of a parent company.
Then
The group
91
companies can be defined in the Indian context as an agglomeration of privately held and publicly traded firms operating in different lines of business, each of which is incorporated as a separate legal entity, but which are collectively under the entrepreneurial, financial, and strategic control of a common authority, typically a family, and are linked by trust-based relationship forged around a similar persona, ethnicity, or community.
But today, when we look at the contract, here in our days, the contract would be 25,000. Today, we are talking about 50,000 crores, 200 crores, and all 200,000 crores when it comes to metro or supply of aircraft or aircraft. But there has to be segregation and outsourcing of certain components or work. Now, kindly see page 90, para 91, Milord. This may be their argument. In case of group of companies,
Para 91.
para 91, Milord.
Ah.
In case, this is vertical analysis. In case of group of companies, there may arise situations where a holding company completely dominates the affairs of the subsidiary company to the extent of misusing its control to avoid or conceal liability. In such situations, the courts apply the doctrine of alter ego or piercing the corporate veil to disregard the corporate separateness between the two companies. Even there, Milord, there is separate.
Treat them as a single entity.
Single entity. A constitution bench of this court
LIC escorts
may
Justice
ignore
Kochina
whereas
Pareddi's judgment.
inextricably connected as to be in reality part of one concern. This is a case of lordships of Dr. Jekyll and Mr. Hyde. So two separate characters coming together as alter ego. Or Batman and Bruce Wayne, as my friend who is a movie buff, he can understand.
Yes.
So that is the 93. 93, my lord. 93. Moreover,
since the companies in a group
is in a group of have separate legal personality, the presence of common shareholders or directors cannot. This is their grievance. I'm 100% shareholder. Common shareholders or director cannot lead to the conclusion that a subsidiary company will be bound by the acts of the holding company. The statements of the representations made by the promoters or directors in their personal capacity. This is where they're saying that Sushil Mantri acted in their personal capacity would not bind a company. Similarly, the mere fact that the two companies have common shareholders or a common board of directors will not constitute a sufficient ground to conclude that they are single economic entity. The single economic entity or a single economic unit theory imposes general enterprise liability on the corporate group. In so-and-so, Lord Denning held that a group of three companies should be treated as a single economic entity on the basis of two factors. First, the parent company owned all the shares of the subsidiary companies to the extent that it controlled every movement of the given subsidiary companies. And second, all the three companies in the group virtually acted as partners and could not be treated separately. Thus, the determination of whether
he lost three lines very important.
Thus, the determination of whether two or more companies constitute a single economic entity depends on the concerted efforts of the companies to act in pursuance of a common endeavor or enterprise. And nobody could have put it in a better word than Lord Denning. And from the above discussion, we can infer that entities within a corporate group have separate legal personality which cannot be ignored, save in exceptional circumstances as fraud. The distinction between a parent company and its subsidiary is fundamental and cannot be easily abridged by taking recourse to economic convenience. Legally, the rights and liabilities of a parent company cannot be transferred to the subsidiary company and vice versa unless there is a strong legal basis for doing so. Now, strong legal basis for doing so is purely subjective.
Next ನೋಡಿ, adopting a pragmatic approach to
Yes, ma'am.
consent.
In the context of arbitration law, the intention of the parties has to be derived from the words used in the arbitration agreement. While construing the arbitration agreement, it is the duty of the court to not delve deep into the intricacies of the human mind, but only consider the expressed intentions of the parties. The words used in the contract reflect the commercial understanding between the parties. Intention of the parties has to be ascertained from the words used in the contract, considered in the light of the surrounding circumstances and the object of such contract. An arbitration agreement encapsulates the commercial understanding of businesses, entities as regards the mode of manner of settlement of disputes that may arise between them in respect of the legal relationship. Most situations, the language of the contract is only suggestive of the intention of the signatories to such contract and not non-signatories. However, there may be situations where a person or entity may not sign an arbitration agreement, yet give the appearance of being a veritable party to such arbitration agreement due to their legal relationship with the signatory parties and involvement in the performance of the underlying contract, especially in cases involving complex transactions involving multiple parties and contract. A non-signatory may be substantially involved in the negotiation or performance of the contractual obligations without formally consenting to be bound by the ensuing burdens, including arbitration. Modern commercial reality suggests that there often arise situations where a company which has gained contract containing arbitration is not always the one.
Understood.
Therefore, my lord, I will not agree that it's
just piercing the wheel ಇಲ್ಲ ಇದು. ಇಲ್ಲ.
That is why
piercing the wheel ಈಗ fraud of duplicity ಅಂತೆಲ್ಲ ಅಡ್ಡಿಲ್ಲ. ಬಟ್ ಇದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡುವಾಗ ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂಡ್ ಅಟೆಂಡಿಂಗ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ ಇದ್ರ ಮೇಲೆ ನಾವು ಡಿಸೈಡ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ನೌ ಲೆಟ್ ಅಸ್ ಕಮ್ ಟು ದಿ ಫ್ಯಾಕ್ಟ್ಸ್.
now
ನಿಮ್ ಕೇಸ್ ಏನು ಅಂದ್ರೆ
his lordship again reiterates that the group of companies doctrine is a fact-based doctrine.
Correct.
Purely subjective.
Correct.
Purely subjective.
Correct.
Now, I will take your lordships to list of the objections filed by the
ನಿಮ್ ಕೇಸ್ ಏನು?
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಅವೈಲಬಲ್ ಇನ್ ದೇರ್. ನಾವು
ನೀವು ಸಿಗ್ನೇಟರಿ ಅಲ್ಲ.
On 26/6/2010, my lord, the respondent, that the claimants basically ISKCON, who had held a substantial quantity of real estate, about 28 acres of land. Now, it was 2 bits of lands were segregated. In 2010, 26/6/2010, there was an agreement between ISKCON and MDPL, that is Monthly Developers Private Limited, to purchase item number 1 and
two properties, one property you wanted to buy.
Outright purchase by MDPL. Item number 2, we wanted to develop. That is, since I am the person who is sought to be implicated, I wanted to develop the item number 2. That your lordships get it. And I paid
Monthly Developers Private
Limited. And I paid 15 crore to ISKCON, claimant number 3. Then there was another agreement dated these dates may be relevant, 29/7/2010. 29/7/2010, there was a supplementary agreement between MDPL, that is the petitioner before your lordship, and claimant number 4 ISKCON. 4. And I paid additional amount of rupees 5 crores. So totally 20 crores were paid to ISKCON by the MDPL. Now, this is most important. Now, on 29th of September 2010, a second supplementary agreement was entered into. There was a paradigm shift in the arrangement in the sense that ISKCON was represented by a company called Gokulam Shelters Private Limited. That is the first respondent before your lordship. Basically, they appointed Gokulam Shelters Private Limited as a front to perform the contract to be entered into, then MDPL assigned the whatever arrangement it had to a company called Landmaster, your lordship need not remember, Landmasters Realtors Limited, which again became Mantri Castle. Now it became the respondent number 5 before your lordship.
Castles Vista
CVPL.
Private Limited.
Pardon me?
Castles Vista.
Yes.
Ah.
Now, all these, they are agreements to enter into an agreement. All these, they are prelude. The actual development agreement was entered on 29th of July 2010.
That is between
Sorry,
petitioner.
September, 29th September on the same day. Between,
29/9.
CVPL,
Between
CVPL, that is respondent number
5.
5, CVPL, and respondent number 1 to 4.
1 to 3.
2, 3, 4 are the consenting parties, but Gokulam was
Party.
their representative. Yes, Gokulam was their representative because that is clearly mentioned in the agreement. It clearly says that ISKCON hereby appoints Gokulam as their.
Where are you standing? Sit down. Yes.
Now there was a 1-to-1 agreement between CVPL and Gokulam with the consenting other 3 consenting parties. The joint development agreement was to develop the remaining extent. The first property I had already purchased. MDPL already purchased the property.
Yeah, the development is in respect of second property.
Second property.
Yes.
Now, Mantri is not a signatory to this joint development agreement.
No, signatory, yes, no issue. Now they are invoking the doctrine of a group of companies.
For this reason, subsequently, there were 3 loan transactions. 30th of April 2018, there was some sort of a escrow agreement. Then there was an agreement dated 2/6/2018. And this is most important. There was a the first day I mentioned to your lordship that the corporate guarantor is sought to be dragged. Now there was a corporate guarantor by MDPL, that is the petitioner before your lordship, in favor of the respondents dated 30th of September 2020. In favor of claimants number 1 and that is Gokul and other person.
You are a guarantor for what?
What happened is this. The CVPL borrowed the money from 2 entities. One is State Bank of India. That amount is already paid. There is another company called Pyramid Finances. The Pyramid Finance huge extent was borrowed. Then MDPL as a parent company, I can use the word parent company, stood as a guarantor that if CVPL fails to pay the amount, I'll pay the amount. To the
Respondents 1
and 2. Respondent 1 and 2. Because I must disclose this. This is not a built-up area surrender to the respondents under the joint development agreement. The arrangement is 70-30. It is not the built-up area that was supposed to be given to the respondent. It was the revenue sharing.
Okay.
This is where there is arguments on their
difference.
If CVPL does not pay, I will pay the amount provided my liability as a corporate guarantor arises only after the loan of SBI and CVPL is fully paid off. And this, interestingly, this corporate guarantee has a separate arbitration agreement. Till today, they have not invoked. The liability under the corporate guarantee agreement dated 30th of September 2020 by MDPL is not yet been triggered because they have not invoked the arbitration agreement under this clause. Now, the only grievance against by the respondents is against CVPL, as can be seen from the notice.
5.
Notice. Yes, kindly see the notice now. That your lordship get the notice issued by the respondents for the first time. This is the starting. They can amend the claim now based on the impleading application being allowed. But they can never amend the original cause of action, that is the arbitration agreement. The real grievance in the arbitration agreement is only against CVPL, only regarding performance of the contract, construction of the building, etc., for which MDPL can no way be involved. Kindly see the notice at page number 59, Annexure B. these are 59 annexure B is the agreement, the notice. Your lordship will get, see the relevant provision at page number 63. Clause 16. Yes. But kindly see to whom it was addressed to. Page 59 to Castle Vista Private
Fifth
Limited.
respondent.
Yes, fifth respondent. Our client, paragraph 16. Our client further instructs us that the following disputes or differences have arisen under the JDA and the fourth deed of amendment to the joint development agreement, which is sought for resolution and submitted to arbitration in terms of clause 30.2 of the JDA. Disputes regarding various breaches on your part in complying with your various obligations under the JDA and amendments executed thereunder, and therefore an award of termination for termination of the JDA and amendments executed thereunder. Disputes relating to recovery of our client's share from the total amount collected and to be collected by you.
This is guaranteed by you.
This
This amount is guaranteed by you.
No, as a guarantor for payment of this amount to CVPL, if CVPL.
We are asking simple.
Yes. To an
You are a
extent.
guarantor for this money.
But I'll come to that. Disputes relating to recovery of a client's share from the total amount collected and to be collected by you towards units sold or booked together with interest at the rate of 18% for delay in payment of the outstanding dues. But I will read the corporate guarantee to specifically point out whether B is included. At this stage, I will not either agree or disagree. Dispute relating to loss sustained by our client along with interest on account of selling the plot less than the agreed minimum sale price. But the allegation is that what was agreed is 1,000 rupees. You will get 300 rupees and I will get 700 rupees. What you have done is instead of 1,000 rupees, you have sold it for 2,200 rupees and pocketed the amount you paid only 300 rupees. This is the allegation. Downwards, revisions, abnormal discounts and other anomalies as noted in the PWC report and recovery of the same. Dispute regarding non-demarcation.
F may not be, E may not be.
None of them actually.
No, this B and C.
B and C.
Let us see your guarantee agreement.
Is corporate guarantee. Is your lordship get the corporate guarantee at page number 319 in the convenience volume.
19.
We can guarantee only after CVPL is settled obligations for the failed market. So there is no consultant which is aware of the CVPL is not. What is the problem?
313 of the convenience volume.
313.
This is the input. Our whole will only once we secure that CVPL fails into the secured obligation.
Unconditional and.
Yes, it is termed as unconditional irrevocable corporate guarantee.
Let us see this.
Kindly see guarantee. Now, kindly see, Millard, the preliminary discussion. A, CVPL has entered into JDA, dated so-and-so, and registered at so-and-so, which shall be collected soon, where under the development rights over the land admeasuring so-and-so, reduced by such extent relinquished towards roads and parks so-and-so.
CVPL is respondent 5.
Yes, Millard. Kanakpura so-and-so. CVPL has agreed to develop and construct residential complex under the name of Mantri so-and-so on the scheduled property on the terms and conditions contained in the joint development agreement. As consideration for granting exclusive development rights over the scheduled property, CVPL has agreed to share 30% of the sale proceeds as defined in the joint development agreement and ISKCON Charities and India Heritage so-and-so, 3% so-and-so, so-and-so, so-and-so. Then in order to secure and facilitate the performance of the following obligations of CVPL
under the joint development agreement, payment of sale proceeds.
Payment of the sale proceeds.
That is the guarantee.
What happens is, let me make it very clear. I am bound by this agreement. Tomorrow, if there is an arbitration award against me, arbitration agreement award against me as a guarantor, I am fully bound by that. This is entirely different from dragging myself into the arbitration proceedings and my lord, making me to undergo the entire trauma of being part of the arbitration. This agreement, I am bound by this. Suppose tomorrow if there is an arbitration award against CVPL and that is sought to be enforced against me, I cannot make any difference. That risk I am taking.
Or you will be bound by the award only to that extent.
To that
You
extent.
will defend in the
Therefore,
arbitration proceedings only to that
correct.
extent.
I cannot deny this agreement.
At all.
I cannot, and performance would be payment of the amount only. My lord, sale of the flats, sale of the common areas, handing over the certain flats, common areas, and construction quality.
All that is not.
All that I have absolutely nothing to do. That is why the word performance is referable to the joint development. I will be referring to what job CVPL has to do under the joint development agreement.
Yes.
If there is an award against me, and if this agreement is sought to be enforced by invoking the arbitration clause, I am bound by that. This is different from dragging me to
No,
the
you want one more arbitration to be drawn
not
against-
necessarily. What
Ah.
I'm submitting is,
If you say that whatever award they are going to get against CVPL, that you will abide by, we will dismiss the allow the petition and record their submission to that effect.
but this is again dependent. I'll come to that. This is dependent. Kindly see paragraph 2, my lord. This situation has not arisen. Of course, it may arise in future. Paragraph 2, my lord. In the event,
ಅಂದ್ರೆ ನೀವನ್ನೋದು ಬಸವರಾಜ್, ಇವರು ಒಂದು ಆರ್ಬಿಟ್ರೇಷನ್ ಇದೊಂದು 5 ವರ್ಷ ಆರ್ಬಿಟ್ರೇಷನ್ ಕೆಲಸ ನಡೆಸಬೇಕು, ಅದರಲ್ಲಿ ಅವಾರ್ಡ್ ಮಾಡಿಕೊಂಡು ಆಮೇಲೆ ಇದ್ರ ಕೆಳಗಡೆ ಇರುವಂತ ಆರ್ಬಿಟ್ರೇಷನ್ ಅನ್ನು ಇನ್ವೋಕ್ ಮಾಡಿ another 5 years.
maybe or may not be
ಮುಂದೆ
necessary.
no, the very object of act will be defeated without you. This issue, which is in respect of, maybe there may be several claims against several defendants, but so far as your liability that arises under the guarantee is covered in respect of notice claim A, B, and C.
The liability of MDPL under this corporate guarantee is defined.
Correct.
For example, if certain acts of CUPL are totally outside this agreement or culminated in fraudulent activities by CVPL, totally unconnected with the corporate business, corporate practice,
That contention.
then my lord, suppose if they want to enforce, then to the extent of me liable to CVPL, there can be an arbitration dispute, because CVPL, suppose if it crosses the Lakshman Rekha and indulges in fraud, it does not even inform me.
You are
Or
not bound by that.
to that extent, the arbitration
You
clause,
can
that's
take up
all.
the no,
If there is
that you can do in that proceeding only.
no. What they want to do is they want to fix the liability on MDPL in the arbitration agreement where thousands of crores are claimed and thousands of counterclaim is made
No,
by
say
CVPL.
your liability is confined to guarantee agreement.
Let them also make it clear. Let them also make it clear
Let us see
whether
what they will say.
if without be participating, I'll only draw, my friend wants. me
If
to draw-
you agree,
paragraph,
even without me being a party, if they get the award straightway, they can enforce that award in terms of this guarantee agreement. We will record that and we'll
subject
dispose of the matter.
subject to one condition mentioned in class 2 itself, 314. In the event, no, this is my liability subject to in the event CVPL defaults in fulfilling secured obligations in full or in part under the joint development agreement after the repayment of the debentures issued by CVPL and repayment of the loan or any enforcement of the rights by the
Always subject to this condition only.
this my liability arises after the
Only after
No,
the
the
your
present
liability
arrangement
is in a
is-
way
yes.
contingent.
present arrangement is, since there is a borrowing from the pyramid finance, the entire profit or whatever proceeds will first go to pyramid. Only thereafter there will be revenue sharing. Revenue sharing arises only after the full amount is paid to pyramid. Therefore, 314 class 2 cuts my the obligation to a limited extent. That number one, there should be entire payment of the loan to pyramid for any reason. Kindly see, of the enforcement of the rights over the project for any reason, whichever is earlier, the guarantor shall within 90 days from the day written demand being made by the beneficiaries, pay to the beneficiaries, that the beneficiaries are the respondents, no doubt, without demur, such sum as specified by the beneficiaries was to discharge any and satisfy the amounts due to the beneficiaries under the joint development agreement. Any such demand made by the beneficiaries on the guarantor shall be based on periodical certificate submitted by as per the joint development agreement, which would cover the dues and interest with penalty if any, and the value of unsold plots which are not handed over to beneficiaries in terms of joint development agreement. In the event CA does not provide the certification to beneficiaries, or CA is not appointed by CVPL under the joint development agreement for any reason, then the beneficiary shall be entitled to appoint a CA, and cost of such CA will be shared as per the provisions of the joint development agreement, and such CA shall determine the amounts due to the beneficiaries towards the secured obligations, and if CA does not certify, determine the amounts due to the beneficiaries towards the secured obligations. For the reason CVPL has not provided the required information, then the amounts due owing to CVPL device shall be determined by the beneficiary on the basis of the information available with the beneficiaries on the basis of the joint development agreement. If such CA certificate or amounts determined by the beneficiaries as per this clause shall be the final and conclusive evidence of CVPL default in performance of the contract. As on today, the default has not taken place, and the
continue much. Morning in Haki. Morning post further.
But in the meanwhile, I'll also find out whether the suggestion is would satisfy my requirement, and let them also make a statement whether the suggestion would, so that we can narrow it down.
Morning in Haki. We have meeting today. A group of companies doctrine no much different from piercing the wheel.
Yes.
All different ಇದೆ. Piercing the wheel ಅದ ಇರಂಗಿದ್ರೆ ಈ doctrine
Exactly. That is company specific, my lord.
Correct.
What happens?
Exactly.
Company specific. Each company specific. It need
Correct.
not be.
Correct.
ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಇದು SPV ಅಂತ.
My lord, in a lighter way, I made the arrangement of marriage between CVPL and I only as a marriage broker, and I suggested them, okay, you enjoy your life and pay the amount. Now in a matrimonial dispute, I'm sought to be added. Just go against. You will not sleep today. Yes.
Revision before examination. Thanks.
96. If you want.
Yeah, of course. No. Take me about that. Yes. No, today we'll sit down.
Sir, date given ಅಲ್ಲ?